Floor be open. The Honourable Opposition House Leader is rising on a point of order.
Thank you, Mr. Speaker. I have two very brief points to make regarding the use of language yesterday in the House following question period by the Prime Minister. First, I do want to add to the point of order regarding the statement by the Prime Minister when he referred to the member for Milton as an ambulance chaser, which is described in the Canadian Oxford as a derogatory term for a person who strives to profit from the misfortunes of others. Mr. Speaker, at page 619 of HoC and Gagnon, it says, reflections which question a member's integrity, honesty, or character are not in order. A member will be requested to withdraw offensive remarks, allegations, or accusations of impropriety towards another member. Mr. Speaker, the Prime Minister's statement of yesterday clearly breaches the rules of order and decorum, and I trust that you will request that he withdraw those offensive remarks as soon as possible. It would appear, Mr. Speaker, that the member for Milton was not the Prime Minister's only target yesterday. My second point will address the rules regarding reflections on the chair. At page 620 and 621 of HoC and Gagnon, it states, it is unacceptable to question the integrity and impartiality of a presiding officer, and if such comments are made, the Speaker may interrupt the member and request that the remarks be withdrawn or immediately give the floor to another member. Only by means of a substantive motion for which 48 hours written notice has been given may the actions of the chair be challenged, criticized, and debated. Reflections on the character or actions of the Speaker or other presiding officers have been ruled to be breach of privilege. As you know, Mr. Speaker, I raised a point of order regarding a question by my Deputy House Leader. In response to the Prime Minister's behaviour towards you, Mr. Speaker, the member for Grand Prairie Mackenzie asked the Prime Minister, are you in charge of the Speaker? The Prime Minister replied, and I quote, yes, I am, suggesting, Mr. Speaker, that you are not impartial. Now, Mr. Speaker, there are a number of individuals here, a number of members who witnessed that, who saw it. According to our practices, this is clearly unacceptable, and the Prime Minister is obligated to withdraw those remarks. If the Prime Minister refuses to withdraw those remarks, I reserve the right to return to the House with a question of privilege. I expect the Prime Minister to have a little bit more respect for this House, its members, and for you, Mr. Speaker. The Prime Minister must take responsibility for his actions and return to the House as soon as possible to withdraw the insult to the member for Milton and his slur against the integrity of you, the Speaker. This is not the first time the Prime Minister has shown such disrespect for this institution and those who serve it. I don't have time to necessarily read into the record his complete list, but you will recall when the Prime Minister once called the member for Thornhill a piece of shit. It was the word, Mr. Speaker. He then had to apologize. His contemptuous attitude was on display when he lost his temper as well on the floor of the House, ending in another member being injured, and again, he had to stand and apologize for that. So, Mr. Speaker, we would ask that the Prime Minister is insulting members, and again, he's doing this and bringing into question the impartiality of the Chair. It's an important matter, and I look forward to your ruling. Thank you very much.
I thank the Honourable Opposition House Leader for her adding her arguments on this subject. We'll be coming back to the House in relation to the first matter to begin with, and I should say that I did not hear the exchange that is spoken of. I'm going to go in a moment to the Honourable Member for Grand Prairie Mackenzie. I'm thinking he wants to add on the same point of order, and I'm allowed to do that. Obviously, I think we'll have to take this under consideration as well, and also review the record, including the audio, to see if we can find any indication of this. The Honourable Member for Grand Prairie Mackenzie on the same point of order.
Thank you, Mr. Speaker. Yesterday, the words out of the Prime Minister did call into question the independence of your office, and I will assure you, Mr. Speaker, that there are over a dozen members of the Conservative caucus who can testify to the exact words that the Prime Minister spoke. They are exactly as our House Leader has indicated, Mr. Speaker. We would be happy to meet with you, Mr. Speaker, and give testimony to the fact that the Prime Minister did utter those exact words. Mr. Speaker, this is a grave concern to our caucus. It should be a grave concern to every member of Parliament to understand that we have a Prime Minister who sits in the highest office in this country, indicating that he controls what must be, what absolutely must be, an independent office.
That's right.
Mr. Speaker, if in fact the words that were spoken by the Prime Minister are true, then every Canadian would have concern about the institution that we sit in. Mr. Speaker, it is your responsibility, and we leave it to you, to defend the integrity of your office. The Prime Minister has attacked that independence, has attacked that integrity, and suggested probably the most unbelievable thing that you could suggest about the Speaker and the role that you play. Mr. Speaker, we do believe that this is a grave concern. We would ask that you review all of what has been said and come back, and we will seek your guidance, but we will respond accordingly. Thank you, Mr. Speaker.
I thank the member for Grand Prairie Mackenzie. And I will review the arguments and review the recordings and come back to the House in due course. Member for Barrie Innisfil is rising on a point of order.
Same point of order, Mr. Speaker. As the member from Grand Prairie Mackenzie stated, I too heard there were probably, I would say, upwards of a dozen members of our caucus say exactly what the Prime Minister said, and I'll go one step further. When the member from Grand Prairie Mackenzie said to the Prime Minister, "Are you telling us that you control the Speaker?" the Prime Minister's response to that, I think if you check the record, you might hear it, "As a matter of fact, I do," were the words of the Prime Minister, Mr. Speaker. And I will be glad to meet with you, with other members of our caucus, to discuss this further. Thank you, Mr. Speaker.
Thank the member for Barrie Innisfil for adding his further comments to this matter. Tabling of documents. J'ai l'honneur de déposer sur le...
I have the honor of laying upon the table the annual report 2017-2018 regarding the Access to Information Act and the Privacy Act by the Office of the Information Commissioner of Canada. Pursuant to the relevant standing order, these reports are deemed referred to the Access to Information and Privacy and Ethics Committee.
To lay upon the table the annual reports on the Access to Information and the Privacy Acts of the Office of the Commissioner of Official Languages for the year 2017-2018. These reports are deemed to have been permanently referred to the Standing Committee on Access to Information, Privacy and Ethics. Dépôt de projet de loi émanant du gouvernement.
Introduction of government bills.
Question de ministre.
Statements by ministers. Reports from interparliamentary delegations. Presenting reports from committees.
For Battle River Crowfoot.
Thank you very much, Mr. Speaker. And I have the honor to present this morning in both official languages the 51st report of the Standing Committee on Public Accounts. And for those members here, you're correct. I said 51. Our committee is doing some work here. So 51st report of the Standing Committee on Public Accounts, entitled Report for Replacing Montreal's Champlain Bridge, Infrastructure Canada of the 2018 Spring Report of the Auditor General of Canada. Pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to this report. Thank you very much, Mr. Speaker.
The honourable member for Etobicoke Lakeshore.
Thank you, Mr. Speaker. I have the honour to present in both official languages the 10th report of the Standing Committee on Natural Resources, entitled Rethinking Canada's Energy Information System, Collaborative Models in a Data-Driven Economy. Pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to this report. Thank you, Mr. Speaker.
Introduction of private members' bills. Mr. Rankin, seconded by Ms. Brosseau, moves for leave to introduce a bill entitled An Act to Establish a Procedure for Expunging Certain Cannabis-Related Convictions. This motion is deemed adopted. The honourable member for Victoria.
Mr. Speaker, I'm very proud to introduce today a bill that will expunge the records of certain cannabis-related convictions. Over 500,000 Canadians have a criminal record for cannabis possession. That's 500,000 Canadians who may be barred from finding employment, from volunteering in their communities, from finding a place to rent, all for nonviolent action that will soon be perfectly legal. I also emphasize that not all Canadians have been treated equally under our cannabis laws. In Toronto, black people without a criminal record were 3 times more likely to be arrested for cannabis possession than white people. In Halifax, 5 times as likely. In Regina, it's 9 times more often for Indigenous people. This bill will allow people to wipe from their records all cannabis convictions for things that will be perfectly legal within 2 weeks. Under the current broken pardon system, Canadians have to wait several years and pay $631 just to apply. Under my bill, they won't have to wait several years, and it will be completely free. This bill is about righting past wrongs, and it will help hundreds of thousands of Canadians to get on with their lives. Thank you, Mr. Speaker.
Mr. Rankin, seconded by Ms. Boisseau, moves that the bill be now read a first time and be printed. This motion is deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House. Mr. O'Brien, seconded by Mr. Brassard, moves for leave to introduce a bill entitled An Act to Designate the Month of October as Hindu Heritage Month. This motion is deemed adopted. The honourable member for Calgary Forest Lawn.
Thank you, Mr. Speaker. First of all, Mr. Speaker, I would like to thank my colleague from Barrie Innisfil for seconding this bill. Mr. Speaker, I rise today to introduce my private member's bill to designate the month of October every year as the Hindu Heritage Month. The bill recognizes the important role played by Hindu Canadians in our country's multicultural social fabric and economic growth. Hindus across the world celebrate significant festivals such as Diwali, which I have hosted here on Parliament Hill since 1998. I was here in Ottawa, being the first Diwali to take place in the national legislature in the Western world. And Mr. Speaker, I invite you on the 30th to please come to the 18th Diwali celebration. By proclaiming the month of October as Hindu Heritage Month, the Government of Canada will recognize the contributions of Hindu Canadians as part of the success story that has made Canada the best country in the world. Thank you, Mr. Speaker.
Mr. O'Brien, seconded by Mr. Brassard, moves that the bill be now read a first time and be printed. This motion is deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House. Irrepressible people around here. First reading of Senate public bills. Motions. Presenting petitions. Presentation de pétition. The honourable member for Renfrew-Nipissing-Pembroke.
Mr. Speaker, I'm pleased to present a petition signed by Canadians from several ridings, including St. Catharines and Niagara Centre. They call on the House of Commons to respect the rights of law-abiding firearms owners and reject the Prime Minister's plan to waste taxpayers' money studying a ban on guns, which are already banned.
The honourable member for Elgin, Middlesex, London.
Speaker, I am pleased to present a petition signed by residents of Elgin, Middlesex, London, as well as residents from the riding of Avalon, regarding the government's proposed attestation regarding Canada Summer Jobs. The government and their views on the contravention of the Canadian Charter of Rights and Freedoms. The petitioners call on the Prime Minister to defend the rights of conscience, thought and belief, and withdraw the attestation requirements for applicants to the Canada Summer Jobs Program. Thank you very much, Mr. Speaker.
The honourable member for London Fanshawe.
I have 2 petitions today. The first is a petition in support of postal banking. Whereas nearly 2 million Canadians desperately need an alternative to payday lenders whose crippling and predatory rates affect the poor, marginalized, rural and Indigenous communities most. We have 3,800 Canada Post outlets already in rural areas where there are few or even no banks at all. Canada Post has the infrastructure to make a rapid transition to include postal banking, and so therefore petitioners call upon Government of Canada to enact my motion M166 to create a committee to study and propose a plan for postal banking under the Canada Post Corporation. And my second petition is in regard to the Thames River. Petitioners are concerned that the Conservative government stripped away environmental regulations covered in the Navigable Waters Act, leaving hundreds of rivers vulnerable. Rivers like the Thames, which is a heritage river, Mr. Speaker. The Liberal government has failed to keep the promise to reinstate environmental protections gutted from the original act, and therefore the petitioners ask the Government of Canada to support my bill HoC 355, which commits government to prioritizing the protection of the Thames River by amending the Navigable Protection Act. Thank you.
The Honourable Member for Repentigny. Mr. Speaker, I have the honour of tabling today e-petition number 1568, in which 1,312 citizens are requesting better working conditions for live-in caregivers. More specifically, signatories are asking the government to ratify Convention number 189 from the International Labour Organization on Domestic Workers and invites governments of provinces and territories to harmonize their respective legislation with recommendation number 201 of the International Labour Organization, which is related to that convention. To conclude, congratulations to the International Workers' Solidarity Centre and its member organizations who are the driving force behind this initiative. Thank you.
For Airdrie.
Thanks, Mr. Speaker. Canadian parents are often left to suffer alone after they experience the tragedy of pregnancy or infant loss, and worse, government programs are often causing them undue financial or emotional hardship. And that's why Motion 110 was put forward that asked the Human Resources Committee to study the issue of pregnancy and infant loss on parents, and that was passed unanimously with all party support in June. However, lost families expect more than symbolism. They expect action. And therefore, I table this petition signed by hundreds of Canadians calling on the government to immediately introduce legislation following the committee report to provide better compassion and more support for parents of pregnancy and infant loss. And if, Mr. Speaker, I can, while I have the floor, I have one other petition I'd like to table, and it's regarded with cannabis legislation coming into effect in less than 2 weeks. There are still many questions that are surrounding how marijuana use will affect driving and how it will impact the health of Canadians. And these are serious concerns that I've heard from constituents, and unfortunately we're not any closer to getting answers. And so I table this petition today, calling on the government to address these and other concerns that Canadians have.
I remind honourable members that presenting petitions is not the time to engage in their arguments about a matter, but to tell us what petitioners say. I think members can manage to frame their comments about presenting a petition in a way that focuses on what the petitioners are asking and saying. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. It's with pleasure I table a petition today that's been literally signed by hundreds of residents of Winnipeg North. And what they're asking for is for the Prime Minister and members of Parliament to reflect on how important it is that we have a national pharmacare program. They want us to, as a national government, to work with provinces and different stakeholders to see if, in fact, we can put in place a single system that would allow for a national pharmacare for prescribed medicines. Thank you, Mr. Speaker.
The member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I'm honoured to rise today to present two petitions. The first petition calls for this Parliament to consider very closely the continuing problem of violence against women, particularly that violence against women disproportionately impacts Indigenous women. The second petition, Mr. Speaker, is from youth in Canada, and as the petitioners frame it, those who care about youth. It calls our attention to the increasing urgency of action on the climate crisis, that unless action is taken very soon in the interests of these youth, the window on achieving 1.5 degrees average global temperature increase and staying well below 2 degrees will close, and close permanently, without swift action. Thank you, Mr. Speaker.
Presenting petitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Mr. Speaker, I would ask that all questions be allowed to stand at this time, please.
Is it agreed? Agreed and so ordered. The Honourable Member,
The Honourable Member for Rivière-des-Mines on a point of order. Thank you very much, Mr. Speaker. I'm rising today to respond to the point of privilege raised on October 2nd, 2018 by the Honourable Member for Montcalm with respect to a supposed contempt of Parliament on supply management. My honourable colleague suggested in his statement that the United States-Mexico-Canada agreement was in contempt of Parliament. The Bloc member's argument was based on 2 points. The first is the fact that 3.59% of the dairy market and Canadian dairy products has been opened up to American producers under the agreement. The second is that on September 26, 2017, this House unanimously passed a motion stating that the House reiterate its desire to fully preserve supply management during the NAFTA renegotiations. renegotiations rather. Thus, my honourable colleague feels that the USMCA is in contempt of Parliament. Mr. Speaker, with your permission, I would like to speak to how that issue is not a question of privilege, but rather a question of debate. Mr. Speaker, it is clear on pages 536 and 537 of the third edition of Procedure and Practice of this House that a resolution of the House is a declaration of opinion or purpose. It does not require that any action be taken, nor is it binding. Therefore, I believe that it is impossible to consider the provisions of the agreement as being in contempt of Parliament, and therefore I respectfully submit that this is a question of debate and not a question of privilege. Thank you, Mr. Speaker. I'd like to thank the honourable member of Rivière-des-Mille-Villes for her comments on the question of privilege, and I will come back to the House with a ruling. Orders of the day. Government orders, government bills.
Bill C-78, an act to amend the Divorce Act and other related acts.
Debate. There are 10 minutes remain. No, I'm sorry. We're going to debate now, or are we going to? We're on debate. Thank you very much. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you very much, Mr. Speaker. I'll be splitting my time with the member for St. John's East. Mr. Speaker, I'm pleased to rise today as the Parliamentary Secretary to the Minister of Justice to speak to an important aspect of Bill C-78, poverty reduction. Over 2 million Canadian children live in separated or divorced families, Mr. Speaker. Of these, lone parent families are the most financially vulnerable of all family types and are more likely to depend upon social assistance. A couple of other important statistics, Mr. Speaker. There is right now well over $1 billion in arrears in support payments in this country. And in the vast majority of such cases, Mr. Speaker, 96% of all such cases, the arrears relate to money owed by men to women. The data on the economic challenges of single parenthood are quite stark. In 2016, the median net worth of Canadian couples with children under 18 was over $300,000, while the median net worth of single-parent families was less than 1/6 of that, $57,200. Separation and divorce can cause a financial crisis for some families. The benefits of sharing family expenses often disappear as a second home must be established. Some parents need to significantly change their work hours to accommodate their changed parenting schedule, which can affect their income and their employment opportunities. This is what I hear when I speak to families in my riding of Parkdale High Park. I hear far too often from single mothers who are struggling to access spousal and child support after a marital breakdown. Bill C-78 will directly benefit these residents of my community and the residents of so many other communities in a similar situation right across Canada. It will help lift those individuals, whether they are mothers or children, out of poverty. It will mean less time fighting out support payments in court, which is costly and time-consuming and creates court backlog. It will mean more tools to allow single parents to identify and locate the assets of their former spouses, and more tools to enforce the actual payment of spousal and child support to single parents and their children. Allow me to explain, Mr. Speaker. I want to turn first to the payment of child support, reducing the risk of poverty. The sooner a fair and accurate amount of child support is established after parents separate and payments are made, the better the outcomes are for the child in question. The payment of child support is a key factor in reducing the risk of child poverty, especially for low-income, single-parent families. Les parents ont l'obligation légale.
Parents have a legal obligation to provide financial support to their children after a separation or divorce. Children have a legal right to that support. Provincial and territorial legislation with respect to child support makes it obligatory for parents to disclose information about their income, including their returns. If not, there are penalties for parents who do not disclose that information. The income of parents is estimated, therefore, then at a specific amount for the purposes of child support. Most parents do comply with their legal obligations. However, despite the sanctions and penalties, many parents do not provide accurate information on their income. This has serious consequences for children and families who end up in the family justice system. Family lawyers and judges often say that disclosure of income is one of the most important issues in the family justice system, and this has an effect on the legal system. Oftentimes, parents cannot reach an agreement in family courts. If there is no accurate estimation of income, that can also prevent families from having access to other services. For example, recalculation of child supports or assistance in those calculations.
The non-disclosure of income. The financial and emotional costs to the parent seeking income disclosure are significant. They are legally entitled to financial information from the other parent, but when financial disclosure is not made, they must ask a court to order that the information be provided. This creates significant costs for families and can lead to overburdening the family justice system, including the courts. And the other parent may still not disclose their income information even after the court has ordered it. In these situations, the court may then impute the income of the other parent. Mr. Speaker, although imputing income may work adequately in some situations, it is very difficult for the court to determine a fair amount of support that reflects a parent's true ability to pay in the absence of a complete and up-to-date income information. Imputing income may result in child support amounts that are too high, which in many situations will not be paid, or in support payments that are too low, which will prevent the children from benefiting from the support of both parents. Consistent with our government's commitment to poverty reduction and to meeting the needs of low and middle income families, Bill C-78 will bring much needed changes to middle class Canadians. It will limit the negative consequences of income-related disputes on the family justice system and parents. Bill C-78 also proposes much needed changes to help to reduce child poverty. I want to turn to one aspect of the laws that are being amended here, the Family Orders and Agreements Enforcement Assistance Act. Amendments to this Act will ensure that a separating or divorcing parent's failure to meet their income disclosure obligations does not prevent the establishment of a fair and accurate amount of support. We will amend this particular law to allow the federal government to release an individual's income information, including information from tax returns, to a court for the purpose of establishing, varying, or enforcing a support provision. The income information to be released will be listed in the regulations, and important safeguards will be included in the Act. An application for information under this legislation will not be permitted if the court is of the view that a release of information will jeopardize the safety and security of any person. Where information is released to a court, it must be sealed and kept in a place to which the public has no access. The release of this income information will help ensure that child support amounts reflect the parent's true capacity to pay. It will also reduce legal costs associated with ensuring income disclosure for a parent, as well as the associated use of court resources. Child support orders will be made more quickly, Mr. Speaker, more accurately, with less conflict and less expense, helping the very women I mentioned at the outset, Mr. Speaker, the 96% of recipients of spousal and child support in Canada who are women.
Mr. Speaker, changes to the Act will also provide for the disclosure of financial information for the purposes of recalculating child support for children. Recent information on the income of a parent are necessary in order to be able to recalculate. These are administrative services in the province and territories, and it's very important for access to justice for those parents who are paying or receiving support. Those services provide for the updating of child support amounts for the child through a more efficient and expedited process. Recalculation services are in the orders for the child, and they are based on parental income. However, that recalculation cannot be done when the income is imputed or when the information has not been disclosed. Parents have to call on the courts to have child support changes made oftentimes. Changes to the legislation will reduce costs, therefore, for the parents and for the justice system, and it will allow administrative services to do these calculations and to obtain the information they need. Agreements with the provinces and territories on the communication of information will be improved, and information about income will be kept confidential.
To the garnishment provisions, Mr. Speaker, this Act provides for the payment of salaries and pension benefits payable to current and former federal employees to another person to help satisfy family support. Amendments to the garnishment legislation will help reduce child poverty by making the process more efficient so that families receive the support to which they're entitled in a timely manner. For example, the amendments will prioritize garnishment for family support debts over all other debts other than debts to the Crown, which allow for earlier garnishment where possible. Mr. Speaker, in conclusion, separation and divorce can be difficult, emotionally and financially, for families and children. That most Canadians dutifully meet their obligations when it comes to both the establishment and payment of child support is a testament to our society's values. However, when parties cannot agree on what their obligations should be, our family justice system should be there to help resolve those issues. And federal enforcement legislation is there to help when parties do not meet their support obligations. That is exactly what Bill C-78 will do, Mr. Speaker. I'm proud to support it, and I urge all members of this House to do the same. Merci beaucoup.
Thank you very much.
Questions and comments? Questions and commentaires? The Honourable Member for Dufferin-Caledon.
Yes, Mr. Speaker. The Parliamentary Secretary has raised an excellent issue, and that is one of disclosure in divorce or separation proceedings. And the problem, one of the most serious problems, is finding out information from people who are self-employed, when many of those people don't disclose to Revenue Canada what they're actually making. This happens all the time. So the question is, and I appreciate the government's trying to deal with that because it's the most serious issue, is obtaining disclosure. But with that specific example, and there are many people who are self-employed, and there's no, just providing the income tax return doesn't reveal what their actual income is.
Parliamentary Secretary to the Minister of Justice.
I thank the member from Dufferin-Caledon for his question and also for his intervention last week on this very bill. And he raises a very important point. What we're doing with Bill C-78 is providing more tools in the toolbox that will allow better access to and disclosure of financial information. Clearly, there are instances, and there will remain instances, where people nevertheless seek to evade such disclosure, and that could arise in many different instances. But with this legislation, what we are doing is responding to the concerns we have heard from Canadians from coast to coast to coast, that they need better tools, better ability of information sharing between different components and departments in government to access that information. And then it is for the courts, through the provisions that are already provided for in the law, to ensure the enforceability, including imputing income where necessary for those that still withhold information.
Questions and comments? The Honourable Member for Vancouver East.
Thank you very much, Mr. Speaker, and I thank the member for his comments. I'm just wondering, with respect to the enforceability of this bill, which follows up, I think the question was just asked moments ago, would it be then up to the provinces through the court system that will enforce this bill and to enforce the support that's provided to the children that are in need?
The Honourable Parliamentary Secretary.
So family law is obviously a matter of dual jurisdiction. So I thank the member from Vancouver East for her comments and her question. The issue of family law is a matter of shared jurisdiction between the provinces and the federal government. Issues of divorce and marriage are obviously a matter of federal jurisdiction. Issue of separation that do not include divorce, for example, are a matter of provincial jurisdiction. We've worked diligently through our FPT colleagues and at various meetings that the minister has had to work collaboratively with provinces and territories on this bill. A component of the enforceability will continue to reside with the courts that are administered in the provinces and territories, as is divided under our constitutional jurisdiction provisions. So it will be a collaborative effort. But what is important to emphasize with this bill, Mr. Speaker, is that under Bill C-78, we're giving more tools and strengthening the enforcement that is available to the very provincial actors that my friend has mentioned, to the courts that are the front lines of the important work that is being done on the family law front, and importantly, not necessarily forcing people to get involved in the courts at the first instance, and reducing the costs, the court backlog, and the necessity of seeking enforcement by creating more tools outside of the court structure that people can access to pursue their rights under this regime. Merci.
Question, commentaire? La députée.
The Honourable Member for Laval-Les-Îles.
And I thank my colleague for his excellent speech, and I would like him, if it's possible, to elaborate on how this government, with this bill and the previous efforts made by this government, will enhance and improve the life of our Canadian children, and particularly also in lifting hundreds of thousands of them out of poverty and ensuring them for better life, better future. And thank you very much.
The Honourable Parliamentary Secretary to the Minister of Justice.
My colleague from Laval-des-Îles for pointing out this point. This is a fundamental theme of not just this bill, but our government. In terms of what we've done with the Canada Child Benefit, lifting 300,000 children out of poverty by having targeted benefits that are tax-free, dedicated to those who need them the most. This bill complements that. It is a staggering figure, Mr. Speaker, that 2 million children in this country live in families that have experienced a divorce. It is equally staggering that over $1 billion in this country is in arrears in terms of spousal support and child support. What we're doing through this legislation is responding to that very real need, ensuring that there are more tools in the toolbox that will allow the actual disclosure of information, the actual arrangement of child support orders, and the enforceability of such child support orders, so that those children currently living in poverty have the ability to receive the support they so desperately deserve. Those are middle-class kids that we're here to support. Thank you, Mr. Speaker.
Resuming debate, the Honourable Member for St. John's East.
Thank you very much, Mr. Speaker. It's a pleasure to rise today on Bill C-78 and the significant contribution that it will make to improve the accessibility and efficiency of the family justice system. As mentioned, federal family laws have not been substantially updated in over 20 years, and changes are long overdue. Access to justice is a priority for our government, and access to family justice is a key component of achieving this. Costs, delays, and complex procedures can make it difficult for Canadians to have access to justice, and in the family law context, along with the expansion of the Unified Family Courts and sustained funding for family justice services, Bill C-78 is part of our government's commitment to improving access to justice for families going through separation and divorce. Under the pen of the retired Supreme Court Justice Cromwell, the Action Committee on Access to Justice in Civil and Family Matters stated that early management of legal issues and encouraging informal dispute resolution are key to improving access to justice. Bill C-78 recognizes the need to improve access to justice and offers guidance, information, and tools to help families going through separation and divorce, including people who represent themselves as well as lawyers and courts involved in the family law issues. Bill C-78 encourages the use of family dispute resolution processes, and these are defined as out-of-court processes used by parties to help them resolve their family law disputes. Negotiation, mediation, and collaborative law are examples of such processes. These are often less expensive and faster than litigation, and they allow parents to actively participate in creating arrangements that are in the child's best interest. Part of the role lawyers play is to ensure that parents who have family law issues have the relevant information on family dispute resolution. Bill C-78 creates a duty for lawyers to tell parents about family justice services that could help them resolve their disputes and to encourage them to try family dispute resolution where appropriate. In addition, if a case is before the court, the bill gives judges the option to refer parents to family dispute resolution where available. Bill C-78 also introduces duties for parents involved in a family law matter to try to resolve their issues through a family dispute resolution process where it is appropriate. That being said, family dispute resolution processes may not be appropriate in all circumstances, including where there is family violence. And for this reason, Bill C-78 only encourages the use of these procedures where appropriate. Courts and lawyers must evaluate each of these situations on a case-by-case basis and take into account family circumstances, including whether there's family violence, before encouraging the use of family dispute resolution. In addition, other service providers such as certified mediators play a critical role in screening for family violence and power imbalances in order to promote a fair and equitable process. There are numerous ways that Bill C-78 facilitates resolution of family disputes and helps parents reach out-of-court agreements focused on the best interests of their children. For example, it proposes changes to custody and access language, the definitions in the old version of the Act, to use terminology that is more neutral and child focus and that reflects the actual tasks of parenting, such as parenting time and other terms used in the Act. It also includes a non-exhaustive list of criteria to help determine what is in the child's best interest, as well as criteria to assist parents dealing with relocation issues. This additional information will help parents make informed and child-focused decisions and better understand what the outcome might be if they were to go to court. This, in turn, is intended to help reduce litigation. Our government is bringing forward some innovative thinking to help improve the family justice system, and there are issues currently determined by courts that are administrative in nature and that can be handled outside the court. Bill C-78 will expand the range of matters that child support services may address and will allow them to perform tasks currently that were the sole purview of the court itself. Many provinces and territories have child support services that recalculate support orders, for instance, and Bill C-78 proposes several measures to make these services more efficient. This includes the recalculation of interim child support amounts in Divorce Act orders. In addition, the bill will allow child support services to recalculate child support amounts at the request of a parent, for example, if there is a job loss. Currently, the Divorce Act requires that recalculation be done only at fixed or regular dates. The bill also includes a new approach allowing for the calculation of initial child support amounts by provincial or territorial support services where possible. This will allow administrative services, as opposed to courts, to calculate based on relevant income information child support amounts based on child support guidelines. These proposed additions and improvements to the Divorce Act will make it easier, less costly, and less adversarial to determine or recalculate child support amounts. Changing Divorce Act orders when parties live in different jurisdictions can also be costly and cumbersome for families. Bill C-78 proposes to improve the process to change a support order for parties living in different provinces or territories. Currently, 2 courts are involved, a court in the applicant's province that makes a provisional order and a court in the respondent's jurisdiction that confirms the order. The new process would involve only 1 court and would eliminate the need for the current first stage hearing, saving time and money. Because this new system mirrors that in most provinces and territories, it would also ensure consistency whether interjurisdictional proceedings are conducted under the provincial legislation or under the Divorce Act. The bill also includes provisions to improve processes in international child support cases. These changes are an essential step for Canada to become party to the 2007 Convention on the International Recovery of Child Support and Other Forms of Family Maintenance, which was signed in May 2017. The 2007 Convention is an international agreement that provides a low-cost and official legal framework for cross-border establishment, modification, recognition, and enforcement of family support obligations. It will be of particular interest to Canadian families and children as a means for a parent to obtain child support from another former spouse living in a different country. Another way in which Bill C-78 will increase access to justice and improve the efficiency of family law justice system is by amending the Family Orders and Agreements Enforcement Assistance Act. This act is used to help parents enforce support. The bill proposes to amend it to permit, in certain limited circumstances, the release of income information when parents do not provide it. Accurate income information is key to determining fair child support amounts. This change would help accurately determine child support amounts and enforce support orders, as well as to reduce time spent in court to attain this information. Proceedings to obtain this information currently take up a lot of court time and resources. And this can be expensive for people who are trying to obtain support and is not a good use of family resources. When this information is given to a court, it would be sealed and kept in a location to which the public has no access, and the court could make any order necessary to protect the confidentiality of the information. While the bill encourages resolution of matters outside of the court system, there are some matters that require formal court resolution. Budget 2018 announced funding to expand unified family courts, fulfilling one of the Ministers of Justice's mandate letter commitments to Canadians. I know the family court in my riding of St. John's East has benefited from this. Unified Family Court provide one-stop shopping for the family justice system by combining jurisdiction over all family law matters into one court. They also provide access to a range of family justice services, such as family law information centers, mediation services to help families through a range of family law issues, including separation and divorce, and other services. Mr. Speaker, funding is essential for the delivery of family justice services, which you know, and that you know that they fall within the provincial and territorial jurisdiction. In Budget 2017, our government committed $16 million per year for family justice services on an ongoing basis. This funding will increase Canadians' access to family justice by supporting provincial and territorial programs and services such as mediation, parent information, education, and support enforcement. I would like to conclude by saying that we have to work together to improve the accessibility and the efficiency of the Canadian family justice system, and Bill C-78, along with the expansion of the Unified Family Courts and sustained funding for family justice services, will help support Canadian families going through separation and divorce and the over 2 million Canadian children who live in separated or divorced families. This is a great step forward, and I trust that the changes we have proposed will bring positive changes to the family justice system, and I encourage all members of the House to support this legislation, and I do, so we can see it move to committee where it can be studied further. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Dufferin-Caledon.
Thank you, Mr. Speaker. I'd like to congratulate the member from St. John's East for his presentation to the House on this topic, particularly zeroing in on the topic of dispute resolution. And as a legal representative, my question is one of the problems the lawyers? The litigation, of course, is very adversarial. It's very adversarial in family law matters. Dispute resolution already exists. And currently, a lawyer acting for one of the parties, or indeed both lawyers, could say, no, we're not interested in dispute resolution. This matter should go to the courts, and which causes a problem because, generally speaking, one of the parties doesn't have the resources to go all the way to the courts. They do have the resources to go to a dispute resolution, but not to the courts, and that creates unfairness and indeed more adversarial attitudes. So my question is, does the proposed legislation correct this discrepancy? Is there something that forces the lawyers who are acting, the legal representatives, to encourage dispute resolution?
Honourable member for St. John's East.
Yes, and I'd like to thank my honourable colleague sitting next to me, as we do in this corner of the House, for his question. First, I would like to say that some of what the member referred to might fall under the frame of sharp practice, and I don't think that that would be the case in the vast majority of members of the family bar that I know, who always try to encourage their clients to obtain the appropriate level of service and support, and to try to reach the resolutions that are in the best interest of the child, which is very much the case of what this legislation is trying to do. With respect to the issue of going through the less acrimonious and often more deliberate and successful route of dispute resolution, the Act does contain requirements on legal counsel to instruct their clients to do so where appropriate. And I provide the caveat of where appropriate because in this particular bill, there is a new definition for family violence. This is a fairly comprehensive definition. It includes things like psychological harm and other types of manipulation that parents may engage in or former spouses may engage in with one another, and in such instances, staying within the court system may be in the best interest of all involved, but otherwise, lawyers are instructed to provide a dispute resolution process to the parents, which will better conserve family resources, which is also, of course, in the best interest of the child. Thank you, Mr. Speaker.
Questions and comments? The honourable member for North Island, Powell River.
Thank you, Mr. Speaker, and I thank the member for his speech. And I would like to take a moment to just appreciate the fact that today is my son's 20th birthday. Happy birthday, Henry. One of the hardest parts for all people in this House and so many across Canada that have to work away from home is not being with their loved ones on these important dates. So just wanted to take that opportunity. Back to the question at hand, one of the challenges in addressing child poverty in the context of this bill is really when domestic violence is part of the equation. Often it's a safety issue for the family, largely for the children and the wife. This often results in either not receiving or not paying on one side or the other of child support. So consultation is key. I think it's really important that we look at how we're going to make sure that this can happen in the safest way possible. I would just like the member to talk a little bit about where he may identify some gaps in this current bill. Thank you.
The honourable member for St. John's East.
Thank you very much, Mr. Speaker. I thank the member for her question. It's an important one. And I also say happy birthday to her son. It was my son's 10th birthday yesterday. Wow. And although I had a chance to speak with him on the phone a couple of times, I really did miss the chance to see him go into double digits. It was a tough one to miss. Yes, the Act does attempt and to address many of the concerns raised by the member. I don't see any particular gaps because I think in a way that this particular legislation builds upon 20 years of work that the provinces have done themselves to start to address some of these issues, and the courts have started to address some of these issues before we finally have come to the point where we're actually implementing it into federal legislation. I do have a copy of the definition open in front of me now, and I'm going to highlight the fact that family violence includes all types of conduct, whether or not the conduct is criminal in nature, that constitutes a pattern of coercive and controlling behavior. It includes physical abuse, sexual abuse, threats to kill or cause bodily harm, harassment, failure to provide the necessities of life, psychological abuse, financial abuse, threats to kill or harm an animal or damage property, and the killing or harming of an animal. So if we look at the financial abuse problem you raise in the context is actually embedded right there in the definition of family violence. And so I'm hoping that your concerns are addressed. But of course, as I suggested in my remarks, I look forward to the bill going to committee where it can be addressed and more of these gaps might be able to be elucidated upon. Thank you.
Resuming debate, the honourable member for St. Albert, Edmonton.
Thank you very much, Mr. Speaker. I'm pleased to rise to speak on Bill C-78, the government's family law bill. Now, as other honourable members have alluded to in this debate, issues relating to family law, by and large, fall within the parameters of provincial jurisdiction. However, Section 91, Sub 26 of the Constitution Act provides that it is within the jurisdiction of Parliament to make laws with respect to marriage and divorce. In order to discuss Bill C-78, what it seeks to do in terms of updating family law and divorce legislation in this country, I think at the outset it would be helpful to provide some context to how divorce law in this country has evolved. Indeed, Mr. Speaker, the Divorce Act is a relatively new piece of legislation. It was passed in 1968, only 50 years ago. Prior to the passage of the Divorce Act of 1968, we had in this country a patchwork of laws with respect to divorce. In some provinces, there were no divorce laws, and as a result, it was necessary for couples to seek a private activist parliament in order to be able to obtain a divorce. In other provinces, divorce was possible if it could be established that there had been some wrongdoing in the relationship. Mr. Speaker, fast forward to 1968 when Parliament did pass legislation to provide uniform laws with respect to divorce. And the Divorce Act of 1968 remained in place until it was updated in 1985. Which is when Parliament made some very significant reforms to divorce and family law. Among the changes made in the 1985 Divorce Act was to provide a single ground upon which divorce could be obtained, namely when there was a breakdown in the relationship. Now, a breakdown in the relationship could be established based upon a number of different criteria, including 1 year of separation amongst the couple, or if it were established that there was adultery in the relationship or physical or mental abuse. Now, since Parliament took steps in 1985 to update divorce law in Canada, over the last 30-plus years, there has been very little changes that have been made to update family law in this country. And I've got to tell you, I was born in 1984, 1 year before the Divorce Act was updated. So it's 1984 or 1985 was a long, long time ago. And Canadian society has evolved considerably in these last 33 or 34 years, including the structure of families, unfortunately, the increased prevalence of divorces and marital breakdown. And so it is about time that Parliament is moving forward to consider a comprehensive update to the Divorce Act. Now, Mr. Speaker, in terms of the substance of this bill, let me say that we're open to looking at it carefully. On the surface, it would seem that this bill contains a number of positive measures. Among the key substantive aspects of this bill includes updating terminology, encouraging families to settle disputes outside of the court, improving child support enforcement, and preserving the well-being of impacted children. Mr. Speaker, all of these measures on the surface appear to be a step in the right direction. In terms of the road to reform, it has been, as I mentioned, a long time coming. And we saw a very thorough review undertaken by Justice Cromwell back in 2013. One of the key recommendations from the Cromwell Committee was the need to update terminology. Right now, under the Divorce Act, the terminology is quite adversarial. And that is not helpful, Mr. Speaker, as families deal with what is often the most difficult times and most challenging times that couples can face when they are in a situation where there is marital breakdown. And so, Mr. Speaker, among the changes that Bill C-78 would make would be to change the language, to make it less adversarial in accordance with the recommendations of the Cromwell Committee. So, in what ways would the bill make the language in the Divorce Act less adversarial? Well, for example, it would replace the term custody with contact and access with parenting, Mr. Speaker. Another aspect of the bill is that it is going to encourage parties to try to settle disputes through mediation or alternative dispute resolution. Far too much money is spent in our courts, and to the degree that families can settle their marital matters outside of court, outside of what is, by definition, an adversarial system, is a step in the right direction. And of course, Mr. Speaker, as I alluded to, it will codify what is, at this time, a wide body of case law to make and have regard for the best interests of the child. Mr. Speaker, I know in talking to an acquaintance of mine who was a judge, he said to me that Upon being appointed, one of the challenges, of course, was to get up to speed on different aspects of the law that he had never practiced. For example, he had never practiced criminal law before, and so there was certainly a lot of time that he had to spend to get up to speed. But he said, aside from the academic side, aside from getting up to speed with different aspects of the law, what he found to be the most difficult was trying to settle disputes when children were involved in terms of making orders respecting parenting, for example, because so often he's there making a decision that is profoundly going to affect the parents, profoundly affect the family, profoundly impact the child. And so, Mr. Speaker, I just make that anecdote to underlie the gravity and the importance and the impact that these changes will have. And so we will, as I say, look at the bill, study it at committee. I guess we will trust, but we will verify at committee and look forward to hearing from a wide array of witnesses and, of course, explore possible amendments. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member opposite for his speech, and I noted that he acknowledged some of the very strong provisions in the legislation with respect to putting children first and enforcing child support payments. I want to ask him about the bill's impact on women, and the context of my question is a couple of statistics. We know that 96% of all those people who are in what are called registered maintenance enforcement agreements involve payments of men to women. We also know that 60% of all of those that are registered in these maintenance enforcement provisions are in default, and the default is in excess of $1 billion. So while this bill will impact on children in a positive way, I wanted to hear the members' comments on how it will impact on women, because we very much feel that this is at the heart of a feminist approach towards government and putting women, including middle-class women, first. Thank you.
Well, member for St. Albert, Edmonton.
Thank you, Mr. Speaker. Let me first of all thank the Parliamentary Secretary to the Minister of Justice for his question and also congratulate him on his appointment as Parliamentary Secretary. I've had an opportunity to get to know the Honourable Parliamentary Secretary over the last 3 years, and I know his background as a lawyer, that he'll be well suited to his new role, and look forward to working with him closely on the Justice Committee. Look, he raises a valid point about issues around collection, issues in respect of women who often are disadvantaged in a divorce or a marital breakdown, and there's no question that it really has a significant financial impact. I mean, oftentimes people are losing half of what they have when there is a divorce. So all I can say is that we will look very carefully at the bill and we'll work with the government, with the Parliamentary Secretary in a constructive manner to hopefully craft the best possible legislation for women, for families, and for children in Canada.
Questions and comments. The Honourable Member for North Okanagan, Shuswap.
Thank you, Mr. Speaker, and I thank my colleague right beside me here for his intervention this morning. It's a little bit awkward for me to get up and stand and speak on a divorce bill, having actually enjoyed almost 40 years of a very happy marriage. So it's a little bit awkward speaking on a divorce bill. But although we've had a very happy marriage, we've also a number of friends that have gone through uncomfortable divorces. And one of the things that comes up, and it's been mentioned as part of this bill, is the child support payments. And I would like to ask my colleague if this bill gets to committee, that he will ensure that there are phrases and language in the bill that can address some of the ways that the individuals are avoiding payment by working for cash. They're not actually paying income tax. None of it is reported to Revenue Canada. It's under the table. It can't be seen by the courts. I'd like to ensure that he can look at wording to address that issue in the bill. Thank you, Mr. Speaker.
The honourable member for St. Albert, Edmonton.
Well, thank you, Mr. Speaker. I thank my colleague for Okanagan Shuswap for his comments, and I certainly agree with him in terms of the importance of the matter that he raised. But seeing that my time is nearly expiring, on a slightly more partisan note, I do want to say that it is a bit ironic that Bill C-78 makes, among other things, and rightfully so, the paramountcy of the best interests of a child. What a contrast to Bill C-75, which is currently before the Justice Committee, which waters down sentences for a whole host of serious offenses that directly impact children, including kidnapping a minor, forced marriage under the age of 16, and I could go on. The government is treating those offenses that directly impact children from serious indictable offenses down to hybrid offenses that could be punishable by a mere fine. So while it is encouraging, as I say, that we are focused on the best interests of the child in this bill, I only wish that the government would have the best interests of the child in all bills, including Bill C-75.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
So, and I appreciate the member's comments, both in his speech and also in his most recent responses to the questions. But what I would put to him is that you see strong statements in Bill C-78 with respect to defining family violence for the first time in a much more expansive way, giving judges actual tools to use in interpreting family violence. And I would put it to the member opposite that I find actually in strong consistency and strong thematic consistency with Bill C-75, which you just mentioned, which goes into intimate partner violence. And I would also say thematically that what both bills are trying to do is reduce reliance upon lawyers like me and lawyers like such as many in this House who are involved in part of the overly litigious nature of the family law system. By encouraging people and giving them the tools to remove themselves from the court system, what we were doing is reducing some of the backlogs that are characterize that system, which is a goal that I think the member opposite and those on this side of the House both share. And I would put it to him that those two are in fact compatible goals and that the legislation is moving in the same direction.
The honourable member for St. Albert, Edmonton.
Well, Mr. Speaker, Bill C-78 does appear to contain a number of measures to, among other things, combat family violence. And we welcome, Mr. Speaker, improvements in order to address the very serious and systemic issue of family violence. We've always stood up for the safety and well-being of children and families as conservatives. And again, I reiterate that I, along with all of my colleagues, intend to work closely with the government to achieve some of those objectives that are very, very important.
Questions and comments. The honourable member for Yellowhead.
Thank you, Mr. Speaker. And I'd like to thank my honourable friend from St. Albert for his speech. But I noticed that the government has also allotted under this bill approximately $77.2 million to be utilized in a program to help situations like this. And so often I get people calling my office, either one spouse or the other spouse, that are in financial hardships, especially over these last 3 years of things happening in Alberta, where they don't have the funds to sit down and negotiate with the lawyer because of the cost. And I wonder if you just comment again on this alternate resolution that might be started as a result of this program, and whether it would be a benefit to couples. It would save them a lot of money. Because we used to have an old saying in Alberta that if you end up going to divorce, you take your estate and half goes to the legal firms, and you might end up with a quarter each if you end up going to a dispute. Thank you.
Honourable member for St. Albert, Edmonton.
Well, I thank my colleague for Yellowhead for his question, and he's absolutely right that the costs involved in litigating family disputes are extremely expensive. It costs thousands and thousands of dollars, often to do very little. And by the time that the matter is resolved, and it really is never resolved because these things are ongoing, when we're talking, Mr. Speaker, about children that are at the center of often these disputes, that tens of thousands, if not hundreds of thousands of dollars may be expended on lawyers. And, you know, at the end of the day, Mr. Speaker, no one benefits from that. Parents don't benefit, nor do children. And of course, the obvious consequence when you're spending tens of thousands, if not in some cases hundreds of thousands of dollars, is a huge amount of resources that could otherwise go to support the children of the family are being expended towards litigation, and lawyers, I guess, to some degree benefit, although I don't think any lawyer takes comfort in seeing families in these disputes expending all kinds of money to no end. So, Mr. Speaker, again, as I mentioned, it is encouraging that this bill does focus on alternative dispute resolution. The faster that these matters can be resolved outside of court at as little costs as possible stands to benefit everyone in the process. So it is an encouraging sign.
Questions and comments? Questions and comments? I sense there are no more questions and comments. I just wanted to bring to the attention of the House, in the course of acknowledging the honourable member for St. Albert Edmonton, force of habit and information that I had in front of me conspired to the fact that I didn't realize that he was actually accorded 20 minutes for his remarks and a following 10 minutes for the period for questions and comments. Accordingly, I gave him the 2-minute mark at 8 minutes into his remarks. Now, I do sense that I did think that he had probably gotten on the record all the things he wanted to do. Nonetheless, I did cut him off midway through the time that was originally allocated to him. So I'll then open it up. If there are any more questions and comments, we can continue for a few minutes. We'll take one more question. The honourable member for Chatham-Kent Leamington.
Well, thank you, Mr. Speaker. And I'm also very interested in my colleague, his comments. And I want to just take him back to his concerns about this government's efforts to protect the child. And I remember in a former committee that we had testimony for youth unemployment. It was actually called youth employment. The major causes, and there was one testimony given by a group that said, look, we have found that those that finish grade 12, get married and stay married, don't do drugs and alcohol, have a greater chance, as a matter of fact, will not probably experience poverty. And so much of the talk today surrounds those issues and those problems that we have in our divorce courts today. But I'm curious if the member might be able to maybe just take us in another direction, and that would be to what we could do as governments to help to strengthen the institution of marriage. Now, I know that this is not part of this bill, but his comments about the government's lack of forcing proper punishment on crimes that are perpetrated against children, are there things that this government can do to help to propagate and build up marriages? Because we certainly do know that that would certainly help our society. Thank you.
Member for St. Albert Edmonton.
Well, I thank the member for Chatham-Kent Leamington, or Chatham-Essex Leamington, for his question. I would say, just speaking to Bill C-78, one of the criticisms that has been raised is that the bill does not provide for a rebuttable presumption for equal shared parenting. Now, it is true that shared parenting isn't always in the best interests of the child in every situation. But I think most honourable members would agree that to the degree that it is possible for both parents to be involved in the raising of that child, that in many circumstances, in the normal course of things, would be in the best interests of the child, hence the basis for a rebuttable presumption for equal shared parenting. Mr. Speaker, I think that that is one of the many issues that we're going to look at carefully when we study this bill in committee.
Questions and comments? Any more questions? Maybe take one more. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I appreciated a bit of the history lesson from my colleague across the way in regards to divorce acts and how they came into being. Appreciate the fact he was born in 1984, I believe he said it was. The question I have to him is, he talked about the patchwork that was in Canada at the time. And to me, it emphasizes the importance of recognizing that, yes, it's good that we have this legislation and it's moving forward, it'll go to committee, but it's also important to recognize that other jurisdictions also have an important role to play in this whole area of divorce and maintenance and so forth. And if he could just provide his thoughts in terms of just how important the stakeholders that are all at play here need to come to the plate also.
The Honourable Member for St. Albert, Edmonton.
Yes, well, I thank the Parliamentary Secretary to the Government House Leader for his question, and he's absolutely right that when we talk about family law, that we are talking about shared jurisdiction between the provinces and the federal government. Section 91, sub 26 of the Constitution Act provides that it is within Parliament's jurisdiction to legislate with respect to marriage and divorce. Everything outside of that falls within the provinces. So issues around separation and separation agreements, etc., would fall within provincial jurisdiction. But beyond the issue of jurisdiction, he's also right that it's not just a matter between parents and children that are involved in these disputes. There are a lot of stakeholders, whether they be social workers, whether they be law enforcement, and I could go on, Mr. Speaker, and it's very important to get their perspective on this bill. I trust that we will be hearing from a cross-section of stakeholders who can provide their feedback, who can perhaps critique or identify some shortcomings or some gaps within the bill that could be closed, and I trust that we will do that at the Justice Committee.
We have time for one more question and response. Questions and comments. The Honourable Member for Yellowhead.
Thank you, Mr. Speaker. I'd like to thank the member from St. Albert again for his report. But he did mention in one of his answers just a few minutes ago about Bill C-75, and I am still concerned about Bill C-75. This bill reduces sentences for very serious crimes, including abduction of child under the age of 14, participating in activities of criminal organizations, forced marriages, marriages under the age of 16, and concealing the body of a child. These policies are very alarming to me, and I wonder if he'd like to just comment on them, because I know earlier he just mentioned Bill C-75. Thank you, Mr. Speaker. Through you.
The Honourable Parliamentary Secretary, on a point of order.
Mr. Speaker, I do believe that question is out of order. We are debating Bill C-78. The matter of Bill C-75 was raised in a response made by my friend opposite in the context of the back and forth interplay on the dialogue. But this question is only referencing Bill C-75 and not referencing Bill C-78. And I would ask you for your ruling as to whether that is in order as a question when we were discussing at second reading Bill C-78.
I thank the Honourable Parliamentary Secretary for his comment on this. This does occasionally happen when other references are made in the context of responses that are given in the House, and therefore it sometimes opens the door to questions potentially and frankly and perhaps indirectly related to the matter before the House. I take the Honourable Member's note. I didn't, frankly, I must admit, I did not specifically hear the reference in the question to the Honourable Member, or that was made by the Honourable Member for Yellowhead. I will remind Honourable Members to keep, even when we are in questions and comments, they can certainly address aspects of the debate that they have heard, either in questions or in comments in this sense. but I would ask honourable members to keep their comments and inquiries pertaining to the matter that's before the House. We'll go to the honourable member for St. Albert Edmonton for his response on this, and then we'll be going to resuming debate. The honourable member.
Thank you, Mr. Speaker. And I do think there is a connection between Bill C-78 and Bill C-75 with respect to the hybridization of offences in the latter bill, to the degree that we are talking in Bill C-78 about the best interests of the child, and yet Bill C-75 is a step in exactly the wrong direction from that standpoint when we're talking about potentially reducing sentences from a maximum of 10 years to 2 years less a day. And of course, in the case of Bill C-75, the reclassification of those offences not only is not going to put the best interests of a child first, it isn't going to achieve the objective of what the government is trying to do, which is to deal with the backlog in our courts. Indeed, 99.6% of criminal cases in Canada are before provincial courts. What the reclassification of offences is going to do is simply download more cases onto our already overburdened and overstretched provincial courts.
Resuming debate, the honourable member for Surrey Centre.
Thank you, Mr. Speaker, and I'll be splitting my time with the member from Willowdale. Mr. Speaker, I'm pleased to rise today to speak on Bill C-78 and the significant contribution that it will make addressing family violence. The Chief Public Health Officer of Canada has identified family violence as an important public health issue, recognizing the effects of family violence go well beyond physical injury and can have long-lasting impacts on mental health. In 2014, 13% of individuals who were separated or divorced and who had been in contact with their former partners within the last 5 years reported being victims of spousal violence. While we have no solid statistics on the number of family law cases where family violence is a factor, estimates from court files, reviews of and surveys of lawyers and judges range anywhere from 8 to 25%. And yet, Mr. Speaker, the Divorce Act currently makes no mention of family violence or how it is relevant to parenting matters. Bill C-78 takes concrete steps to address this gap. There are marked differences in the severity and the violence that men and women experience. In 2014, women were twice as likely as men to report being sexually assaulted, beaten, choked, or threatened with a gun or knife. In contrast, men were 3.5 times more likely to report being kicked, bitten, or hit. Mr. Speaker, we also cannot forget that children can be directly and indirectly affected by family violence, and that the exposure to family violence often comes with direct abuse against the child. In 2014, 70% of adults who reported having witnessed parental violence as children also reported being victims of childhood physical and/or sexual abuse. Children who witnessed that violence were also more than twice as likely to experience the most severe forms of physical abuse compared to those who had not witnessed violence. Mr. Speaker, children can be negatively and deeply harmed emotionally when they are exposed to family violence. Whether it's from seeing the violence take place or bruises on a parent, emotional and behavioral problems, and even post-traumatic stress disorder can be a serious effect. Mr. Speaker, despite all we know about family violence, myths about it remain. There are two main myths that I would like to highlight today. The first myth about family violence, particularly intimate partner violence, is that if a survivor has not reported to the police, then the violence did not happen or it was not serious. Statistics Canada tells us that only 19% of survivors report violence to police. Some do not report violence to police out of fear of not being believed and or that calling the police may escalate the violence. Certain vulnerable communities also have mistrust for the police. Despite these fears, survivors may choose to start family law proceedings in order to protect their children, whether they reported violence to the police or not. In some cases, starting a family law proceeding can increase the risk of violence. Leading family violence researcher Linda Nielsen notes that family law cases involving domestic violence are not necessarily less serious or less dangerous than criminal cases. Indeed, some are more dangerous. Mr. Speaker, the other myth is that intimate partner violence ends after separation. In fact, separation can actually increase the risk of family violence, and it often persists long after the relationship has ended. In 2014, 41% of those who experienced family violence by an ex-spouse reported that it occurred after the breakup. In just under half those cases, about 48%, the violence took place at least 6 months after the separation. Very worrying is the fact that in almost half of those cases where violence occurred after the separation, it increased in severity. Bill C-78 includes a number of measures to strengthen the family justice system's response to an unfortunate case of family violence. First, Mr. Speaker, we must realize that when a family is in crisis, it is possible that various aspects of justice may be involved, such as the criminal, civil protection, or child protection proceedings, in addition to divorce proceedings. Unfortunately, however, the divorce courts are often not aware of other proceedings or orders that may have been made. This lack of information about other proceedings can lead to conflicting orders, such as where a criminal order prohibits contact between a parent and other family members, but a family order provides that same parent with access to a child. This is why Bill C-78 will amend the Divorce Act so that courts will have evidence of other pending proceedings or orders in effect. This will help improve the administration of justice. Where parenting is specifically at issue, courts are required to consider only the best interests of the child. New criteria listed in Bill C-78 will require consolidation of any civil or criminal proceedings or order relevant to the well-being of a child, even if no longer in effect. This is to help ensure that the court has all relevant information when deciding on the best interests of the child. It is critical that family violence be taken into account when deciding on parenting arrangements for children. Mr. Speaker, as we have learned more about family violence, in particular intimate partner violence, we have come to understand that not all family violence is the same. Depending on the nature of the violence, it can have very different implications on the parenting of the child and the ability of former spouses to co-parent successfully. At least 4 different types of violence have been identified, but given my short time today, I will only mention 2. The first is separation-instigated violence. It generally involves a small number of incidents around the separation. Although these can range from very minor to more serious, while no violence is ever acceptable, Mr. Speaker, this type of violence may, over the long term, be less likely to negatively affect the ability of the parents to work together or care for the child. In contrast, the second type is coercive and controlling family violence. As the name suggests, this violence involves a pattern of control-based intimidation, emotional abuse, and physical violence. Coercive and controlling violence is most often perpetrated by men against women. It generally occurs over a prolonged period, has the highest risk of lethality, and is most associated with compromised parenting skills. The perpetrator often attempts to control his former partner long after separation. As a result, in these situations, joint decision-making can be challenging, and contact between parents during the exchange of the child can create opportunities for further abuse. To address the range of family violence, Bill C-78 includes an evidence-based definition of family violence. It identifies that family violence can include a pattern of coercive and controlling behavior. It provides examples of specific behaviors that constitute family violence, such as physical and sexual abuse, and psychological violence and harassment, including stalking. Finally, Mr. Speaker, Bill C-78 specifically highlights family violence as relevant to the best interests of the child when making parenting arrangements. The proposed amendments will direct consideration of any impact of the family violence, but in particular how it might affect the ability of the parents to cooperate with one another, or how it may affect the ability of an abusive parent to care for the child. The bill also provides a list of specific criteria for the court to consider that will determine the severity of the violence, the impact that it has had or may have, and whether and how this should inform the parenting arrangement. Mr. Speaker, these criteria will help put focus on the particular dynamics of family violence in each individual case. Importantly, both the definition of family violence and the best interest criteria recognize that even when children are not directly subjected to violence, they can be harmed by it. Through Bill C-78, we're taking concrete actions to promote children's best interests in situations where they are most vulnerable. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Yellowhead.
Thank you, Mr. Speaker. I'd like to thank the honourable member Cross for that speech. And I wonder if he would be able to clarify something for me under Clause 54. The increased term of service is binding by Her Majesty from 5 years to 12 years. And I wonder if he could explain to me why it was raised.
The honourable member for Surrey Centre.
Thank you for the question. Unfortunately, I'm not privy to that. Let me look into that, and I will love to get back to the member opposite. But as far as I know, I can't answer that, and I wish to answer that in due course. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member from Vancouver, from Surrey, for his comments and for his speech and for the work he's doing on behalf of his constituents. And as a lawyer, I also take a lot of solace in the insight that he's provided in terms of what this bill will do in terms of addressing the litigious area that represents family law. But he focused a lot of his comments on family violence. And I'd put to him that there are specific provisions in this bill that will require, under the Divorce Act, that there must be evidence before the courts about any criminal proceedings or orders against any person seeking a parenting order or a contact order. And that's intended to avoid inconsistent orders where, for example, a criminal court might have said no contact to a certain parent, and a family court might be making a different order, not knowing about the criminal order. Could the member please elaborate upon that kind of change and what it means for addressing the very important family violence objectives that we were trying to achieve in reducing family violence in Canada?
Honourable member for Surrey Centre.
Thank you. I'd like to thank the Parliamentary Secretary on his insightful question. It's going to help a lot. As we know, litigation can be long and cumbersome. It can also involve different departments. There could be child protection arrangements that are made which have certain contact orders. It could be criminal proceedings. Sometimes other family members are also involved where others have no contact orders or stay away orders or restrictive contact orders. And previously the two didn't marry in court, and the family judge would not necessarily know of the other binding or other arrangements, and now they will have access to those. You will not have to make special applications to have them heard or brought into court. A judge will have all the data available, all the orders available, regardless of the level of court or the jurisdiction of the court or the type of proceeding that it was made in. And that facilitates, again, the best interest of the child, safety and security of the parent, and just clarity so that judges don't contradict and make contradictory orders, not knowing other aspects of the arrangement.
Questions and comments. The Honourable member for North Island, Powell River.
Thank you, Mr. Speaker, and I thank the member for his speech. I appreciate the child-focused approach to this bill. I think that's really important that we acknowledge that children during these very difficult times need to be at the very center of the conversation. In this bill, it also includes a lot of discussion around reducing child poverty. But there's no resources that have been set aside for this. So I just am curious if the member could tell me a little bit about how this government will provide the means to get to that ambition. Thank you.
The Honourable member for Surrey Centre.
Sure, I'd like to thank the member from North Island from British Columbia for a pointed question. Look, it's going to reduce poverty by simplifying and streamlining processes related to family support. It's going to allow for the release of CRA information to help establish, vary, and enforce family support, i.e. income information from your T1s, which otherwise would have to be voluntary or have a court order to be made for it. It's going to allow implementation of the 2007 Hague Child Support Convention, which provides a low-cost and efficient way for people to get family services across international borders. So I think the combination of those four will have a great impact on making it more efficient and more cost preventative for families.
Resuming debate, the honourable member for Willowdale.
Thank you, Mr. Speaker. First of all, allow me to thank the honourable member from Surrey Centre for focusing essentially on the question of violence and how this bill will allow us to address that. I, on the other hand, will be taking a more general overview of this legislation, which I'm incredibly proud of. Now, as you know, the first substantial update to Canadian family law is occurring in 20 years. Bill C-78 represents a landmark in strengthening and enshrining the best interests of the child and will make federal family law more responsive to the modern-day needs of Canadian families. Family law, as has been noted by all the speakers today, is both complex and broad, and as a result, there are significant gaps and inefficiencies which existing laws have not adequately addressed. Bill C-78 seeks to remedy these gaps through a wide-ranging series of common-sense adjustments. Today, I will focus on 6 key elements of Bill C-78. 1. Strengthening the best interests of the child provision. 2. Enshrining primary consideration into family law. 3. Important changes to terminology. 4. Modernizing the Divorce Act. 5. Creating contact orders. And 6. Setting new relocation guidelines. So allow me to first start off with best interest of the child test. The best interest of the child test has been a fundamental part of family law in Canada and in many other countries for decades. Under the Divorce Act, courts must consider only a child's best interests when making decisions about who may care for or make decisions about a child. The Divorce Act, however, gives surprisingly little guidance regarding this test. In 1998, the Special Joint Committee on Custody and Access called for the Divorce Act to include a list of criteria considered to be in the best interests of the child. Many others have added to this call, including academics, child advocates, and the Canadian Bar Association. With Bill C-78, our government is answering their calls and taking important steps to address existing gaps and inefficiencies in the family law system. The proposed criteria for the best interests of the child will emphasize critical elements of a child's life. They include a child's stage of development, ties to loved ones, cultural identity, and personal views and preferences. However, the list is not closed or exhaustive. If a particular factor in a child's life is especially relevant, for example, if the child has medical needs or participates in competitive sporting events, courts could consider these factors where appropriate and relevant. Adding definitional certainty to the best interests of the child test in the Divorce Act promotes children's interests. It also promotes another one of the bill's key goals, improving access to justice. In some Canadian jurisdictions, over 3/4 of family law litigants are self-represented. Also, a list of best interests of the child criteria in the Divorce Act will help parents better understand their legal responsibilities. It will assist them to better frame their negotiations on arrangements for their children and more often come to agreements outside the court system. Alternatively, if parents cannot agree on their own, this clarity will help self-represented litigants better frame their arguments in legal proceedings. Allow me now to move to the second point, which is primary consideration. The reference to primary consideration is crucial to the values embodied in Bill C-78. Emphasizing primary consideration ensures that courts prioritize a child's physical, emotional, and psychological safety, security, and well-being. Courts will weigh all other criteria in regards to this primary consideration. Doing so will ensure that the best interests of the child remain paramount in protecting families from the negative outcomes often related to separation and divorce. Moving to the third point, updates to terminology. Bill C-78 makes important and, frankly, long overdue changes in family law terminology. Custody and access are now archaic legal terms. The term custody traces its origins to property law, which for hundreds of years has essentially treated children as possessions. Access, meanwhile, refers to a right to use or pass over property. This is not how we should describe responsibilities for children in 2018. In addition, litigation over custody and access has created additional labels whereby custodial parents are viewed as winners of parenting disputes and access parents the losers. Bill C-78 would move away from such confrontational language as Alberta, BC, and several other international jurisdictions have done. Now, going to the issue of modernizing the Divorce Act, Bill C-78 replaces orders for custody and access in the Divorce Act with parenting orders. A parenting order addresses parenting time and decision-making responsibility for each of the parents. Specifically, parenting time refers to the time a child spends in a parent's care. This includes all time when a parent is responsible for a child, even when the child is at school. Each parent will have as much parenting time as is consistent with the best interests of the child. On the other hand, decision-making responsibility refers to making important decisions on issues such as health, education, language, religion, and significant extracurricular activities. Bill C-78 allows the courts to allocate this responsibility to one or both parents, or alternatively, to divide elements between the parents. Furthering the goal of improving access to justice, the bill includes a parenting plan provision, referring to agreements between parents that sets out a roadmap for the care of the children moving forward. The bill encourages courts to incorporate a parenting plan that is in the child's best interests. This provision recognizes that parents are generally best placed to make decisions about their children. Now, moving to the fifth issue, which is contact order, Bill C-78 also proposes a contact order in keeping with the best practices already established by several provincial courts. Contact orders carve out time in a child's schedule with a person other than a parent, such as a grandparent. I'd like to clarify that a contact order would not usually be necessary in order for grandparents and other loved ones to spend time with a child. It would only be necessary where, because of conflict, parents do not agree to let grandparents or other loved ones spend time with the child. In such cases, Bill C-78 will allow courts to make contact orders. These orders could help preserve children's relationships with their loved ones where appropriate. As with parenting orders, courts will make contact orders if they are in the best interest of the child. Finally, the issue of relocation. I'd like to address an issue that's challenged parents, lawyers, and courts for many years. Relocation involves moving a child after separation and divorce. It is one of the most litigated family law issues in existence. In a 2016 survey of lawyers and judges, for example, over 98% of respondents indicated that disputes are harder to settle when relocation is involved. Bill C-78 creates relocation guidelines to address this conflict. Parents will now be required to give notice if they want to relocate either themselves or their children. An assessment will be conducted using best interest criteria when considering such a request. These would include factors such as reasons for relocation, the impacts of relocation on the children, and finally, how reasonable the relocation request is. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I want to thank the member from Willowdale, who happens to be an old high school classmate, for his speech today about Bill C-78 and for that very comprehensive overview about the legislation. And I want to ask him, because he touched on so many different facets, if we could zoom out a little bit and if he could provide us with his insight and comments about how this bill fits in with some of the broader initiatives that our government is pursuing. And the two that I would ask him about are, we've heard about how this bill impacts upon child poverty. How does that fit with some of our broader objectives on addressing child poverty in Canada as a government? And secondly, we've heard about how this bill will address family violence in a more direct way. And how does that work with Bill C-75, which is before the Justice Committee, which my colleague is a member of, and the provisions that are being put in place in that bill that deal with intimate partner violence as a context of things such as bail conditions. So if we could elaborate on the broader impact on what we were doing as a government. Thank you.
Member for Willowdale.
Thank you, Mr. Speaker. I'm much obliged to listen to the Parliamentary Secretary for bringing to the fore two really significant issues that are very much at the heart of this bill. The first issue being reducing poverty. As was noted, I think this is a huge step in the right direction. First of all, it should be noted that this particular bill simplifies and streamlines processes that relate to family support. Secondly, it will allow for the release of CRA information, which can be really critical in these types of disputes. Lastly, insofar as the issue of poverty is concerned, I think it's important that we're implementing the 2007 HoC Child Support Convention. The second issue that the Parliamentary Secretary has raised is the issue of family violence. I think we can all agree that we should be very much concerned about the high incidence of violence. And I think this bill, again, really does an incredible job of addressing this priority. Looking at the bill, one of the things you will notice is that there is a definition for family violence in the Divorce Act, which, for the first time, would include any conduct that is violent, threatening, a pattern of coercive behavior, or behavior which causes a family member to fear for their safety. In addition, it requires courts to consider family violence in determining the best interests of the children. Lastly, I'd like to highlight the fact that improving safeguards to account for family violence is very much a part of this specific bill. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Yellowhead.
Thank you, Mr. Speaker. I'd like to thank the member from Willowdale for a very good speech. I don't think there's anybody here in this House can deny that C-78 is well overdue and is needed. And I listened in depth about your conversation about separation, family relocating, the courts sitting down and evaluating a mechanism to look at both sides, and maybe that body, through you, Mr. Speaker, deciding if it is appropriate for the parties to move from one location. But I was wondering if the honourable member, I was reading through this bill just lately, but is there a mechanism of repeal if the courts say, okay, you can't move for some reasons based on what you have brought to us? Is there an appeal mechanism built into this act that would allow people to appeal that? Thank you.
The Honourable Member for Willowdale.
Yes, firstly, allow me to thank the Honourable Member for raising that very significant issues. As he kindly noted, I think this is a huge step because this is 20 years overdue. So it's great to see that the members are focused on this significant priority. Insofar as relocation provisions are concerned, I think the emphasis here is to make sure that when courts are considering such a significant issue, they actually take the best interests of the child. They consider it and they hear from both of the parties so that this isn't essentially an issue that is brushed aside. It's something that is at the center of it, and that is precisely why this bill does provide guidelines for judges to consider such a significant issue. Thank you.
Resuming debate, the Honourable Member for Yorkton Melville.
Thank you, Mr. Speaker. I'm pleased to rise today to speak to Bill C-78. I don't come at this from a legal perspective. I am not a lawyer. And I don't come from it from the perspective of actually having experienced this directly. Although I can say, even as an adult, I was raised in a home with 6 children, a very happy, very busy home. And then when my parents were much older in life, and I was a grown woman myself, they faced a difficult time when they came very close to divorcing. And I have to say that even then, as an adult and with my own children, it was extremely unnerving and disturbing to me, which just raises the realization of how important it is that we have systems in place to assist children. I can't imagine what it would have been like to actually be dealing with those circumstances as a young child in my home. Fortunately, things worked out well. But that being said, in regards to Bill C-78, I appreciate the 4 key objectives that are listed here: to promote the best interests of the child, address family violence, to help reduce child poverty, and streamlining various definitions and processes, but more importantly, requiring legal professionals to encourage clients to use alternative ways to resolve disputes. You know, the Conservative Party has always had this perspective that we believe that in the event of a marital breakdown, the Divorce Act should grant joint custody and/or shared parenting unless it is clearly demonstrated not to be in the best interests of the child. Both parents and all grandparents should be allowed to maintain a meaningful relationship with their children and grandchildren unless it's demonstrated not to be in the best interest of the child. In every case where it's possible, the influence of both parents and grandparents as well and siblings are so key to making sure that that family unit is able to survive as best as it can through these difficult circumstances. We understand very well how traumatic divorces are on families. So overall, pleased with the intentions of Bill C-78, especially the promotion of child welfare and the measures to combat family violence. We've always stood up for and believe in the safety of the well-being of children and families. However, where this kind of goes off the tracks for me is in the fact that the counterintuitive implementation of Bill C-75 is here as well. And I know that Canadians' heads are spinning, quite often trying to determine if this is a whole government approach to things, how it is on the one hand we can be saying we're so concerned about children, and then on the other hand be bringing in C-78 that reduces sentences for very serious crimes, including abduction of a child under the age of 14, participating in activities of a criminal organization, forced marriages, marriage under the age of 16, and concealing the body of a child. These are very, very serious crimes and impact children, and yet this government seems prepared to bring in something that seems so contrary to me. I forgot to mention as well, Mr. Speaker, I will be sharing my time with the member from Banff Airdrie. I don't want him to miss this opportunity. I want to actually quote something that I read from the Lawyer's Daily, written by David Franco. He wrote, "The impetus in fights between parents does not begin when spouses read the terms custody and access in the Divorce Act. Therefore, unless there are additional provisions added to the proposed amendments, the family conflicts will likely continue, even with the replacement of the terms custody and access with parenting as introduced in Bill C-78. I appreciate what's being attempted there with the terminology being changed, but at the same time, that's a good point, that simply changing the terminology will not, in the end, make a huge difference. A parenting order will replace the traditional named custody and access order. So that needs to be done, but actually it has already been taking place. The significant changing, he says, in wording likely arose to answers that concerns from the courts over the years that have awarded one parent status of custody and the other access, realized that it created unnecessary winners and losers. As in 1975, Justice Robert Furlong wrote, "The time is long past when the courts disposed of the custody of a child as a reward to the well-behaved parent or as a punishment to the one who misbehaved. The custody of their children is not a prize to be contended for by parents as an award for their good behavior." In 1986, the Manitoba Court of Appeal upheld a decision to refrain from using words custody and access because the trial judge thought those would be destructive to the child. However, perhaps the more important focus of this discussion should be the issue of control, as that's quite often, unfortunately, what the fight is about when we have these circumstances. Litigants in time will become sophisticated in understanding the effects of a future parenting order, and couples that previously fought incessantly over the term custody will now fight over who will have the decision-making responsibilities. So in other words, that's part of it, but how do we basically come to the point where the extreme difficulties of making these decisions are not fought out in such a confrontational way? Therapy and assessment orders, he goes on to say, for litigants will not solve all the problems in custody battles, but they may expose the underlying factors contributing to unreasonable positions taken by them. Therefore, in addition to change in language to the Divorce Act, it may be necessary for a court to have the jurisdiction to order trained professionals to determine and opine whether a parent's desire for custody or parenting order is based on healthy motives or not. And as such, if this information cannot be readily available when needed, then simply repealing the terms custody and access may not achieve the intended consequences we're all waiting for with Bill C-78's introduction. So in other words, Mr. Speaker, there's a need here to make sure that there's implementation of efforts to make sure that the individuals that are involved in this circumstance have the tools at their disposal to be able to assist them to process more effectively. There is no question that in these circumstances, probably it's one of the most trying and difficult circumstances for a couple who at one point married because of a desire to see their life be a long-term commitment and have children and then be in this circumstance. Yes, sometimes there are very violent circumstances. Other times there's a loss of that ability to communicate, but there needs to be these processes in place to assist them. Further to that, I read an article from Robert Harvey. Now, he is a family lawyer, mediator, and arbitrator with HoC Vale LLP, advisory board member for the National Self-Represented Litigants Project, and past Law Society of Alberta bencher. So this individual comes at this, I think, from a very well-rounded perspective. He says the unveiling of Bill C-78 received almost uniform praise from the media and legal profession as the first major amendment of the Divorce Act in 20 years, which it is. But he says, my opinion is less effusive. Perhaps it's the cynicism of a lawyer who has been working in family law for 32 years. Having sat as a bencher with the Law Society of Alberta and in fact chaired their Access to Justice Committee for 2 years, I have seen much promise and very little delivery in improving access to justice. As a result, I opened up the 190 pages of Bill C-78 with less optimism than many of my colleagues. He kind of compared it, he says, similarly to the excitement over the maiden voyage of the Titanic, which got my interest. He talked about how with the Titanic, they talked about all the amazing additions to make this amenities and necessities better. Squash racket courts, baths, gymnasiums, swimming pools, electric passenger lifts, all these different services, more deck chairs to make the trip better. However, the reality was that they didn't have what they truly needed. Mr. Speaker, he indicates that at the core of Bill C-78, it's devoid of changes to the overall resolution process. Lawyers charge too much money. Law societies appear focused on reducing complaints rather than caring for them. Litigation is antiquated and cumbersome. He says we need to fund and support more alternative forms of resolution. Well, Mr. Speaker, I have a good friend, it reminds me of, who settled many, many cases for his law firm, divorce and custody cases. He settled them out of court without expensive litigation. However, he lost his job. Why? Because he didn't have enough billables, not productive enough for the firm, i.e., didn't make enough money for the firm. He was encouraged to go work for legal aid because that was where he belonged. Mr. Speaker, our legal system needs to change. so that there's an investment within our firms in litigating these cases through mediation and arbitration. Yes, we can tell people they should go and do this, that they should make this choice, but they find themselves usually at first at a law firm. I would like to see this as a concern within the legal profession in Canada, where we make this a priority and prepare our lawyers that are clearly there and willing to take this type of a role on to serve Canada, to serve men and women, and especially to serve children. Thank you.
And comments. The honourable member for Parkdale High Park.
Thank you very much, and I thank the member opposite for her comments, but I actually will confess that I find them quite puzzling. And to analogize this legislation to the Titanic is actually fairly preposterous, Mr. Speaker, and here's why. Because the consultations that were done were widespread. The reception we've received for this legislation has been vociferous in its support, and that is from coast to coast to coast. And the consultations, including in Alberta itself, that uses a conservative government in Alberta is the very government that initiated the concept of changing the terminology from custody and access to contact and parenting orders. And what I would say to the member opposite is that she raised Bill C-75 and some of the provisions there that she finds logically inconsistent with what we were doing in Bill C-78. And what I would say to her is quite the contrary. What we were doing in Bill C-75 is exactly the same as what we were doing in Bill C-78 in two important respects. Family violence, intimate partner violence is at the heart of what we were doing in C-75. We are addressing it, making it a requisite to deal with that as a concept or a condition on bail. What we were doing here is making family violence something that a judge has to consider, including criminal orders or proceedings in terms of the determination of the best interests of the child. The other conceptual component that is exactly the same between the two pieces of legislation is that in each instance we were trying to reduce the very backlog that my friend opposite laments in our court system, our over-reliance on the court system, the over-litigiousness of Canadian society. We're reducing that on the C-75 side, and that is exactly what we are doing here with this provision. And two cases in point are with the ADR mechanisms for calculating support. Could I have the members opposite's comments on how improving ADR mechanisms addresses actually the very problem that she's identified?
Honourable member for Yorkton Melville.
Thank you, Mr. Speaker. I clearly hit a nerve, and I have indicated already there are many circumstances where the legal system needs to do what it needs to do to deal with very violent circumstances within family scenarios, and that is important. I'm not denying that. However, at the same time, as I indicated by the individual who, it wasn't me that actually compared it to the Titanic, it was Robert Harvey, family lawyer, mediator, and arbitrator, also the advisory board member for the National Self-Represented Litigants Project and Past Law Society of Alberta. He indicated that while we're uniformly acknowledging how damaging and inappropriate litigation is to resolve family disputes, this is a man who knows his stuff. At the same time, we're acknowledging that, but funding and support for alternate forms of resolution is so scant as to be almost non-existent, while the funding for the litigation machine only grows. And I know personally scenarios where couples find themselves in a circumstance already overwhelmingly difficult, where both individuals realize that they are facing divorce and have to get through that process and are very concerned for their children. I'm talking about circumstances where we could do a great deal more to enable couples to deal with the circumstances they're facing through other methods and means, rather than having to go through the law system where lawyers charge huge amounts of money and litigation is the natural path for them to take, rather than, as with my friend who was an amazing lawyer, working in a firm, and solving most of the issues, not all of them, but many of them that came to his desk through arbitration and mediation without going to court, without expensive litigation. So that is the point that I'm trying to make. And that is not a priority of the legal system when they say go over to legal aid, work there, rather than invest within Canada to see healthy families continue to thrive because we invest in this type of services within our legal system. Thank you.
Resuming debate, the honourable member for Banff Airdrie.
Thank you, Mr. Speaker. In rising to speak today to this bill, Bill C-78, I guess I'd like to start with a story, personal story, one that probably will surprise many in the House and probably many back home in my community even. I spent a number of years as a very young man as a single father, and raised my son Quinn, who's now 22 years old, and kind of working 2 jobs while going to school full time and trying to raise him. And it was a difficult time for me financially, for sure, and one that we got through. We did well. My son actually often tells me he looks back on that time with some of the best memories of his life were from that time. Even though it wasn't a lot I could afford to put on the table. It was craft dinner. It was hot dogs. It was hamburger helper at best. And we did without a lot of things. We lived in basement suite apartments for a few years while I did school. But I was able to raise him, and I think I've raised him into a fine young man, one that I'm very proud of. And although at that time I did have some experience with family law, it wasn't. I guess it wouldn't have related specifically to the Divorce Act, but I think it does speak to some of the concerns that are trying to be addressed by this piece of legislation today. And it's for that reason, and some of the stories that I've heard from others that I've spoken to during and since that time, during my time as a member of Parliament as well, that I do find the objectives and the goals of this piece of legislation to be laudable. Certainly, the idea that some of the things I guess being addressed by the bill are making sure that, or trying to ensure that the best interests of the child are always being promoted. Reinforcing and emphasizing the importance of keeping a child's best interest as the absolute top priority in family law when making decisions about parenting in these situations, in these cases, is a principle that is very critical, I believe. I also think that it's important that more is done to require legal professionals to encourage clients to use alternative ways to resolve disputes. I think that is always something that we should seek to achieve, and I know that this legislation certainly has those things amongst its objectives, Mr. Speaker, and I certainly, although I don't have the occasion to do that often with this government, unfortunately, I do laud the government for its efforts in trying to achieve those goals. I'm still not certain that it actually, this piece of legislation will actually achieve the goals that are set out by it. Certainly, there are some questions that I and others on this side of the House do have that remain that I think need to be addressed. There are some concerns I think need to be addressed, and I do want to see this bill go to committee to have the opportunity for those concerns and those issues and those questions to be addressed, and I'm hopeful that they can be. And I guess I'll just maybe point to a few articles. I noted that my colleague who spoke before me had sort of read from one of those articles herself, but there is a few articles that I had noted, and I'm just going to read very brief little passages from a couple of them that sort of, I guess, pan this bill somewhat. The first one is an article that is entitled How the New Bill C-78 Affects Custody and Access Rulings, and it says just in a couple of spots, really briefly, Mr. Speaker. First of all, it says, on its face, this bill is an expression by the federal government that progress was needed in the way that separated families were treated under the law. And I would certainly agree with that. Now, it goes on to say, though, and I quote here again, however, much of what is being proposed has already been implemented in out-of-court settlements as well as in decisions made by judges. The second article is what's in a name, Divorce Act Amendment, not enough to reduce parental conflict. Now, I won't read any passages from the articles because I do think that title speaks for itself in terms of some of the concerns that would be addressed in that article, and given the short time, I won't read from it. Also, this is the article that my colleague had also read from. I have some different parts of that article that I had wanted to read, Mr. Speaker, and it's entitled Bill C-78 Amendments to the Divorce Act, and it in quotes, rearranging the deck chairs. Now, from that article, there's just a few little spots I'd like to read. First, it says, the author suggests, and someone who has vast experience in family law in my province of Alberta, he goes on to say, I would go further and suggest most of Bill C-78 is an expression of good intention without sufficient substance to accomplish real change. Now, that is quite a typical statement that can be made about many of the initiatives of this government. Often they tend to focus on symbolism and talking points and these kinds of things, rather than really actually accomplishing anything that would really achieve those kinds of objectives that they often speak about. I'm not going to say that that's necessarily the case. The author of this article certainly is positing that, though, Mr. Speaker. And also the author goes on to say, also noted that is that Bill C-78 is 190 pages long. The current Divorce Act is only 41 pages long. As self-represented litigants now comprise 80% of the parties before any courts, one might reasonably ask how they will navigate through legislation that is over 4 times longer than the previous version, which was already difficult for a non-lawyer to digest. So my take, Bill C-78 is a huge new ship with some very nice-looking aesthetic additions, but with too few lifeboats. And the iceberg is still coming. That's the comments of the author of that article. So obviously there may be some things we need to look at here, some things that may need to be addressed with this piece of legislation. But as I've already stated, Mr. Speaker, I do believe that the objectives that are trying to be achieved here are laudable, and I certainly hope that this bill will actually be found to address those, or can be amended or changed in ways that would make sure that it would do just that, because I think it is something that does need to be done. I think it is something that is important. I certainly have discovered during my time as both a member of Parliament and, as I mentioned, in the time around my experience with the family law with my son, that ultimately worked out positively in my situation. There was far too many parents, mainly fathers, and grandparents whose children and grandchildren were being deprived of time with them, Mr. Speaker, and that needs to be fixed. And that's part of the reason why I'm so proud to be a part of the Conservative Party of Canada that has the following policy regarding shared parenting. And I'll read the policy into the record, Mr. Speaker. The Conservative Party believes that in the event of a marital breakdown, the Divorce Act should grant joint custody and or shared parenting unless it is clearly demonstrated not to be in the best interest of the child. Both parents and all grandparents should be allowed to maintain a meaningful relationship with their children and grandchildren unless it is demonstrated not to be in the best interest of the child. That's a very important principle, and one that I fully support and believe in, and one that I think we should be seeking to achieve here. I guess I'll just tell a brief personal story, Mr. Speaker. I was a child of divorce as well. My parents divorced when I was about 12 years old. And I've got 2 brothers. I spent some time after my parents' divorce living with each of my parents, and actually both of my brothers did the same at different times. And the key thing is that my parents, although as in most divorces, I suppose, certainly didn't get along very well, and I would say to this day probably don't get along very well. They were able to put aside those differences when it came to their children and tried to do what was right to make sure that their children were able to maintain a strong, positive relationship with both parents, and that even though at times my brothers and I did not live in the same house, in fact lived in cities that were an hour apart, made sure that we had the opportunity to continue to have very strong relationships as siblings. And I would say today that I maintain that with my brothers, with both my parents, and that was important, but it's not a common enough story. And that's why these changes are so important, and why it's important that this bill is done in the right way. And it's not about just symbolism, that it is actually going to accomplish the objectives. And so I certainly hope that after examination in committee and that after any amendments that might be required, Mr. Speaker, that it is shown to me that this will be possible through this piece of legislation for more children and for more families to be able to achieve that goal of ensuring that relationship remains with both parents and with all the children of the relationship. And if that is, in fact, able to be the case following that examination and the completion of that, I would certainly be happy to support this piece of legislation if that was to prove to be the case. So thank you, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for Parkdale Hyde Park.
Mr. Speaker, I thank the member from Banff Airdrie for his comments in this chamber, and I congratulate him on I applaud his candor and his honesty with the chamber in terms of sharing his own personal background and experience, and also applaud him for having raised a very fine son in what was likely difficult circumstances when he was younger. What I would actually point out in my comment and my question to him is that I would find, with all due respect, that there's a bit of an inconsistency, because some of the members' comments were that this is a symbolic piece of legislation and there isn't enough policy substance to it. But at the same time, he also said that it's an overly dense piece of legislation that is 4 times longer than the current act. I would put it to the House, Mr. Speaker, that you can't have it actually both ways. It's either one or the other. It's either too dense because it's too policy-rich, or it's not dense enough and it's only symbolic. And what I would say to him is that it is actually dense in terms of policy, and I'd point out to him a few because I think they highlight exactly what he's driving at. There are measures in this bill that address keeping people out of court in terms of calculating income support and also recalculating income support. There are measures in this bill that specifically deal with information sharing between different departments in government, particularly the CRA, that allow people to calculate benefits better and more quickly and with more open disclosure. And there are substantive aspects of this bill that define family violence and force judges to take that into consideration when they're making determinations. So I'd put it to the member opposite. Are those not the very type of substantive policy changes that he would like to see, that many parliamentarians, many Canadians would like to see, to advance the issue of family law and address the best interests of the child at bottom line? Thank you.
The honourable member for Banff Airdrie.
Well, I appreciate the question. I will disagree with the statement that was made by the member that something cannot be lengthy and wordy and yet not have a great deal of substance. That would be a typical kind of a typical comment of a type of a person in a legal profession to make, because certainly something can be wordy and complicated without actually accomplishing significant objectives. I'm not saying that that's the case in this situation. I simply was reiterating the comments of a number of individuals who were commenting on this piece of legislation. I'm hopeful, because I will admit this is a lengthy piece of legislation. I have not had the chance to fully review the legislation myself at this point. I have looked at it briefly. I have read summaries. I have read commentary on it. And I hope to have that chance to do that. I mean, as we all have different responsibilities in this House, one of the pieces of legislation that this government brought forward around the same time was one that, in my critic role, I was dealing with quite substantially and therefore had the chance to, review this lengthy piece of legislation in great detail. But I am hopeful that through the process in committee, that some of these concerns that I have read that others have shared will be addressed, and that it can be found that either this bill does accomplish some of the things that it claims to want to achieve, or that it can be amended in such a way that it would actually achieve those things. Because I do think they are very important goals, and I certainly hope that the government is as sincere as I am about wanting to see that happen, and if it is found that their legislation is failing to accomplish what it seeks to achieve, that they will be open to the amendments that are necessary, and that they will actually try to make sure this goes beyond the idea of symbolism, that it goes beyond the idea of sort of superficially addressing something and actually concretely achieves the objectives that it sets out to achieve. That is my hope. I hope that is the hope of all members of Parliament in this place, and I hope it can be done, Mr. Speaker.
Questions et commentaires, questions and comments. The honourable member for Skeena Bulkley Valley, 30-second question with a 30-second answer, please.
Oh boy, I like a challenge, Chair. I guess a very quick question to my friend. I know we all share a common interest in this House in protecting children, particularly children who are exposed to domestic violence. Children born into families through no fault of their own, and then experiencing things that we know can have a generational impact. Succeeding generations feel those effects. That if this bill, C-78, which we broadly support, is able to take into account the effects of domestic violence on children during divorce proceedings, more clearly define the varying degrees of domestic violence to ascertain what the ruling should be in the end in custody and other decisions that the court makes. Would this not be a step forward in battling something that I'm sure we all agree is entirely one of the most difficult and reprehensible things that exists still far too much in our society?
The honourable member for Banff Airdrie.
Well, I would certainly be able to say very clearly that domestic violence is one of the most hideous forms of violence that we can see in a society. And if piece of legislation is seeking to address that and trying to deal with that in a way that ensures the safety of all involved, and particularly the children, that is important. I think it's always important to try to make sure that the opportunity is given for children to maintain that relationship with parents, with grandparents and others. But certainly, I think it does need to address the issue of domestic violence, and I certainly would agree that that is an important principle that needs to be considered in anything that's done here in this regard.
Resuming debate, reprise du débat, l'honorable député de Beauport.
The honourable member for Beauport, Côte de Beaupré, Île d'Orléans, Charlevoix. Thank you very much, Mr. Speaker. That's quite a long name for a riding, isn't it? I'd like to begin by saying that I will be sharing my time with the member for Barrie Innisfield. I myself have been divorced now for about 27 years. I'm a proud single mother of 2 children, 2 girls who are about 30 years old and 29 years old. And I know, therefore, how obsolete divorce legislation is and has been for many, many years. It's been too long since we have reviewed that legislation. So it gives me great pleasure to rise today and speak to Bill C-78 on the modernization of the Divorce Act. The Conservative Party has been and always will be the party that wants to improve all areas of our justice system and to put people who are suffering at the very center of our thoughts on how to improve their situations, adults and children. Bill C-78 amends the Divorce Act, the Family Orders and Agreements Enforcement Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act. And in this case, we're talking about child support, and to make consequential amendments to another act. I am a member from the province of Quebec, and therefore I know how quickly over the past 40 years separation and divorce have been increasing, and therefore it is so important that our legislation be revisited and revised so that we do not add to the already huge burden that parents face in terms of litigation, and this litigation can be very emotional. This review of Bill C-78 focuses on replacing terminology on custody and access, and it changes that terminology to emphasize more the role of parents and parenting. It also provides a list of criteria for the best interests of the child, and it creates obligations on the parts of parties and legal and lawyers to encourage the use of dispute resolution outside the courts in order to help the courts deal with family violence, for example. And it also establishes a system for relocating children and processes with respect to child support. Now, when one wants to improve aspects of a bill, it is very, very important to want to reach the goals set out. In this case, it is absolutely critical that the interests of the child be put at the top of the list by strengthening and focusing on the importance of making that interest of the child an absolute priority when any parenting decisions are made. Unfortunately, all too often, children are used as scapegoats in separation litigation, and the children or child end up suffering even more and suffer from the after effects of that throughout their lives. This bill must also tackle family violence by making courts that are dealing with violence to take into account the seriousness and the impact on the child and on any future parenting arrangements. Currently, oftentimes this situation is dealt with outside the separation litigation, and that work should be done at the same time. It is also important that this bill aim to reduce poverty amongst children by providing more tools for child support for children and more tools to ensure that child support orders are followed. Currently, when the parent that is responsible for the support does not pay that support, parents once again end up using the legal system and clogging the legal system because they have to go before the court to enforce this and to prove that the child is not receiving that support. And that uses up money that does not serve the child. What is really unfortunate, or rather what is important, is to make sure that the family justice system is more accessible and more efficient. We have to simplify the various definitions and processes in order to make the system more flexible and in order to provide more flexibility to provincial services to be able to review child support and reduce the burden on the courts by allowing provincial administrative agencies responsible for child support to implement some orders that are now up to the courts to implement and apply. The Conservative Party works and has always worked in the interests of victims and their families, and therefore that we believe in the case of a breakup, the Divorce Act should allow for shared custody or shared parenting unless it is shown that that is not in the best interests of the child. Both parents and all grandparents should be able to maintain close and serious relationships with their children and grandchildren unless it is shown that that is not in the best interests of the child, of course. Now, this all has financial impacts as well. And when the government enhanced and enlarged the Unified Family Courts, it also stated that this would cost $77.2 million over 4 years, starting in 2019, 2020, and $20.8 million a year after that, in order to create 39 positions for judges in Alberta, Ontario, Nova Scotia, Newfoundland, and Labrador. Federal legislation for family law has not been updated in 20 years. And according to the 2016 census, more than 2 million children live within separated or divorced families. That is a very high number. 5 million Canadians have separated or divorced between 1991 and 2011. Out of that number, 38% involved a child at the time of their separation or divorce. 1.16 million children of separated or divorced parents live in a single parent home, and 1.02 million children live in a step family. Single-parent families, especially those with a woman at the head of the family, like myself for a long time, are more likely to live in poverty than two-parent families, and that is very true. Studies have shown that child support is a key factor for lifting families out of poverty after a separation or a divorce. Mr. Speaker, when a single family does not receive child support, it is very, very difficult, especially if that one person is making $12, $13, or $14 an hour. it's very difficult to feed your children on that kind of income. Young children need a lot of protein. They eat a lot because they're growing. And boys apparently eat more than girls. I only had girls, so I can't necessarily speak to that. But we have to take all this into consideration, and we have to focus on single-parent families. And we have to make sure that in a bill like this one, the child is at the center of that bill. The well-being of the child is at the center of that bill. More and more people end up being impoverished after a separation or a divorce. In the budget 2018, the Liberals announced that they would work to improve unified family courts. And Liberals must keep that promise and not play politics with such sad and heart-wrenching cases that have long-lasting impacts. So with that promise and the purposes of the bill in mind, I would like to say that I support the intention and the goals of the bill, which are to protect the higher interests of the child and tackle family violence. Thank you, Mr. Speaker. Questions and comments? The Honourable Member for Parkdale Hyde Park. Thank you, Mr. Speaker, and I appreciate the remarks of the member for Beauport. And I appreciate the fact that she spoke so openly about her own personal experience. I'd just like to bring up 3 other numbers about the poverty of women and children, because this was raised by the member opposite. We know that in most cases, 96% of cases, men are the ones paying the child support to a woman. We also know that 1 year ago, 60% of cases for child support orders were in arrears. And these arrears involve millions of dollars. And I'd like to know if the member opposite has anything to say about these kinds of numbers and how we can address and improve this situation in terms of lifting children and women out of poverty in Canada. The Honourable Member for Beauport, Côte-de-Beaupré, Île d'Orléans, Charlevoix. Thank you very much, Mr. Speaker, and I'd like to thank my colleague opposite for his question. Many numbers have been quoted, and I agree that someone has to pay the person receiving support, but there have to be incentives. And I think Bill 78 on the whole is a pretty good bill. However, there's a bit of a contradiction, and I'd like to know if my colleague sees this contradiction. So there's much talk about children in the context of Bill C-78, and that child is being put front and center. But I'm going to raise another bill that runs counter to Bill C-78, and that's Bill C-75, that proposes to decrease sentences for serious crimes, for example, abduction of a child under 14 or 16 years old. So when a bill on divorce is brought forward like this, one also has to keep in mind that in some cases there are serious cases of violence occurring. We've seen this everywhere. We've seen Dr. Turcotte, for example, in Quebec. So I'd like to know how you can bring forward a bill like C-78 that puts the higher interests of the child at the center of it, and then on the other hand come forward with Bill C-75 that decreases sentences for people who are using violence against children. Questions and comments. The Honourable Member for Jonquière. Thank you, Mr. Speaker. I myself have 2 wonderful boys. And I can confirm to her that, yes, boys eat more than girls. We could always check our experience against each other's. Now, laughing aside, this is a very important topic. I had 2 children out of a common law relationship, and so I'm concerned by this bill as well. Here's what I'd like to know from my colleague. So I'd like to know, once this bill goes to committee, if there should be more protection inserted in there for common law children, because more and more common law relationships lead to having children, and therefore the parents are not married. So I'd like to know what my colleague thinks about that. Thank you, Mr. Speaker. The Honourable Member for Beauport, Côte-de-Beaupré, Île d'Orléans, Charlevoix. Thank you very much, Mr. Speaker. And yes, that is true. And I'd like to thank my colleague for raising this. My child also has a child herself out of a common law relationship. I think this bill does reflect the reality of Canadian couples. Now, in Quebec, there are more and more common law relationships. There is a lot of marriage, but there are more and more common law relationships, and the children from those relationships have to be protected. Oftentimes, these children have lesser protection, and in Bill C-78, there's an attempt to protect children. And if we want to protect children, from my perspective, then yes, absolutely, that should include children out of a common law relationship. Children are children. They're Canadians. They have to be protected. Resuming debate.
The Honourable Member for Barrie Innisfil.
Thank you, Mr. Speaker, and I want to thank my honourable colleague for sharing her time with me today to speak on this very important topic. I will be taking a different perspective. I have no legal training, no legal background. I've been happily married for 29 years now to my beautiful wife, Leanne. But having worked in the emergency services as a firefighter in my previous life, I was certainly witness to a high propensity of divorce situations within the emergency services. Now, there's lots of reasons why that happens, Mr. Speaker, but suffice to say that I saw the effects firsthand of divorce on many of my colleagues, many of my friends, not just in the fire services, but the police services, and all emergency services for that matter. And so, in particular, Bill C-78 is a very timely bill in the sense that it brings into line and modernizes and, in fact, codifies a lot of case law that's gone on, that many of the divorce cases have been dealt with over the course of the last several decades. And so there's a lot to be supportive of. But when you look at divorce in this country and you see just the extent of the divorce, if you look at the 2016 census, Mr. Speaker, over 2 million children were living in separated or divorced families. 5 million Canadians separated or divorced between 1991 and 2011. And of those, 38% had a child together at the time of their separation or divorce. So this, in effect, affects over a third of Canadian population children of those who are part of a divorce situation. And 1.16 million children of separated or divorced parents were living in a lone parent family. And another 1.02 million children were living in step families. And those were the statistics as they relate to the 2016 census. Now, I will also be taking another perspective, and if you'll indulge me, Mr. Speaker, later on I will be reading into the record, because I have had meetings with several of my constituents, and of course I'm here to represent my constituents, on the implications and the impact of Bill C-78. And I've received several letters, but there's one letter in particular that I am going to read into the record. And the hope is that when this bill does go to committee, that there will be reflection on what people across this country would like to see, changes to this piece of legislation. Now, as I said earlier, there is a lot to support, and it's a rather robust piece of legislation. There's 190 pages that are involved with Bill C-78, and when you contrast that to the Divorce Act, for example, having 41 pages, there's a lot to consider and a lot to reflect on within this piece of legislation. Some things, as I said, to support, some things that need to be changed when we get to committee. And so, obviously, the reduction in delays of the justice system will save costs. That's another thing, Mr. Speaker, that I've witnessed over my years in the emergency service, just the devastating impact that this can have on families, the cost, not just to the fathers, but also to the mothers as well, and the impacts, of course, that it can have on the family. So what is it that C-78 is attempting to do? This was tabled, as you are aware, Mr. Speaker, on May 22nd, 2018, and it amends the Divorce Act to, among other things, replace terminology related to custody and access with terminology related to parenting. Again, a simple modification, but it does reflect the modern times. It establishes non-exhaustive list criteria with respect to the best interest of the child. There's none of us within this House of Commons or this Parliament, or quite frankly right across the country, that aren't interested in the best interest of the child. It creates duties for parties and legal advisors to encourage the use of family dispute resolution processes. And as I said before, Mr. Speaker, the cost associated with this divorce is debilitating for many, and for some parents, just simply can't recover from those costs. And so there are things to like about this piece of legislation. As I said, it modernizes it. But more importantly, as we get it to committee, we will get to hear from stakeholders. Now, as I said earlier, I did want to read into the record a letter that I received from Mr. Andrew Corbett, a constituent of mine, and he is part of a Simcoe County group, a support group called Fathers Equal Parenting. And he wrote me a letter, and this is a letter that was subsequent to a meeting that we had in our constituency office in Barrie Innisfil, and it provides a different perspective, a different context. Of course, we're debating today, Mr. Speaker, Bill C-78, and the government has proposed this legislation, but it's also important, I believe, and I think you'll agree with me, Mr. Speaker, that to find those contrasting views, those things that can help parents across the country. And so it says, as one of your constituents, I'm writing to express my concerns about child custody legislation and the recent Bill C-78. Bill C-78 fails to give sufficient credence to the views of the vast majority of Canadians who support rebuttable presumption for equal shared parenting when it comes to child custody law. Although there may be some plausible positive measures in the new government's initiative, Bill C-78, there are a number of serious deficits in the proposed reform of child custody legislation. Notwithstanding, I believe that there are tenable solutions to significantly improve C-78. And this is what Andrew writes as I read further. Canadians overwhelmingly support equal shared parenting. In recent polls, nearly 80% support equal shared parenting countrywide. Moreover, many countries have adopted shared parenting or have endorsed shared parenting and are proposing legislative changes. Furthermore, social science research and literature has strongly come in favor of shared parenting, concluding that children in these relationships have superior academic, emotional, social, and economic futures with drastically lower incidences of substance abuse, crime, and incarceration. In view of the changes in social norms and family structures in the intervening 33 years since the current Divorce Act was passed, our child custody legal system requires fundamental structural changes. And while the government initiative with Bill C-78 should be commended for its housekeeping changes, we really need to make lives better for a number of amendments to Bill C-78. I ask that you advocate for legislative change that incorporates accepted social science, research findings, and consistently expressed views of the Canadian public. A rebuttable presumption in favor of equal shared parenting is the appropriate course of action in light of the research and consistent polling data over many years. In other words, about 80% in favor. Interest groups, including the Bar Association and other interest groups, will surely oppose, but in summary, the following points need to be incorporated in this bill. Canada needs a rebuttable presumption of equal shared parenting. This principle should be the starting point for the best interest of child deliberations. Adopt continuity of family relationships as the definition basis for the best interests of the child standard. Amend proposed relocation clauses to place the onus on the relocating parent for changes in parenting responsibilities and arrangements. Include arbitration as an explicit component of dispute resolution options, and include provisions for parental coordination to mediate and, if necessary, to break deadlock situations in a day-to-day implementation of a parenting order. Now, on paper, Andrew goes on to say the proposed Bill C-78 seems to support some admirable measures, but I ask again that you advocate for less adversarial family justice systems with implementation of the following: further implementation of the Unified Family Court, support for alternative and non-adversarial dispute resolution, expansion of such programs as 393 Mediate, where free, low-cost mediation is provided with the courts, and increased legal aid funding. Wider access to justice in the family system is essential. And so, in conclusion, Andrew wrote to me that a rebuttable presumption in favor of equal share parenting will set the stage for equality and serve to reduce conflicts stemming from unwarranted senses of entitlement, reduce excess in legal expenses, thus allocating family finances for the needs of the family and the children, and promote the best interests of Canadian children to enjoy a decent relationship with both parents. Many like-minded Canadians support these changes, and so he thanks me for reading the letter. I will submit this into the record, Mr. Speaker. I've asked Mr. Corbett to come to committee once this bill does pass through the House of Commons so that he can testify and submit his own view on where Bill C-78 needs to be approved. There are many people who believe that C-78 is a good piece of legislation, but there are some amendments that could provide a better, solid piece of legislation that's in the best interests of Canadian children and their families. Thank you, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And you know, the Government of Canada over the last few years has taken different, and I would suggest to you, a very progressive approach at trying to provide support for children in Canada. One of those would have been, for example, the Canada Benefit Program, literally lifting thousands of children out of poverty. This legislation ultimately will assist children by seeing the parent that has custody have a greater likelihood of success in terms of receiving the monies that are necessary in order to help bring up that child. And that's one of the reasons why I believe, Mr. Speaker, you know, as a government, we've taken a holistic approach at lifting children, in particular, out of poverty. I've mentioned a budgetary measure. Today, we're debating a legislative measure. And I would ask my colleague from across the way, would he too not agree that through legislation and government policy, that the governments can, in fact, have a positive outcome for our children, and that's one of the reasons why it's important that we proceed with this legislation.
Well, member for Barrie Innisfil.
Thank you, Mr. Speaker. And there's no argument to a question like that. And I think throughout the history and course of our country, it's been the responsibility of all governments to look after our children, to make sure that we have a safe and secure environment for not only them, but families, understanding that we need to make sure that there's a responsibility on the part of parents to be looking after their children. Not all that responsibility lies on the part of government. At least that's a fundamental belief that I have. I mean, we need to encourage parents to accept the responsibility of parenthood. And but I will say that in contrast to that, there's some difficulties, and there is some hypocrisy on the part of the government, specifically as it relates to Bill C-75, where they've made some changes that directly impact crimes against children. And so I don't want to get into the weeds on C-75, but absolutely governments across this country throughout the course of the history of this country always believe in the rights of children, making sure we have a safe and secure environment for children and families as well. Thank you, Mr. Speaker.
Questions et commentaires. Questions and comments. L'honorable député de Beauport.
The honourable member for Beauport-Limoilou.
Innisfil has stated, we generally support the bill, and we'll see what happens in committee during the hearings and the reading of the different articles. But I noticed while reading the bill that there is an amendment to the Divorce Act proposing to put an obligation on the two spouses who go through the divorce to consult a lawyer in an obligation way. So I was wondering, some couples, and I know some friends, have been through divorce, and it was perfectly positive. There was no huge discussion, no fears or fight or whatsoever about how everything can go bad while there is a divorce. So, is it really necessary to have this amendment which would force and put the obligation to consult a lawyer and to spend money when it's not required?
The honourable member for Barrie Innisfil.
Thank you, Mr. Speaker, and I thank my honourable colleague for that question. I think when you look at a situation of divorce, it's traumatic enough of an experience for parents and children, the whole family unit for that matter, when they go through this situation. And for many parents, and I can speak to this directly, based again, as I said earlier, my experience in the emergency services and seeing parents go through this, colleagues and friends that have gone through this. The financial implications of this are sometimes so onerous that it's difficult for those individuals to recover, both the husband and the wife. And so to include lawyers and not have a potential dispute mechanism as people go through divorce that eases that financial burden, especially in a situation, and there are situations where, the couple, it's an amicable divorce. They agree that, they're not going to remain married, and they decide that in the best interest of the child that they're going to go through this amicably. So in those situations, obviously involving a lawyer could potentially set that couple down a path, first and foremost, of financial difficulty, but it could also stir up some other emotions because divorce is a very emotive thing. Thank you, Mr. Speaker.
Reprise du débat, resuming debate. The honourable member for Vancouver East.
Thank you very much, Mr. Speaker, and I rise to enter into debate Bill C-78, an act to amend the Divorce Act, the Family Orders and Amendment Agreements Enforcement Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act, and to make consequential amendments to another act. Quite a title, Mr. Speaker, for Bill C-78. So for the purposes of this discussion, I'll simply refer to this bill as Bill C-78. In essence, what are we talking about? We're talking about a situation where there's a family breakdown. Really, that's what it is. And under no circumstances can we imagine that could ever be a positive thing for anybody, for any of the parties involved. But that said, sometimes making that hard decision, going down that difficult path may very well be the best thing. And sometimes in those circumstances, it may well be the best thing and in the best interest of the child as well. Now, that said, when you have a disagreement, when you have a breakdown, often people's emotions are very high, and understandably, right? When you come from a place where you come from marriage generally happens as a result with people declaring their love for each other. And imagine for a moment when that breaks down, what that means, and the anger, the hurt, all of those emotions come flooding back, the sadness that go with it. And so it is very, very difficult in the best of circumstances, but sometimes that's a process adults would have to embark on. Now, there were members in this House who talked about their own personal experiences. Sadly for me, and I think for many people, I'm one of those statistics as well. I too am a single mom, right, with 2 children. And so it's not an easy path, but sometimes it is the path to which we have to take. So with that said, I applaud this piece of legislation. I welcome this piece of legislation. Why? Because it attempts to make the process a little bit easier, a little bit better, and most important of all, with the best interests of the child at heart. Now, that's not to say Bill C-78 will do all of it and will fix everything, and that there aren't issues with it, to which I assume when it gets to committee stage, there will be opportunities for witnesses to come before the committee and offer their thoughts, and then amendments, if required, would be tabled, and hopefully that those changes could be made in a nonpartisan way, in the best interest of the child at heart. And so with that, I'd like to focus on a couple of aspects of the bill that I think is important and I think worthy of support. One of the issues, and I come from a community, Vancouver East, where, generally speaking, we're not affluent people. People in my community tend to be lower income, middle income people, and when you enter into a situation where you have to get into a divorce, a lot of the times, and particularly women, I would say, often don't have the necessary resource to fight that fight, to get to court, to have the custody battle to be dealt with. And this bill attempts to bring forward a more amicable way, a less onerous way in achieving I hope, the same result that one would want to see, and that is to ensure that the caring of the child, the spending of the time of the child would be divided or would be provided with both parents. And that is of paramount importance. And so the bill proposes that whoever wants to initiate this process would be required to get a certification agreement with the other individual that they have attempted and exhausted all the other avenues in resolution of that dispute before it goes to court. So that is to say, if you can get resolution, then you don't have to go to court. And that, I would think, is not only in the best interest of the child, I think that is also in the best interest of the two adults involved in that situation. Dispute resolution, I think at all times is a good thing, whether it be in other circumstances, in different arenas. If there is a way to not really go to court, to fight the battle and be so angry and so, what is the word, just to be so pessimistic, really, about the procedure, and then to be so sometimes litigious about it, right? If there's a way to try and resolve this in a more amicable way, I think that would be in the best interest of everyone involved. And of course, from the government side, from the taxpayer side, this would be important as well because it actually reduces the cost for the courts and the court system, and that too is a positive outcome, I would think. So from that perspective, I think that element of the bill is absolutely worthy of support and to move towards an alternative dispute resolution process. Now, the bill also recognizes, and I think this is of significant importance as well, that in the situation where domestic violence is involved, and in those instances, this bill requires the court to take that issue into consideration, and especially with respect to the interests of the child, and that is to say, when it comes to the custody of the child, there might be moments that it is in the best interest of the child and for that child to only be under the guardianship of one parent. And that might be a requirement. And that is for the courts to decide, but however, making it explicit to say that that needs to be dealt with in the best interest of the child, I think is an important component as well. So often we see these situations where there is a marriage breakdown that you see the children get caught in the crossfire. I have met lawyers who've told me who do family law, and they tell me that the most heartbreaking aspect of their job, the most difficult part of their job is, in fact, to have to see these cases and see the sadness and the tragedies that could fall out of it because of the tensions that exist, because of the animosities that exist, and often it is the child or the children who end up actually really getting hurt. And often the adults, they may not even be thinking about the fact that they are hurting their children, but sometimes they are so caught up in the situation that they're blinded by it and they can't see it. And that is a tragedy. And so for the bill to allow for a provision for the courts to ensure that actions taken would be in the best interest of the child, I think is absolutely worthy of support. The bill gives a tool to the parties to ensure that child maintenance is calculated accurately and is provided accurately. One would think and automatically assume, right, that in the event of a breakdown of a marriage and where children are involved, that you would want to ensure that those children are supported, right, and that they have the best opportunities to succeed and that their needs are met. But yet, it doesn't always happen that way for, I say sad reasons, really, but sometimes it doesn't always happen that way, and that child support is not there, that maintenance is not there, and especially from the partner who can actually afford to do so. I don't know why people do that, but sometimes that is what happens. And this bill gives that tool to ensure that ensure that you give the accurate calculation towards that maintenance contribution for the child in the best interest of the child. And I think that, too, is a positive outcome. In British Columbia, where I come from, for a very long time, people on income assistance particularly, single parents, and usually is a single mom, would have a really difficult time getting maintenance pay. It would just be so awful for them to try and get that. And the income assistance system requires them to report the access, the possible access to maintenance. And, you know, for a long time in British Columbia, we actually had a situation where it is incumbent on usually that single mom to pursue that maintenance payment. And then when they get it, that maintenance payment is actually clawed back from their income assistance payment. So, you know, it's as though that money received from their ex-spouse or ex-partner would be contributed towards the support of the children, but in reality, at the end, it wasn't, because that money was clawed back by government. Now, I'm glad to say that that law has now been changed, and that's a positive thing. And so making sure that in that process, the maintenance component is achieved in a fair way, and to ensure that those dollars go to support the child or the children, I think is of paramount importance. And this bill aims to do that, gives it the tools to achieve that outcome, and I do think that that's a laudable goal and something that I would absolutely support. Now, Mr. Speaker, the bill talks about there are some gaps, though, within the bill, and those are the areas to which concerns me. I think has already been brought forward by other members in their debate, and that is to say, for people who are in a common law situation, and particularly, for example, in Quebec, for people who are in a common law situation, this bill would not apply to them. And so I do wonder, from for the government side, how do we ensure that this bill and the intention of this bill, and that is to act in the best interest of the child or the children in the event of a divorce or marriage breakdown, how would that apply for all the children in Canada, including Quebec, in those circumstances? I think that's worthy of looking into. I understand and fully accept that Quebec has a different system than we do in the rest of the provinces and territories. But with that said, there is a gap, and I think that gap is worth looking into to see if there's a way to address that. The bill, Mr. Speaker, provides for what the government say, reducing child poverty. Now, on the face of it, I would say that when you're able to reduce the cost of these kinds of court procedures, that's in the best interest of everyone. I would say that when you ensure that maintenance and accurate and fair maintenance is determined in the case of a marriage breakdown or divorce, that would support families, and particularly for those who are low-income families and sometimes have a tough time in ensuring that fair maintenance is provided for. I suppose that contributes to it. But I do hope, though, that that's not the only thing to which we rely on in reducing child poverty. One of the things that when I think back in this place, and I'm a new MP really, as a first-time MP in this chamber, I look back in history, and it was back in the day when Ed Broadbent was an MP, and that was very, very many years ago, and he actually passed a motion, a bill in this House, a motion in this House, and it was unanimously passed by every single member of this House to say that we need to end child poverty. But yet to this day, we still don't have a national strategy to get there. And I just wonder, why is that? So we have one piece here in the government. I'm sure government members will get up and say, but we're doing this, we're doing that. It is all fantastic and wonderful. But not really. Those are all little patchwork pieces coming in play. Just like Bill C-78 contributes to that, but it's also just a patchwork piece towards that. How about if we actually bring forward a national strategy to end child poverty, a comprehensive approach that looks at all the different approaches to which we can achieve that goal? Wouldn't that be in the best interest of a child? When we would actually be able to realize the words and the intention of this very chamber when Ed Broadbent brought forward his motion so many years ago that received unanimous consent. That would be a positive way forward, and I would hope that we can achieve that. That would be a significant piece towards child poverty. The other thing that would be a significant piece towards child poverty, Mr. Speaker, of course, would be the provision of affordable housing. And many people have a tough time accessing affordable housing. Where I come from in Vancouver, it is almost impossible to get affordable housing, access to safe, secure, affordable housing. Now, I know the government will say that they have put forward a national strategy towards affordable housing strategy. But the problem with that, too, is that 90% of that money won't flow until after the next election. So it's not like as if people can say, well, gee, I'm homeless today, but let me just wait for, a year. It's a year now. When they first introduced it was 2 years ago. But let me just sort of sleep under this alcove and feel really good about it until about 2 years from now when the money will flow. And by the way, when the money actually flows, having come from the nonprofit sector, it often takes 3-4 years to get a project built in minimum. Right? So that's another 5, 6, 7 years away before someone actually gets access to housing. And I would say that access to housing would be a significant component towards the fight against poverty, would be a significant component towards that. And wouldn't it be great in budget 2019 for the government to say that, you know what, we will actually flow this money right now because the crisis is right before us right now. All of that will contribute to this equation. Some of the women that I've met in my community in Vancouver East, sometimes, especially for women, and it's just heartbreaking, who are faced with a domestic dispute violence, and they don't feel that they have an option. They don't feel that they have an option to walk away from that relationship because they can't access housing, because they have no other means to support themselves. So this bill, while it aims to provide some support towards that, but you have to look deeper than that, and that is to say that you need to make sure that women and families also have the options of walking away from that relationship, and that is to ensure that they have some resources and some support in securing housing. That is an absolute equation, important component to that equation. I've met women who've actually said to me they can't secure affordable housing. They now have to go back to that abusive relationship. And that can't be the way forward, and that's definitely not in the best interest of a child. So I would like for us to look at this issue in a more comprehensive way. Mr. Speaker, I support this bill, absolutely, and I expect that at committee there will be further discussion about it. Witnesses will provide testimony towards this bill and their comments toward it, and if there are amendments to come forward, I hope that all parties will work together to bring forward these amendments in the best interest of the child, and then beyond that, I hope that the government will bring forward other components to make a difference in the lives of children, especially those who are struggling today and those who ought to be and should always be in the eyes of parliamentarians when we take action to be acting in their best interest as well. Thank you very much, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for Parkdale High Park.
I thank the member from Vancouver East for her contribution in this most recent speech and her contributions earlier today. In terms of what she identified as a couple of gaps in the bill, I would just, through you, Mr. Speaker, inform the House that the jurisdiction of it is the exclusive jurisdiction of provinces and territories over unmarried couples, including common law couples. So that is a provincial and territorial matter. The member earlier raised, in terms of debate earlier today, the issue of enforcement, and the enforcement tools are indeed strengthened through this legislation. And one principal and critical way is through the Family Orders and Enforcement Assistance Act, by enabling the government to do exactly what many members opposite have called on us to do, which is ensure that departments are collaborating and sharing information, including sensitive Canada Revenue Agency information can be shared under certain parameters and with certain conditions to ensure that enforcement of support orders are being made. What I wanted to ask the member opposite, and I know her from work over the past 3 years, and I know her to be a passionate advocate about two issues. One is multiculturalism, and two is Indigenous reconciliation. And what I would point out is that in this legislation, it is entrenching for the first time in the legislation an explicit requirement for courts to consider a child's linguistic, cultural, and spiritual heritage and upbringing, including their Indigenous heritage, when making decisions about parenting arrangements for the child. That is explicitly part of the best interest analysis that now must be undertaken. If I could have the member from Vancouver East offer her comments on what that will do to advance both cultural identity, including multiculturalism, and also Indigenous reconciliation. Thank you.
The honourable member for Vancouver East.
Thank you very much, Mr. Speaker, and I thank the Parliamentary Secretary for both his comments and as well as his work. I've worked with him in different capacities, formerly as the Parliamentary Secretary to Immigration, Refugee and Citizenship, and then multiculturalism, and now in this capacity. And I look forward to continue to working with him to advance different causes that would be important for all of our communities. On the question around linguistic and cultural recognition, and particularly for Indigenous children and families, absolutely I would support that. You know, this is Canada's shame and history, I have to say, with the residential school history, with the 60s scoop, where the interests of the child and the interests of Indigenous peoples, the Inuit and Métis community were not taken into consideration at all. In fact, if anything, Canada's history has been to try and decimate and really exercise genocide toward those communities. So in this bill, there's one small piece within that, and I think that is a welcome component. But again, I hope that we don't stop there, because there's much work to be done to walk the path of reconciliation, given the impact of colonialism and the intergenerational and the generational impacts. Lastly, I just want to make a quick comment with respect to the issue around child poverty. And by the way, when Ed Broadbent brought this forward, that was back in 1989, and this House was supposed to have acted on that by the year 2000. It is now 18 years later since that goal, and we still don't have a national strategy against child poverty. It is time for us to act.
Questions and comments? Questions et commentaires. L'honorable député de Beauport-Limoilou.
The honourable member for Beauport-Limoilou.
The proposed bill, I've noticed that there is an article that proposes to make an obligation for spouses going through a divorce to consult a lawyer. And well, I'm thinking, even some of my friends that I know very closely, I've gone through divorce in amicable way. And sometimes it's possible. So I'm just thinking, is it really necessary to put forward an obligation to consult a lawyer? And I believe this is one of the amendments proposed for the Divorce Act. And I'm just wondering what the honourable member of Parliament thinks about that.
The honourable member for Vancouver East.
Thank you very much, Mr. Speaker, and I thank the member for his question. I think he asked of a different member a similar question earlier as well. What the bill requires is to ensure that the process of alternative dispute resolution is embarked on. That is the intent of the bill. Of course, in the best circumstances, in the best case scenario, would be for it to be amicable, for both parties to come to agreement on how they can proceed, and for both parties to say, we don't need to go to courts on that. We agree with how we ensure that this is a fair way, that maintenance is being provided for, how we will split the time of caring for the child, and so on and so forth. Of course, that would be the best option. What this bill does, and let's just be clear about that, is to require that the process be undertaken, that you embark on, the individuals involved embark on that dispute resolution process. That is of paramount, and that is, I think, the way in which will ultimately reduce legal fee as well as expenses for the courts.
Questions and comments? The honourable member for Skeena, Bulkley Valley.
Thank you very much, Mr. Speaker, and thank my friend for her speech and her long advocacy, particularly on the eradication of child poverty. She's right. It was Ed Broadbent who stood just a few seats down from where I'm standing here today that in 1989 moved a motion to eradicate child poverty in Canada by the year 2000. It was adopted unanimously by the House, all parties. And in fact, the most recent reports from Statistics Canada shows that from 1989 to now, child poverty has actually gone up. Rather than be eradicated, the problem has become worse. The Liberals have claimed that they are interested in this issue, yet, as my friend has pointed out, don't actually have a plan to get there. And we all know how things change without plans. They simply don't. A very specific question about Bill C-78, as this pertains to divorces in Canada and some new amendments which we appreciate. There's not a lot of language in the legislation that we read around common law couples. Now, we know, particularly in Quebec and some of the northern territories, a large number of couples now live in common law relationships, are not seeking to go through any kind of a procedure in a faith community or a civic arrangement, but are married by every intent under the law. This legislation is not, to my reading of it, not sufficiently exuberant about describing the situation for common law couples who then seek to separate, particularly if they have children. I wonder if my friend can tell us what needs to be done to include common law couples into this conversation, as that is not only a large percentage, but is a growing percentage of the arrangements that many families have in Canada now.
Honourable member for Vancouver East.
Thank you very much, Mr. Speaker, and I thank my colleague for his question as well. The issue that he raised is, I think, a valid one, is one that I touched on in my speech as well, and one that I think that the committee needs to look at, because he's absolutely correct. More and more people are in common law relationships, and when that breaks down, what is the recourse? How do we ensure in those circumstances where children are involved that the best interest of the child is also embarked on, and how will this bill apply to them? Right? And those are very valid questions to which I am very hopeful that the committee will engage in a process and to try and address some of those concerns that I have, that I share with him, and ultimately to bring forward a system that is applicable for everyone and with the central goal of the child's best interest at heart.
Questions et commentaires. The honourable member for Parkdale, Harry Park.
With respect to the member from Vancouver East's comments with respect to child poverty, I just put to her a few important statistics that we have unearthed. 2 million Canadian children live in separated or divorced families. There are 60% of all cases where there is a maintenance enforcement program involved. are in arrears, and those arrears total over $1 billion in Canada right now of unpaid support. By facilitating the payment of child support, by putting in place better tools for garnishment and information sharing, those tools will help to address getting those payments flowing and addressing the very child poverty that my friend opposite has underscored as being an important imperative. Could she offer her comments on the impact that this will have on child poverty?
The honourable member for Vancouver East.
Thank you very much, Mr. Speaker, and I thank the member for his question. I was talking about the importance of ensuring that we have a comprehensive strategy for child poverty, one to which this House endorsed under Ed Broadbent's motion back in 1989 that's supposed to be in place in the year 2000, to which we still don't. That is the issue to which, if we want to address child poverty in a comprehensive way, that's what I think we need to do, have a national strategy. A component piece within that, of course, is this bill. And yes, it does help to a degree in ensuring that maintenance is paid and that there is fair calculation of the maintenance, and to ensure that all that information is provided so that you can come up with that figure. And that is a positive thing. But I hope that the member does not think that is the only thing. That is the end-all and be-all towards child poverty. The ad hoc approach to which this government has adopted to address the issue of child poverty is deficient, and that is my point. And we need to come together to honor the words of Ed Broadbent and the intent of this House back in 1989 when they unanimously passed this motion to bring an end to child poverty with a national child poverty strategy, Mr. Speaker.
Reprise du débat, resuming debate, l'honorable député.
The honourable member for Beauport-Limoilou. Thank you very much, Mr. Speaker. We are so pleased to rise and speak today on behalf of the thousands of people in Beauport-Limoilou, and I'd like to salute them and greet them warmly today because it's been a long time since I've been able to speak directly to them here from the House. And today I'll be speaking about Bill C-78, an act to amend the Divorce Act, the Family Orders and Agreements Enforcement Assistance Act, and the Garnishment, Attachment and Pension Diversion Act, and to make consequential amendments to another act. Mr. Speaker, marriage has always been important to me. From a very young age, I always wanted to become married one day. I've always felt that connection between two individuals that is sanctioned through marriage is beautiful, and it's also a beautiful tradition. And as a conservative, I love to preserve traditions. And unfortunately, I lived in a social context in Quebec, and do so now, where not enough value is attached to marriage. And I'm talking about official marriage, whether it's civilian or religious. I feel that marriage isn't valued enough. Many people are in a common law relationship, and that's fine for them. However, something that is very dear to me as a conservative is this tradition and this tradition of marriage. My wife, Pascale Neville, and I have been married for 19 years, and after 7 years of being with her, I wanted to be able to officially propose to her, and I'm so happy still to be married today, and I hope this will go right through to my dying days. So that is what I wish for the most. Mr. Speaker, with your permission, I'd just like to speak a little to what my summer involved in my riding. There are many people listening to us on CPAC right now, and I've met my citizens many, many times over the course of the summer. During those 3 months of that summer break. Now, I call it a summer break, but it wasn't a break in work. Some people seem to think that it's an actual break, but I was actually in my office for a few weeks. I did go to Baie-Saint-Paul for a vacation. I camped in the area of Charlevoix. And I celebrated July 1st in Beauport, where thousands of citizens came to celebrate the birth of Confederation. And I also celebrated where there were 3,500 citizens to come and speak to me about their concerns. We had hot dogs and corn. This was another event where everything had been provided by Provigo and Limoilou, and I'd like to thank Mr. Baudouin, the owner of Provigo, for having been so generous to the citizens of Beauport-Limoilou. I knocked on doors, like I always do every month. I knock on doors a couple of times a week. I wanted to find out what the concerns were so that I could pass those on to our leader. And I wanted to find out how they feel about our distinct, unique nature in Quebec. And I also met with business leaders in Beauport-Limoilou. I set up breakfasts where business leaders could come and meet with me. And on the 12th of October at 7 in the morning, I'm going to meet more. We'll have an economic roundtable. We're going to meet various economists and business people, and many small and medium-sized business owners will be there. Over the summer, I went to many other events in my riding. I also held my second consultation with citizens, and I actually am going to be bringing forward a private member's bill that reflects some of the concerns that were raised. And then, of course, there was also the usual administrative work in my office. 2 weeks ago, I celebrated with the mayor of Quebec City, Monsieur Régis Lebaume, and a member of the Liberal Quebec Party, because we were celebrating Medicago, a new business that provides many jobs in research. And they're going to be participating in a sort of revitalization activity in Quebec. Now, let's come back to the subject at hand today, Bill C-78. I would say from the outset that the Conservatives intend on supporting this bill at this stage. I think this is first reading of the bill, rather perhaps second reading. I realize first is pretty automatic, but we do still have some reservations, and we want an opportunity to be able to hear witnesses when the committee holds its hearings. We want to hear what the reactions of the Liberals will be to any concerns that are raised about this bill, because as I'll be showing earlier, some of the things in this bill are a little confusing to us. But I would like to say to my fellow citizens in Beauport-Limoilou, here are the main points of the bill. Well, first I would say that it's the interests of the child that are at the heart of this bill. There have been no amendments to the Divorce Act for a good 20 years, and 20 years is 2 decades. We've had all kinds of generations, X, Y, millennials. So the years have been going by, things have been changing, customs have been changing. 2 decades, 20 years is a long time. And I would say to the Liberals that this was a good idea to go ahead with amendments to this legislation. Children experience many things when they go through a divorce, and Liberals are right in saying that perhaps what we should be doing is put the child at the center, just in the way that we say that the patient should be at the center of the healthcare system. And we, the Conservatives, agree on putting the child at the heart of this legislation. Yes, let us put the child at the heart of our debates and our discussions on these amendments, so that no matter what happens within a couple, the impact is as low as possible on the child. My parents, my mother and father, are divorced. The parents of my wife are divorced. It almost seemed to be the fashion at the time. And I'm saying this quite honestly. And my wife and I often joke that a joke that we don't necessarily have the option of divorcing when we're older because my children already have several sets of grandparents, so it wouldn't be fair to them for us to divorce. Regardless, there are many people who divorce for unavoidable reasons. And, Mr. Speaker, when I was looking at the bill, I thought that we've been seeing a lot happening this week. For example, the signing of the agreement between the United States, Canada, and Mexico. And we're talking about marriage, we're talking about deals. Well, perhaps we should be thinking about the USMCA as a marriage between countries. It's an economic marriage. And within this economic marriage that has taken place for rational reasons, imagine that we're trying to protect the children, that the children in this case are the economy and our country's sovereignty. So I'm drawing a parallel between marriage and NAFTA because it is an important agreement. It's an agreement between two countries deciding to open up their borders, deciding to work together collectively in order to help both countries develop in a way that benefits everyone. Now, what are we noticing with the signing of this deal? Well, in terms of the economy, Mr. Speaker, we see that this marriage makes no sense because the Prime Minister, the member for Papineau, was not able to make sure that this would be a fair marriage. Let's take softwood lumber. That issue has not been dealt with. Here we are at our third softwood lumber crisis. I visited Gaspésie and Rimouski, and people wouldn't be happy that I call it that. I'll say the Bas-Saint-Laurent. I met many lumber businesses, and they are tired of seeing these repeated crises. This would have been a golden opportunity to strengthen the Canadian-U.S. marriage and deal with the softwood lumber problem. And let's look at all the other regions in Quebec. They will be suffering because of this breach that has been opened up into supply management for dairy products and the dairy sector. Once again, we've made no gains, but we're giving away. But that's not a fair marriage. In 1989, point of order, the honourable member for Parkdale Hyde Park. Yes, I apologize for interrupting my colleague from Beauport-Limoilou while he's in the middle of a speech. But it's one thing to discuss the bill before us, C-78, and it's another to start long remarks and a speech on NAFTA and the new USMCA agreement. And then to be inserting supply management into the discussion.
I would actually ask that you make a ruling as to whether that's in order, and ask the member opposite if he could direct his comments directly to this piece of legislation. Merci beaucoup.
Thank you.
J'ai vu beaucoup de
Many speeches have taken place in this House, and oftentimes the member starts along a line of thinking. One wonders often where he's going, he or she are going. And sometimes it's hard to predict. They go off on a tangent that doesn't seem to make any sense. However, the member has a right to head off in one direction, and I am quite certain that the member in question will be able to return to the discussion that is taking place again and bring together his lines of thinking. I'm sure that his line of thinking will be relevant, so I'm going to give the floor back to the member for Beauport-Limoilou. Thank you very much, Mr. Speaker. And I understand why my colleague would be concerned, but there was a reasoning in my line of thinking. So I want to talk about the contradictions between that bill and the other bill, actually Bill C-75, but let's move on from NAFTA, and let me draw another parallel. We have C-78 being tabled in the House today, and it's telling Canadians, after 20 years, we're going to bring forward significant, important technical changes, amendments that will strengthen provisions and the institution of marriage in the country. However, we, the Conservatives, will be supporting this bill depending on the outcome of consultations in committee. However, it's very difficult to trust the Prime Minister when he says he wants to strengthen marriage when we look at his behavior as a government leader. For example, when Trudeau was elected in 2015, one would have called it a marriage between him and the people of Canada. But let's look at what has happened after 3 years. A marriage, given what he has done, wouldn't have held up even for a year, because the Prime Minister broke 3 promises, 3 important promises that I feel undermine that marriage morally. And I'm going to show you how that parallel stands and how I can draw that parallel with this legislation. There were 3 important promises. Have a $10 billion deficit for the first 3 years, and then to bring that down. He didn't do that. It was $30 billion every year, for every year. Second promise, by 2020, 2021, to balance the budget. Is anything more important than finances within a couple? Well, yes, love, I understand that. But budgets are extremely important within a household. For a couple to stay connected, budgets are important. I can testify to that. Love does have its limits within a household. You know, you have to be able to support your children, feed your family, and you have to balance your budget. And oftentimes Canadian families will do that. But our Prime Minister is not able to keep that promise. Now, the other one was on voting. In other words, how are we going to make our lives together work? How are we going to involve other Canadians? And he said to Canadians, I am going to reform elections. But he didn't keep that promise. And it's one of the first promises he broke, actually, which is a serious, serious betrayal of his promise. Now, I absolutely disagree with those reforms because I feel that first past the post is the best system for a parliamentary democracy. However, he made that promise to all these young people, Vancouver, Toronto, and they all thought proportional representation might be better for their future. However, he broke that promise to them. Not only would the marriage be over by now, not only would they be divorced. Thank you, Mr. Speaker. I am getting to the bill, I promise you. The other promise was his promise about infrastructure. Mr. Speaker, he said, I, the Prime Minister of Canada, will invest millions of dollars over the next 14 years in infrastructure. This was supposed to be the biggest infrastructure program in the history of Canada. However, we also had a huge infrastructure program. Mr. Speaker, how many billions of dollars do you think were spent out of the billions he promised? Well, even the parliamentary budget officer spoke about how little he put in compared to his promise. So how can one trust this Prime Minister, member for Papineau, who brings forward a bill whose purpose is to strengthen marriage, whose purpose is to strengthen protection of the child when there are marriage breakdowns, when there are divorces, when he himself, in his own solemn marriage with the Canadian people, has broken some of the biggest promises that he laid out in his platform in 2015. So, the promises have been broken, and there is a divorce coming. Mr. Speaker, it will happen in 2019 on October 19th. Now, in terms of Bill C-78, there are some pretty significant statistics. More than 2 million children live in separated family. Rather, lived in 2016. 5 million couples separated. 38% had a child at the time of their separation or divorce. And I imagine that's why Bill C-78 wants to focus on these children.
So, Section 101, which says that it has to do with the process of garnishment. Now, this is of concern for us because we want to avoid we're going to have witnesses in committee, and we might want to amend this. There's also Section 54, which we feel which imposes a penalty of 5 to 12 years, and we think this is something that might be a problem. Also, Mr. Speaker, I don't want to end on a negative note, but I wanted to raise one of the really important issues here. The Liberals very enthusiastically are saying they're putting the child at the very heart of a divorce and not on the divorcing couple. But when you look at Bill C-78, which is an omnibus bill, a mammoth omnibus bill, 300 pages long, this is a bill that wants to go backwards and redo all the measures undertaken by Prime Minister Harper during a marvelous decade in Canadian history. And in Bill C-78, what do we see? We see, and for everyone listening, it reduces sentences for crimes committed against children. So you can't just say Conservatives bad, Liberals good. They boast about their being the purveyors of universal love. But here in this bill, they say that they want to help children. So we see the contradiction. There are complaints and criticisms, but I want to say to my fellow citizens, do they have to accept? Here they are looking at promises that have been, all these promises being broken since 2015. I want to tell Canadians that there is an imminent divorce between Liberals and the Canadian people. The Honourable Member for Parkdale Hyde Park. I appreciate the comments of the member across the way. And I don't know why he wanted to discuss this bill rather than other worries on the other side of the House. But at least he discussed it rather than other things. Now, there was one aspect that we agree on. Now, I know that on the other side of the House there is a concern about the fact that when there is unpaid income or a revenue gap.
The revenue gaps have been identified in terms of income support payments, parental support, and child support payments to the tune of payments in arrears that total over $1 billion in Canada right now. That has a disproportionate impact on women who are largely the people to whom the payments are made by debtors who are largely men. Given that context, would the member opposite agree to discuss this bill, and in the context of this bill, the impact that this bill will have on alleviating the poverty that is identified right across the country, including in Beauport-Limoilou by its constituents, that touches women poverty and child poverty?
The Honourable Member for Beauport-Limoilou.
I agree with the member opposite. He's perfectly right. This is one of the excellent amendments that will be brought about to the Bill C-78. which aims, for example, to enhance the power of the Revenue Canada Agency to be able to verify the information, the financial information of one or the other spouses, to make sure that there's equity. Equity not for the spouses, but for the children. We all agree with that. But my concern, though, and of course it will be good for my citizens in Beauport-Limoilou, no doubt about it, but I have two concerns, one regarding this and one regarding the bill. The bill does not anticipate or propose enhancing the budget of the RCA, Revenue Canada Agency, to exactly do what the E is doing saying about, to have more power to verify the information. The RCA does not work on free-paying jobs bureaucrats. The RCA does not work on written words on a blank paper. The RCA works with people who have pension, with people who work, so you need to inject more money when you want to increase the power of the RCA. And I hope to see in the budget that the action will follow the words of his government. My other concern, sir, and unfortunately you won't be able to answer my question unless nobody else stands up, but I don't understand why they want to make an obligation of both spouses to meet and consult with a lawyer, because in many instances, sir, some people go through a divorce in an amicable way. I know friends that went through the divorce for the better well-being and good of their children. The divorce was done in an appropriate way. And so why will this government want to impose the obligation to consult with a lawyer, which will necessitate spending? I would like to have the Liberals address this concern. Thank you, sir.
Questions and comments. Questions et commentaires. L'honorable député.
The honourable member for Salaberry-sur-Roi. Thank you, Mr. Speaker, and I thank my colleague who in his speech talked about the best interests of the child. I believe that this bill does have this as an intention, but there are amendments that might be made to make sure that a child could be represented by a third party who had more resources in terms of psychological help and everything that has to do with support. But when it has to do with putting the best interests of the child at the very center of this, I think that we might consult experts and make amendments to improve this, as long as the amendments serve the best interests of the child and they are at the center of our discussion. The honourable member. Well, of course, Mr. Speaker, and I commend my colleague, and I haven't really been able to say hello to her before, since we came back from the summer break. But yes, I imagine the NDP, just as is the case with the Conservatives, see that Liberals are making the protection of the child and the consequences that a child might be subjected to because of divorce, that this is being put at the center of the bill. This is something that all members can agree on, but we're eager to talk about this in committee. And we know the devil is in the details, and this is a voluminous bill. I'm eager to see what experts will say in committee. I think it's important that we make amendments to the Marriage Act, for example. And here we have 101 and Section 54. I have certain apprehensions because, and I reiterate, and as I said in my speech, the Prime Minister did not respect his commitment, his marriage, with the Canadian people. He broke his promises toward the Canadian people in this marriage of 2015. You'll understand I'm speaking metaphorically, but the child should be at the center of our concerns. But what about What about Bill C-75, which reduces sentences?
Member for Parkdale High Park.
So I appreciate the member's commentary, and in respect to the debate that we're having, juste to souligner, il n'y a aucune obligation.
I want to emphasize that there is no obligation to consult a lawyer. This bill aims at avoiding the necessity of consulting a lawyer. There are two very specific things. First of all, how support is calculated. This can be done from an administrative point of view without having to do anything to do with a lawyer. And then this can be adjusted. It can be adjusted without the advice of a lawyer. We want to avoid it becoming too litigious. We want family court that's less litigious, and we've heard from interveners who have said, and we heard this Canada-wide, that this is a good reform in family justice. And I'd like to know if the member across the way can explain his worries in a more precise and specific way, because I don't see this, what he's talking about in the bill. The Honourable Member for Beauport-Limoilou. Thank you, Mr. Speaker. I'm very happy that my colleague answered so frankly, because I don't think I said there was an obligation to see a lawyer during a divorce. But it does seem to me is that what he said leads to other questions. He said, we want to streamline the process, simplify it, allow there to be another path forwards than the judicial one. We want to, we're talking about spouses and which spouse will have custody, but he said that the bill proposes that Revenue Canada be able to update and verify citizens' files, and in this case it would be the couple. But here's another question. There is nothing in the bill that provides for an additional budget at Revenue Canada, and seriously, in order to add work and to have more inquiries and investigation, then the CRA will need additional money. So, yes, if they want to make it less litigious, they are going to have to put in their 2019 budget more money for Revenue Canada, because this summer I heard all kinds of horror stories from fellow citizens with respect to Revenue Canada. Unbelievable what's happening. So the minister will have to look into what's happening at Revenue Canada. Now, I heard about this all summer, and I'm happy to talk about it. People told me, Mr. Clark, it's unacceptable. We call, no one answers. The line is always busy. We get no answers. Unacceptable. There should be a minimum of response when people contact the public service.
For Elgin, Middlesex, London, I want to inform the honourable member that she'll have approximately 6 minutes and then we'll break. And upon resuming debate, she'll have 4 minutes coming to her to resume and then have the questions asked. The honourable member.
Thank you very much, Mr. Speaker. And today I'm honoured to rise and speak on Bill C-78. I am not coming to you as a lawyer, as many of the other speakers have done today, but I am coming to you as a woman who has been divorced, as well as a woman who has worked in a constituency office, dealing with people who have come from divorce and dealing with different government departments. I'm just going to begin with some of my own experiences dealing as a constituency assistant and dealing when we're talking about how Canada Child Benefit divvies out the Canada Child Benefit. With the Canada Revenue Agency, under the leadership of the Conservative government, they did an excellent job when it came to looking at the shared custody and the shared parenting. That has become a nuance for many new families. Anyone who is going to divorce, you know, if you asked me 20 years ago when I was looking at that, shared parenting really wasn't the option, but for many families, it is now what they're looking at. So when the Canada Revenue Agency put in the opportunity for people to divide their benefits, it became very, very beneficial for many of those families. The only question that I will have for the government that will go on to this is, what are we looking at? What does 40% mean? A lot of times when we're looking at those numbers, it can be very, very difficult because we have to recognize that when somebody has the custody of their child, is that child in school? Are you the person who's picking them up from school? Is the child sleeping in your own home? There's so many factors that have to be looked at. So I do want to make sure that when we're talking about that 40%, when it comes to parenting, that is really looked at with a fine microscope. But also, I come to you as a person who has had a divorce, who understands what it's like to raise children who have come from that situation where their parents are divorced. It's been very, very difficult. We talk about, child support, and I'm really, really pleased with this bill to see that the child support is now it does not have to go in front of a judge. It does not need to go to the court, and that it can be done at an administrative level. For many families, this is a huge barrier, whether it's having to pay those legal fees or even having to go through that entire process. So seeing a way of making it easier for Canadian families is very, very important. But we have to understand that there are barriers to that as well, and it has been brought up by my colleagues about how do we address those issues when people are being paid off of payroll and under the table. There are many, many parents, not just fathers, not just mothers, but there are parents across the country that are not paying child support and are trying to, let's say, rip off their children, because that is, at the end of the day, those are the people that are most affected. And so anything that we can do to make sure that we're always putting the best interests of our children forward is very, very important. I just wanted to read a little bit of something when we talk about the psychology and the emotional issues that occur around a divorce. And seeing what we put in this bill about the child welfare, it is something that I fully support. Children have to come first during a divorce. Honestly, I look at myself and I think divorce is 20/20 hindsight. If I could have done things differently, I would. But at that time, the emotions, the anger, the wanting for revenge, all of those horrible things that you feel during a divorce and during a separation occur. So we have to recognize that it is such an emotional issue. And sometimes, and I apologize to all of the lawyers in the rooms, but sometimes it does get worse when you go to a lawyer, and at the end of the day, you're putting yourself at $20,000, $25,000 behind the eight ball because of all of that. But Brian Gelberth, a lawyer in Barrie, wrote on his website, "Depression can occur during separation and divorce. According to a national population health survey, the 2-year period after a divorce has high rate of serious psychological problems for the couple. This is not surprising, in fact, given the anxieties of the children and the drastic life and income changes that occur at this time." And as also noted in Psychology Today, an issue of Psychology Today, divorce introduces a massive change into the life of a boy or girl, no matter what the age. Witnessing loss of love between parents, having breaks from marriage commitment, adjusting to coming back and forth between two different households, and the daily absence of one parent while living with the other all create a challenging new family circumstance in which to live. In the personal history of the boy or girl, parental divorce is a watershed event. Life that follows is significantly changed, and life how it goes and how it was before. The dependent child's short-term reaction to divorce can be an anxious one, and this is something that the government talks about child welfare. So in this, we talk about mediation, we talk about the opportunities to have a lawyer assisting our child, and I really want to say if this is something we're going to look at, we have to make sure we have those resources for the children. I can share with you that 18 years ago when I went through my divorce, these opportunities for low-income women, as myself at that time, were not available. A waiting list for my own son, just to sit down so he could talk about it, was not available to him. It took 8 months. So I thank you very much for the time. Thank you.
The honourable member for Elgin, Middlesex, London will have 15 minutes coming to her when we resume debate, plus 10 minutes of questions that go with that. Statements by members, déclaration des députés. L'honorable député de la...
The honourable member for La Pointe de l'Île. Mr. Speaker, it would seem that the Prime Minister of Canada just realized that the notwithstanding clause exists. And not only does it exist, but it's useful and legitimate. The notwithstanding clause allowed Quebec to avoid implementing certain provisions of the 1982 Constitution, which ran against the identity of the population of Quebec. The province never signed the Constitution. It is up to Quebec to decide and not a judge on the Supreme Court. René Lévesque applied it to all of Quebec's legislation. Since then, notwithstanding provisions were used for 41 laws in Quebec to protect socially progressive measures and to protect our distinctive national identity. Let it be clear, if the Canada wants to restart a war about Quebec's societal choices, the Bloc Québécois will be in its way.
Dartmouth Cole Harbour.
Mr. Speaker, I rise today to celebrate Dartmouth Cole Harbour's beautiful Lake Banook and Dartmouth, Nova Scotia's paddling culture. Mr. Speaker, in Dartmouth, folks don't ask if you paddle, they ask where you paddle. Last month, Lake Banook successfully hosted the 2018 Pan American Canoe Sprint Championships. Over 350 elite paddlers from more than 16 countries competed on our world-recognized natural race course. I want to thank and commend the folks at Atlantic Division Canoe Kayak Canada, Banook Canoe Club, Micmac Amateur Aquatic Club, Abenaki Aquatic Club, Sonobe Aquatic Club, and all of the incredible volunteers who worked so hard to make this event a success. Paddling has always been a huge part of Dartmouth's identity and its culture, and Lake Banook is our world stage to showcase our pride in our community. In 2020, Lake Banook will host the World Championships for the third time. Mr. Speaker, I invite you all to come to beautiful Dartmouth, Nova Scotia in 2020 to experience all that Lake Banook has to offer.
The honourable member for Foothills.
My loving mother, grandmother, wife, but most importantly, Mary Gillard was a beloved educator. Mary passed away earlier this summer on her 95th birthday, but the impact on her community will be her long-lasting legacy. Over the course of an outstanding 65-year teaching career, which lasted until she was 82, she inspired generations of Albertans. Mary believed that every one of her students had a unique gift, and she taught them work ethic, the importance of community, but most importantly, respect must be earned, and she was right. A mentor and an educator, Mary was one honored multiple times for her teaching and her community support. She was given the Silver Falcon Award for outstanding service to the community and youth, the Okotoks Rotary Integrity Award, and the school division gave her the Outstanding Teaching Award when she was 87. She shaped the hearts and minds of so many in our communities, grandparents, parents, sons and daughters, including my own. For generations of Okotokians, Mary was a guiding light in the classroom and community. Together, we honor the life and legacy of this outstanding, inspiring woman. Thank you.
The honourable member for South Surrey White Rock.
Well, thank you, kind speaker. How do we know what we know? Politician philosopher Daniel Patrick Moynihan once wisely said, everyone is entitled to their own opinions, but not to their own facts. However, often we deal with people who seem to enjoy using their own facts. It seems that anyone can find their own set of facts and then use those facts to reinforce their own opinions. The great Stephen Colbert once termed the phrase truthiness, which is meant to denote how smart, sophisticated people, like all of us in this House, can go awry on questions of fact, ideas that just seem right without reference to logic or intellectual rigor, as hard as that may be to believe. However, this is true in all walks of life, but especially true in politics. It seems that with increased politicization of debate, there comes increased public cynicism, which is probably why polling has recently shown that 4 out of 5 Canadians believe that when politicians make public statements, they tell the truth less than half the time. I trust that all of us in this House are exempt from that admonishment. So, whether it's facts, logic, or some form of truthiness, it seems important that we consider the trust that Canadians place in each of us as their representatives when we choose which of our set of facts to embrace.
The honourable member for Hamilton Mountain.
Mr. Speaker, after 3 years, this government has done little to help Canadian seniors and retirees. The Prime Minister promised during the election campaign to use every tool in the toolbox to fix Canada's flawed bankruptcy and insolvency law to protect workers' pensions, but so far has done nothing. After news that 18,000 Sears retirees will lose 30% of their pensions, we still heard nothing from this government. The government made a promise to consult in their last budget, but clearly Liberal promises are not worth the paper they are written on. Changing the laws to protect workers' pensions is not hard.
my Bill C-384 and Liberal Senator Art Akelden's Bill S-253 lay out straightforward measures to fix the problems. Still, the government refuses to act. For 3 years, I've been asking this government to change the laws to protect Canadian pensioners. Every time I get back the same non-answers. The lack of respect is insulting Canadian workers and retirees. Let's stop the pension theft.
Bravo. L'honorable député de Thérèse de...
The Honourable Member for Thérèse de Blainville. Mr. Speaker, here's what you need to know about Thanksgiving, other than the fact that it's a statutory holiday. The roots of Thanksgiving extended back to 2,000 years ago, at a time when Indigenous peoples celebrated the fall harvest. After the arrival of European colonists, Thanksgiving was celebrated for the first time in 1578 by the explorer Martin Frobisher in Newfoundland. Mr. Speaker, if I have any advice to give to the turkeys, it would be to run. I don't know where, but run. Because 3 million turkeys are going to be eaten in Canada this weekend, with cranberries on the side, which were originally harvested by the Algonquin, and were served during festivals as a sign of peace. Celebrating Thanksgiving is celebrating life, family, and peace. Happy Thanksgiving to everyone.
The Honourable Member for Cypress Hills Grasslands.
Mr. Speaker, the loss of democracy in any country should concern us. Cambodia is falling back into the darkness it experienced in the past. Prime Minister Hun Sen has destroyed democratic institutions and practices. He's outlawed the opposition, jailed the opposition leader, Kem Sokha. The July election was fixed and illegitimate. Cambodia's history as a one-party state has had long-lasting consequences that the Cambodian people have worked hard to overcome. Democracy is foundational for the establishment of human rights. Exiled Cambodian leaders like Mu Sokha have addressed members of this House calling on Canada to speak out. Today, I do call on this Liberal government to press for the restoration of democracy in Cambodia and call for Kem Sokha's immediate release. We call for the restoration of the rights of the opposition and a new election. Until then, we ask that this government not recognize the representatives of this illegitimate regime.
The Honourable Member for Parkdale High Park.
Mr. Speaker, this Thanksgiving, I give thanks to the incredible young people in Parkdale High Park. Students who had the courage to stand up and be heard on something that is vital, their education. In 2015, Ontario revised its sexual education curriculum to bring it into the 21st century, to address things like same-sex families, gender identity, online bullying, and consent. But the new Ontario government has seen fit to reverse that curriculum, to take it back to 1998, when things like the internet and online sexual predatory activity was in its infancy. This reversion is not only unwelcome, it is unhelpful. It prevents our children from learning how to protect themselves. But it's not just me that disagrees with the reversion. It's also hundreds of my young constituents from Parkdale Collegiate, Western Tech, Ursula Franklin Academy, the Student School, and Humberside Collegiate, who walked out of class on September 21st to say, we do not consent to taking education backwards. Today, I lend my voice to theirs. Sex ed must be modern, inclusive, and empower our young people about how to stay safe. Thank you, Mr. Speaker.
Honourable Member for London West.
Mr. Speaker, small businesses make up 98% of Canadian businesses and employ over 10 million hardworking Canadians from coast to coast to coast. One such small business is Turner Drug Store, an independent pharmacy located in my riding of London West, which recently celebrated its 80th anniversary. Jeffrey Robb, a pharmacist and the current owner, has worked at Turner Drug Store since 1974 when he was just 14 years old. This small business holds a special place in the heart of many Londoners as it has provided pharmaceutical, vitamins and herbal remedies to the community for 8 decades. Our government knows the fundamental role that small businesses play in our economy, and we will continue to support their growth and success. I would like to extend my sincerest congratulations to Turner Drug Store for reaching this astounding milestone. Thank you very much, Mr. Speaker.
Honourable Member for Sturgeon River Parkland.
Mr. Speaker, this week LNG Canada approved a groundbreaking $40 billion investment in developing Canada's liquefied natural gas industry. Now, the Liberals would like to claim that their carbon tax plan is working, but mega projects like LNG Canada cannot move forward under the spectre of this Liberal carbon tax on everything. Provincial governments across Canada get it. You cannot grow the economy by adding new taxes. The Manitoba government is the latest to pull out of this Liberal carbon tax scam, and others are soon to follow. That's why the BC government gave LNG a pass on new carbon taxes. The project would not have gone forward otherwise. It's time for the Liberals to recognize that their carbon tax and spend agenda is failing Canadian businesses and Canadian families.
Hello. The honourable member for Scarborough Centre.
Thank you, Mr. Speaker. Mr. Speaker, I recently had the privilege of attending a parade recognizing the 50th anniversary of the Royal Canadian Legion Branch 617 in my riding of Scarborough Centre. Branch 617 is proudly known as the Dam Busters, commemorating the iconic air raid of the Second World War. You may have seen the movie. Since its founding, Branch 617 has served to our veterans, providing a place for them to socialize with their peers. Their Poppy campaign supports services for veterans who need help, and the annual Remembrance Day ceremony at their cenotaph ensures that we will remember them. They also support Squadron 166 of the Royal Canadian Air Cadets and the NLCC Prince of Wales of the Navy League, helping to instill a spirit of responsibility, discipline, and leadership in the next generation. Félicitations à la branche.
Congratulations to Branch 617 for its 50th anniversary, and thank you to all of the branches of our Legion throughout Canada. The Honourable Member for La Salle-et-Mare-Verdun. Mr. Speaker, it is with great pleasure and honour that today, for the third year in a row, I welcome citizens from my riding here in Ottawa as part of the traditional Day on the Hill, which I've been organizing since I was elected in 2015 as member for La Salle-et-Mare-Verdun. As politicians, we are elected to represent the interests of citizens in this place to the best of our abilities. Therefore, it is a real privilege for me to have at my side the people behind the work that I accomplish with pride every day.
I want to thank the people of La Salle-et-Mare-Verdun for their confidence and for taking time to travel to the Hill today. Thank you for your interest, your passion, and your hard work. It's what drives me to accomplish my duties as an MP. Thank you. Merci.
The honourable member for Red Deer-Lacombe.
Mr. Speaker, less than an hour ago, many of my colleagues, including my good friend from Red Deer Mountain View and myself, had the privilege of taking part in a torch-lighting ceremony at the Centennial Flame. Now, this ceremony was the official start of the Canada Games torch relay in advance of the 2019 Canada Winter Games. The torch relay is an important part of the Canada Games, and it will unite communities across our nation. This is the first time ever the torch relay will travel Canada-wide to mark the Games, with 48 communities from coast to coast participating. A huge thanks to MNP for sponsoring the torch relay, to the Games Committee, their staff and volunteers who are working tirelessly to organize this incredible event, and to all of the torch bearers who have been nominated to carry the torch on behalf of their communities. In 134 days, the Games will begin, and we are ready to welcome Canada to Central Alberta and to join the festivities and watch our amazing athletes perform. Mr. Speaker, Red Deer is ready, and everyone is invited.
I suppose members will be all fired up now, so to speak. The honourable member for Kitchener Centre.
Mr. Speaker, Canadians of German origin are one of the largest ancestral groups in Canada. 1 out of 10 Canadians is of German ancestry, and 1 of every 5 live where I do in Waterloo Region. The Kitchener-Waterloo Oktoberfest, now marking its 50th anniversary, is the largest Oktoberfest celebration outside of Germany. It is a 9-day celebration of German heritage filled with food, music, and festivities. So, put on your lederhosen and your dindros and experience the Gemütlichkeit as you polka the night away at one of our 17 Festhallen. On behalf of myself and the members for Kitchener-South Hespeler, Kitchener-Conestoga, Cambridge, and Waterloo, it gives me great pleasure to invite all members to join us tomorrow at Kitchener City Hall for the official keg-tapping opening ceremony. Thank you, Mr. Speaker.
The Honourable Member for Salaberry-sur-Roi. Mr. Speaker,
My riding of Salaberry-sur-Roi, like every other riding in this country, is experiencing the effects of climate change. The challenge is even greater in peripheral regions because we have to fight to maintain economic activity and welcome new businesses to cut down on rural exodus. I am very proud to be able to announce in this House that the city of Salaberry de Valleyfield made its mark on both fronts. Last week, the mayor's office announced an agreement with the Solargize company to build a large solar panel factory. This is an investment of nearly $1 billion that will create 450 jobs. And this great news is made even better by the fact that this company makes solar panels without plastics. I would like to congratulate the mayor, Miguel Lemieux, municipal councillors, and everyone who made this project a reality. The municipal level did its work, and now it's up to the federal levels to do more to fight against climate change. Thank you.
A member for Dauphin, Swan River, Nicola.
Mr. Speaker, when it came to the Liberals' carbon tax, Manitoba Premier Brian Palliser tried to be reasonable. Premier Palliser is a strong conservationist himself, which led to the development of the Manitoba Climate and Green Plan. The plan focuses on the 4 pillars of clean water, conservation of natural areas, effective steps to address climate change, and strengthening the economy. Unfortunately, the Prime Minister was completely unreasonable. It is clear to me that the Prime Minister's intransigence in the face of an eminently reasonable proposal gave Premier Palliser no choice but to move forward with his Made in Manitoba Climate and Green Plan without a carbon tax. Hear, hear. I applaud the decision by the Manitoba government to protect taxpayers from the Liberals' heavy-handed carbon tax scheme while still moving forward with a detailed environmental plan. I look forward to seeing the real and tangible environmental outcomes that will flow from the Manitoba Climate and Green Plan while ensuring Manitoba's economy continues to grow. Thank you, Premier Brian Palliser.
The Honourable Member for Labrador.
Thank you, Mr. Speaker. Today, here on Parliament Hill and all across the country, vigils are being held in memory of missing and murdered Indigenous women and girls. I invite all Canadians to observe a moment of silence today on the occasion of Sisters in Spirit vigils, which have been taking place since 2006. A vigil can take many forms, from a walk to a rally to a shared meal, a moment to reflect and a moment to remember. Let us honor our sisters in spirit by participating in a vigil today. Let us demonstrate our shared commitment to end the national tragedy of violence experienced by Indigenous girls and women in Canada. As Sisters in Spirit Vigil founder, Kaduka Terry Brown says, "Grandmother, lighten our path in the dark. Creator, keep our sisters safe from harm." Today, we remember all of them and work towards a safer country.
Alors, suite aux discussions en...
Following discussions among representatives of all parties in the House, I understand that there is an agreement to observe a moment of silence in the context of the Sisters in Spirit Vigils held each year on October 4th to honor the lives of missing and murdered Indigenous women and girls. I now invite honourable members to rise.
Eulalia, thank you. Merci. Oral questions. Questions orales. Honorable.
The Honourable Member for Richmond, Arthabaska.
Monsieur le Président.
Mr. Speaker, The USMCA includes Provision 32 that stipulates that the United States are involved in our trade negotiations with non-market economies. That gives President Trump the right to interfere in our economy, and it imperils our sovereignty and to negotiate our own free trade agreements. Can the Prime Minister tell us what he got in exchange for that major concession, the Honourable Minister of Transport? Mr. Speaker, it is very important to diversify our trade agreements in order to grow our economy. We are a trading country, and within NAFTA, it has always been possible for parties to withdraw from the agreement. That is essential. Each country has the sovereign right to withdraw from a trade agreement. Nothing in this agreement infringes on the sovereign right of Canada to develop trade relations with countries of its choice. The Honourable Member for Richmond, Athabasca. Well, it's so impressive how this party is able to avoid answering questions. Loss of economic sovereignty, maintaining tariffs on steel and aluminum, maintaining taxes on softwood lumber, concessions in the dairy market, pharmacare drugs going up. All these concessions to our workers throughout the country. Will the government tell us what economic advantage they managed to get in exchange for all the concessions to President Donald Trump? The Honourable Minister of Transport. Mr. Speaker, I am mystified by why the Conservatives are not applauding us for this deal that we signed Sunday night. This isn't just any agreement. This is an agreement that is good for Canada. All other Canadians know this. Why won't they realize that? It is so important for our economy, for stability, for long-term access. We have succeeded, and they should be acknowledging that.
The Honourable Member for Wellington Halton Hills.
Mr. Speaker, 100 years ago, 60,000 Canadians died in the Great War. Their sacrifice, their bloodshed is full of the remembrance of that war. Parliament's full of reminders of that sacrifice. Their bloodshed paid for an independent Canadian foreign policy. It paid for our signature on the Treaty of Versailles. It paid for the Statute of Westminster. But this government was so desperate for a deal, we now have to ask Washington for permission to negotiate free trade with certain countries. Article 32 makes us a vassal state. Is this restoring Canadian leadership in the world? Is this standing up for Canada?
The Honourable Minister of Transport.
We will take no lessons from the Conservatives. We have always been a sovereign country. We will always be a sovereign country, and we will negotiate trade agreements with any country that it is in the interests of Canada to negotiate with. That is how we run things in this government here, and that has always been the case. And in case you didn't know it, under NAFTA, any party to NAFTA is allowed, or under the new arrangement, to leave with 6 months' notice.
Wednesday was yesterday. Order. Order. A little order, please. The Honourable Opposition House Leader.
Yesterday, the Prime Minister had the chance to respond to Canadians, do the right thing, and move Tory Stafford's killer back behind bars. He had a chance to speak out against this terrible decision and act to reverse it. Instead, he did what he always does when he's challenged. He acted like a bully and he called us names. But in doing so, he rejected the calls from Canadians and indeed from Tory's family to correct this injustice. So when will the Prime Minister stop acting like a bully, stop calling names, do his job, and reverse this terrible decision?
The Honourable Minister of Social Development.
Thank you, Mr. Speaker. Our hearts go out to the family of Tory Stafford for the loss they have endured and have lived with in the last 9 years. The Corrections and Conditional Release Act makes individual placement decisions of inmates the responsibility of corrections staff, not politicians. The Minister of Public Safety has asked the new Commissioner of Corrections to fully review the placement decision in order to ensure it was compliant with all correctional services policies and to make sure these policies are adequate.
Opposition House Leader.
Mr. Speaker, Tory's dad couldn't have been clearer. He wants the Prime Minister to reverse this decision. We all want action. Now, Mr. Speaker, the Prime Minister could immediately implement a broad policy which would make sure that no child killer is placed in a healing lodge. That would include McClintock and anyone like her. It would be a broad policy. It would be very simple. It would satisfy the concerns that the government has. So again, will the government do their job? Will they act? And will they reverse this decision with a broad policy?
The Minister of Social Development.
Thank you, Mr. Speaker. Our thoughts are with Tory Stafford's family for the suffering and the grieving they have suffered over the past several years. Under the legislation, any inmate placement decisions are the responsibility of correctional services, not that of politicians. The minister has been asked to review, the minister has asked the commissioner to review policies and decisions to see if these policies can be improved in any way. The honourable member for Jonquière. Mr. Speaker, for 4 months now, the United States have been imposing customs tariffs on 10% of aluminum imports and 25% on steel. Prices are going up and orders are going down. What is the result? Profit margins are going down. Throughout Canada, thousands of people could lose their jobs. Working men and women were hoping that the new NAFTA negotiations would get rid of these customs tariffs. Why has the government signed a new trade agreement with no assurances that these tariffs will be eliminated?
Minister of Transport.
The Honourable Minister of Transport. Mr. Speaker, I want to reassure Canadians that we continue to discuss tariffs, those Section 232 tariffs, with the United States. Our position is firm and clear. These tariffs are not justified. The agreement is yet another is more proof that we put workers at the top of our list of priorities, and we ourselves impose $16 billion worth of tariffs on the United States. We have fought for Canadians at the negotiating table, and we will continue to fight against these tariffs for steel and aluminum workers. The honourable member for Jonquière. Mr. Speaker, it's Quebec SMEs that process metal, and they have been hard. In my Saguenay-Lac-Saint-Jean region, working men and women are wondering if they'll still have a job. Thousands of families are living in uncertainty. This is a position that no one wants to find themselves in. Quebec produces 90% of the aluminum that is exported to the United States. The Trump administration must withdraw those customs tariffs on aluminum and steel. When will this government come forward with the plan? The Honourable Minister of Transport. Mr. Speaker, as I said, we also are fighting against these tariffs that are completely unjustified and that were imposed by the United States based on national security, which makes no sense. Canadians and Quebecers in the aluminum industry know that we are fighting against these tariffs. They know that we also imposed, in retaliation, $16 billion worth of tariffs, and we know that we are here to protect them because we know how important these aluminum and steel industry workers are.
Every single day, workers in Windsor-Essex and Ontario have to face the fact that this government has abandoned them. Failing to get steel and aluminum exempted from U.S. tariffs in the new USMCA deal is clear proof that this government doesn't care about Canadian workers. Experts have said it doesn't make sense to make an agreement where there would be a tariff on a particular good. What do Liberals have to say to the tens of thousands of families whose livelihoods have been left on the line because of their failure to get an exemption?
The Minister of Transport.
Mr. Speaker, I believe that Canadians understand the very strong position taken by this government against the United States tariffs imposed on aluminum and steel. They know that we are there to protect them. They know that we are there to provide protection while these tariffs are on. They know that we have imposed counter tariffs of $16 billion on these 232 measures, which are completely unjustified. Canadians know that this government is there for them.
Honourable member for Essex.
A strong position would have not been to leave the table without those tariffs removed. Do the Liberals not realize that we are talking about tens of thousands of jobs jobs in small shops across our country. While the big players are painfully weathering this storm, small shops are fighting to keep their doors open. While Liberals keep bragging about the USMCA, we're talking about small businesses and shops that are drowning under these tariffs. The NDP has called on the government to strike a national tariff task force to help with this urgent situation. Will Liberals agree to the task force to help small business, or have they turned their backs on them too?
Honourable Minister of Transport.
Mr. Speaker, I'm always somewhat baffled by the NDP position. If I'm not mistaken, the NDP doesn't really want us to go ahead with USMCA, and yet they have all sorts of comments to make about it. Strike some task force, do this and do that. The fact is, we care about the Canadian population and the future of our trade with our neighbours to the south. We now have over $2 billion per day of trade with our southern neighbours. This is good for Canada, it's good for our economy, and I wish the NDP would change its mind about trade agreements.
The Honourable Opposition House Leader.
Mr. Speaker, I bring great news from my home province of Manitoba. Yesterday, our Premier Brian Pallister announced that Manitobans will not be subjected to the carbon tax. Manitoba abandoned the Liberal carbon tax plan and came up with its own green plan after the Prime Minister's arrogance and Ottawa knows best attitude. Manitoba has made it clear, and so has a number of other provinces across the country. A carbon tax does not work, and it costs Canadian families. So, will the federal government respect the provinces, and will they finally abandon this terrible carbon tax?
The Honourable Minister of Intergovernmental Affairs.
Mr. Speaker, our government respects the provinces. That's precisely why we committed in the Pan-Canadian Framework, signed by the Government of Manitoba, to work with provinces to design a real climate plan to deal with the real threat that climate change poses to all Canadians. We regret very much that the Government of Manitoba has decided to pull out of the plan that they had previously submitted, which put a price on pollution. They obviously think that pollution should be free. And, Mr. Speaker, we don't agree with this flip-flop from the Government of Manitoba.
Hear, hear. Honourable Member for Edmonton Wetaskiwin.
Well, Mr. Speaker, Manitoba joins a growing number of provinces in saying a firm no to a national carbon tax. The Liberal carbon tax plan is clearly in shambles, and the minister can't even tell us by how much her tax will reduce Canada's greenhouse gas emissions. Experts on all sides are now saying that the Prime Minister's plan is nowhere near meeting his international commitments. So my question for the minister is clear. Will she confirm today that her government will not meet its Paris Agreement emissions targets?
The Minister of Environment.
Thank you, Mr. Speaker. I'm so excited to hear the party on the other side actually talk about targets, actually talk about climate change. Maybe they should accept that pollution isn't free, that there's a cost, and actually we're seeing the cost from coast to coast to coast with extreme weather events. There's also a $26 trillion opportunity. So I can't wait to see the Conservative Party's plan to tackle climate change, to meet the Paris Agreement, and to put a price on pollution.
Order. The Honourable Member for Calgary-Mindapore.
Mr. Speaker, the Prime Minister arrogantly believes that he can deal with the pollution problem through another tax. But now another province is telling him that he is on the wrong track. The provinces know that families cannot afford this, and even the Liberals know that industry can't afford this. Now that Manitoba is rejecting the carbon tax, will the Prime Minister abandon his plan to tax struggling families? The Honourable Minister for Intergovernmental Affairs. Mr. Speaker, as I said a few moments ago, we regret the decision of the Manitoba government to withdraw from a plan that would have put a price on pollution. We think that Canadians know that their government should be working with provinces to tackle climate change. And Canadians also know, Mr. Speaker, that if Manitoba does not have a plan that meets our commitments from 2 years ago, well, then a federal plan will be applied. And we are going to reimburse that money to the residents of that province.
For Brandon Souris.
Mr. Speaker, we know that people who will be hardest hit by this tax are families and seniors who are struggling to exist, and part of that is because the Liberals have given large emitters an exemption from their own tax. no targets, bullying. Those are some of the reasons why Manitoba has joined the growing list of provinces that are rejecting the Liberals' job-killing carbon tax. Will the Prime Minister finally admit that his national carbon tax is a failure and drop this tax hike once and for all?
Minister of Environment.
Mr. Speaker, we have a plan to protect our environment, to take action against climate change. Why? Because Canadians expected it. They voted us in to grow the economy and tackle climate change. Unfortunately, the party opposite doesn't get it. We're back in the Harper era where you think that you can't grow the economy and you can't protect the environment. Well, we're going to do both. We're going to continue acting. We're going to recognize there's a cost to pollution. We're going to continue creating jobs and growing our economy.
Order. The honourable member for Provencher.
Mr. Speaker, the Prime Minister's carbon tax is just another example of a Liberal failure. My province of Manitoba is the latest to stand up for families that just can't afford another tax. And in fact, the Prime Minister acknowledges that industry can't afford it neither. The BC LNG project was only announced after the Prime Minister exempted them from paying this carbon tax.
There you go.
Will the Prime Minister cancel his carbon tax, or will he insist that hard-working middle-class Canadians pay this tax?
There you go.
The Minister of Environment.
Mr. Speaker, you know what failure is? Failure is not recognizing that there is a price on pollution.
Order. Order. Members, I know we'll want to hear both the questions and the answers, and I would ask them to restrain themselves. I know they're able to. I have great confidence that members are able to act like adults and restrain themselves. The Honourable Minister of Environment has the floor.
Mr. Speaker, you know what failure is? Failure is not recognizing that there is a cost to climate change, and we're paying it right now. You know what failure is? Failure isn't recognizing the $26 trillion opportunity. We're not going to fail. We're going to continue growing our economy. We've created more than 500,000 jobs. We have the fastest growing economy in the G7. And you know what? Our emissions are going down. You can do both. I only wish the party opposite would recognize that climate change is real.
Member for Selkirk Interlake Eastman.
Thank you, Mr. Speaker. And only a Liberal would believe that taxing everything would actually grow the economy. Yesterday, my Premier, Brian Palliser, announced that he's standing up for Manitobans by saying yes to Manitoba's Green Plan and no to the Liberal carbon tax. Millions of Canadians are rejecting the Prime Minister's tax on everything. And why? Because family and industry simply can't afford it. When will the Liberals finally do the right thing, respect provincial jurisdiction, and axe the Liberal carbon tax?
The Honourable Minister of Environment.
Mr. Speaker, it seems only a Conservative would believe that you can't tackle climate change and grow the economy. When are they going to get with the program? That you can grow the economy, that you can create good jobs, that you can invest in innovation, that you can have innovation here creating solutions that we can export abroad, creating good jobs. And at the same time, you know what? We can ensure a more sustainable future for our kids. We're going to continue doing what Canadians expect. Grow our economy, tackle climate change, protect our environment, create good jobs for Canadians.
The Honourable Member for Saint-Hyacinthe-Bacotte. Mr. Speaker, the agreement signed by the Liberals is sowing discontent throughout the country. Yvon Boucher, president of the dairy producers in Montérégie-Est, told me how angry producers are for having been duped by a government that broke yet another promise. Under this bad agreement and all the preceding breaches, dairy producers will be losing every single year a month's worth of wages. Would the Prime Minister or any member of his government, or anyone for that matter, say that they had signed a good agreement if they were going to be losing a month's wages?
Honourable Minister of Agriculture.
Thank you, Mr. Speaker. And as I said many times in this House, we are the party that implemented supply management, and we are the government that did defend supply management. It's important to note that the American government indicated quite clearly at the beginning of these negotiations that their desire was to destroy the supply management system. We made sure that did not happen. Mr. Speaker, we will fully and fairly compensate our farmers and make sure they continue to succeed. Also, the Prime Minister met with the farmers today, with the dairy sector, and I met with many of the supply management sectors across this country. Thank you.
The Honourable Member for Berthier-Masquinongé. Order, please. Mr. Speaker, since the new NAFTA was signed, I have received many emails from young dairy producers from our riding who are worried. They're worried about their future, given this new breach. This 4% concession is on top of the CETA's 3% concession and the TPP 3.25%. Dairy producers and the new generation of agricultural producers are very, very disappointed about having been sacrificed once again by the Liberal government. How can this government say in this House to these young producers that they signed a good deal for them, because it's not true?
Secrétaire parlementaire.
Honourable Parliamentary Secretary. Mr. Speaker, we fully support our dairy producers, their families, and their communities. And it was the United States' intention to destroy supply management, and we are the ones who protected it. This agreement will provide access to the market, but it will protect the supply management system. It has not been jeopardized, and we will always support our dairy producers. And the Prime Minister had a good meeting with dairy producers this morning.
For Halliburton, Kawartha Lakes, Brock.
Mr. Speaker, for Canadian families who depend on the oil and gas sector, every day counts, as they are left in limbo by a Prime Minister who has failed, yet again, to deliver a real plan to get the Trans Mountain Pipeline built. The only plan this government has is to bury this pipeline in so many delays that it never gets built. When will the government take this seriously, appeal the federal court ruling, and request a stay of the decision so that the construction process can begin now?
Honourable Parliamentary Secretary to the Minister of Natural Resources.
Thank you, Mr. Speaker. We share the Federal Courts of Appeal's view that we can and must proceed by engaging in a specific and focused dialogue with First Nations that are involved in this project. That is exactly what we intend to do. Let me be very clear. We are not starting over. We are building on the relationships that we have, the information that we have gathered, and the consultations that we have done to date. We know it's worth taking the time to get it right together, and that is the only way that we can move forward.
Member for Halliburton, Kawartha Lakes, Brock.
Thank you very much, Mr. Speaker. The Prime Minister thinks he's fooling Canadians with his so-called plan for the Trans Mountain Pipeline, a consultation to find out how to consult. Canadians know a real plan when they see one. Sticking your head in the ground and crossing your fingers is no plan. When will this government snap back to reality, start consultations immediately, and ask for a stay in this decision to finally get shovels in the ground to start construction on the Trans Mountain Pipeline?
Honourable Parliamentary Secretary.
Mr. Speaker, we will take no lessons from the Conservatives. For 10 years, they have not built one pipeline to new markets. Canadians know now more than ever we need to get our resources to market. For them, consulting with First Nation is a suggestion and not a constitutional obligation. For them, climate change is not even real. Mr. Speaker, we respect the court's decision, and we will take the path that it has provided us.
Thank you, Mr. Speaker.
Member for Edmonton Riverbend.
Mr. Speaker, plain and simple, the government bought an expensive pipeline they can't even get built. If the Liberals had any intention on getting the pipeline built, they would have begun consultations and appealed the decision. Clearly, the member from Edmonton Mill Woods is incapable of standing up for hard-working Albertans. Will he finally admit that all this has just been a delay tactic on an economically vital project for Alberta?
Honourable Parliamentary Secretary.
Mr. Speaker, we believe that getting it right and in consulting and respecting the decision for the Federal Court of Appeal is the way to move forward. For the Conservatives, they disregard Federal Court of Appeal decisions. They disregard consulting with First Nations. Their record speaks for itself. For 10 years, not one pipeline was built to new markets. They could not get it right. We will do it the right way. That's what Mr. President.
The Honourable Member for Grand Prairie Mackenzie.
Well, the member across the way is new here, but he's totally wrong. There was 4 major projects that got oil and gas to new markets, and if the Liberals would do one thing, it would be to take a lesson from us, because ever since they took control of this pipeline, they've ended all work on the pipeline. They sent Kinder Morgan packing with $4.5 billion of taxpayers' money so that they could build pipelines in the United States. this last week, the minister from Alberta, the Minister of Natural Resources, announced additional delays that are going to kill this project. When did the minister decide to betray Alberta and kill this pipeline?
Parliamentary Secretary.
Mr. Speaker, let's look at the Conservatives' record on pipelines. When they took office in 2006, 99% of our oil exports went to the United States. Flash forward to 2015, 99% of oil exports still go to the United States.
Oh, great job.
The Conservatives had 10 years to expand the global markets. They did not do so. Why? They did not respect First Nations. They did not respect the court's judgments. And at the same time, they did not respect the environment. To move forward, we need to do it in the right way, take the time that is needed, and ensure that we move forward in a meaningful way.
The Honourable Member for Longueuil-Saint-Hubert. Mr. Speaker, Netflix has announced a permanent office in France. They're going to be doubling their investment in French production. They'll even be paying taxes and collecting sales tax. They'll take 2% of their revenues for film production, and 30% of their content will be European. What a crazy, revolutionary idea. The French asked Netflix to respect their culture and pay their fair share. Will the new Minister of Heritage do his job, put an end to special treatment, and even get commitments from Netflix to create here? The Honourable.
We'll always be there for our artists and creators, and that's exactly what we've demonstrated through our cultural policy last year. We've made historic investments of $3.2 billion in the cultural sector, including in the CBC, the Canada Council, Telefilm, and the NFB. Due to the previous government's inaction, our culture laws predate the internet, which is why we're reviewing them so that they continue to support high-quality Canadian content production. The principle of this review is clear. If you participate in the system, you will contribute to the system. There will be no free ride. Thank you, Mr. Speaker.
The Honourable Member for Sherbrooke. Mr. Speaker, 90% of CRA experts state that it's easier for the rich to escape their fiscal responsibility than average Canadians. These are experts from the agency, and they say 90%. This is a total failure for the Revenue Minister in her so-called fight against tax evasion. In her ivory tower, she thinks everything is working. Will the minister today contradict 90% of her own employees, or say that the Liberals have always favored the rich and Liberal friends?
Parliamentary Secretary to the Minister of Revenue.
Thank you, Mr. Speaker. Unlike the Harper Conservatives, fighting tax evasion in Canada and abroad is a priority for our government. We have made historic investments in the CRA for the fight against tax cheats. We have fully adopted the international standards for automatic information exchange with our partners in the OECD, which gives the CRA useful data to help fight tax cheats even more effectively. The CRA is able now to assess the risk of 100% of our large multinational corporations annually, and is better able to identify taxpayers who participate in a...
Honourable Member for Sackville, Preston, Chesterfield.
Monsieur le Président. Mr. Speaker, in official language minority communities, community media play a very important role, whether it's sharing news, local news, or for expressing cultural identities. It's extremely important, and it is for this reason that the Minister made a very important announcement today. This has to do with the community media in official language minority communities. Can the Minister please share with the House what will happen? The Honourable Minister. Thank you, Mr. Speaker, and I thank my honourable colleague for his excellent question. Our minority language communities are very important for us, and to have strong communities, they need to have newspapers and media that serve them. Right now we have responded to their needs by saying, ready, I ready. We will be investing $140 million in media for official language minority communities. Thank you, Mr. Speaker.
Member for Parry Sound, Muskoka.
Speaker, yesterday the Liberals voted
against our Conservative motion to put 8-year-old Tory Stafford's killer, Terry Lynn McClintic, back behind bars. Also yesterday, though, Tory's father, Rodney Stafford, visited Ottawa and gave several media interviews in which he asked the Prime Minister to reverse the transfer of his daughter's killer. Will the Public Safety Minister and the Prime Minister listen to Tory's father and the outrage of Canadians and put McClintic back behind bars?
Secretary to the Minister of Public Safety.
The loss and pain that the family of Tory Stafford have suffered, it's heartbreaking, Mr. Speaker. Section 28 of the Corrections Act says that inmate placement decisions must be made by correctional services. Parliament decided that this power does not belong to a minister. However, the Minister of Public Safety asked the Corrections Commissioner to do a review, ensure that policies and procedures were followed, and that those procedures remain appropriate. Thank you, Mr. Speaker.
Honourable Member for Parry Sound, Muskoka.
Mr. Speaker, Parliament actually has opined under Section 6 of the Act that the Corrections Canada officials have to listen to the minister, Mr. Speaker. Before, under the Conservatives, Tory Stafford's killer was behind bars. Under the Liberals, she was moved to a healing lodge. And yesterday, Rodney Stafford, the father of Tory, made an impassioned plea to the Prime Minister to put his daughter's killer back behind bars. He said, I want to see if I could kind of touch him a little. It's not about politics. Will the honourable members listen to Tory's father immediately and put Terry Lynn McClintic back behind?
Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. We do understand the loss and pain that Tory Stafford's family has gone through all these years. But it's important to understand the powers that have been vested in this Parliament by Parliament. Former Harper PMO lawyer Benjamin Perrin said, "This may be unpopular to voice, but I'm concerned with politicians being the ones who decide how any particular individual offender is treated." Thank you, Mr. Speaker.
The Honourable Member for Beauport, Côte-Beaupré et d'Orléans-Charlevoix. Yesterday, during question period, the Prime Minister asked us to listen to Tory Stafford's family, and we've been doing that since the beginning of this debate. We are listening to the family, and we are their voice in this House. Tory's father wants this criminal who so horrifically took his daughter's life goes back behind bars. Why are the Liberals continuing to defend the indefensible while they should be defending and listening to the victims of this heinous crime? The Honourable Parliamentary Secretary.
Section 28 of the Corrections Act says that inmate placement decisions must be made by corrections services. This act was created in 1992 by a Conservative government. As much as he might like to, the Minister of Public Safety cannot simply overrule laws, including the ones created by Conservative governments. Thank you, Mr. Speaker.
Honourable Member for Chilliwack Hope.
The Prime Minister said that we shouldn't try to guess what Tory Stafford's family wanted when it came to putting her killer back behind bars, but we don't have to. Tory's father said yesterday somebody clearly messed up, made a mistake, and I'm just trying to get this mistake reversed. Yep. Tory Stafford's killer was moved from a prison to a healing lodge under this Prime Minister's watch. Now, the Prime Minister can run, but he can't hide from his responsibility. Yeah. So why doesn't he finally do the right thing today and fix this mistake?
Yeah. Honourable Parliamentary Secretary.
Mr. Speaker, that particular inmate was reclassified from a maximum security to a medium security under the previous government. Mr. Speaker, we believe that we have the correctional services who are in place. They are the professionals. They are the ones who know these cases. And to discuss this in an individual base in this place is not appropriate. Thank you, Mr. Speaker.
Honourable Member for Desnethé, Mississippi, Churchill River.
Mr. Speaker, Marie Trottier is a Métis elder from Buffalo Narrows who this week shared her
experience with me of just how expensive medical care is for elders in my riding. Like Murray, too many northern elders and seniors have to pay to get to a hospital in the city. They have to pay for hotels, meals, and for their prescriptions. This is unacceptable. Why is the Minister of Seniors proud of the work she's done when so many Northerners are being left behind?
Minister.
Thank you, Mr. Speaker, and I'd like to thank the member for the question. This government has invested $2 billion in rural and northern communities, which includes projects that support food security, local roads, renewable energy, and enhanced broadband connectivity. We have also made the New Horizons for Seniors program more flexible, and this program is directed at combating isolation. It also helps to promote exercise and activity. Mr. Speaker, we've also automatically enrolled for GIS recipients. 210,000 seniors are now receiving benefits. Mr. Speaker, we're going to continue to work for our seniors to ensure that they are appreciated and included in our...
The honourable member for Hamilton Mountain.
Mr. Speaker, this summer the Prime Minister appointed a Minister of Seniors with the mandate to conduct hearings into protecting workers' pensions. So far, Canadian workers and retirees have heard nothing. The Liberal rank-and-file passed a motion at your convention to fix Canada's flawed bankruptcy legislation. A Liberal senator introduced a bill to do the same thing. On my cross-country pension theft tour, Canadians made it clear they expect this government to fix this problem. Why is this minister refusing to listen to Canadian workers and retirees?
For seniors.
Speaker, pension security is very important to our government. That's why the first time in 20 years we increased the CPP so that security will be given to those retirees. Also, Mr. Speaker, as the honourable member knows, he's speaking about workplace pensions. Our government has committed in the 2018 budget to consult with stakeholders on this issue, and I am delighted that this is also included in my mandate letter. The member knows, and all members of this House know, this is a decades-old problem, and our government is going to consult in order to get this right, in order to protect our pensioners.
The honourable member for Lévis-Lotbinière. Mr. Speaker, delays in hearings for asylum seekers, they're just getting worse. Yesterday we learned that an asylum seeker in Montreal was told to come to a hearing for his application on, believe it or not, January 1st, 2030, which is also a statutory holiday 12 years from now. Mr. Speaker, the government's ridiculous management on this file, it just is ridiculous. When will these files be dealt with in a reasonable time?
Yeah, Mr. Speaker, I rarely get the opportunity to stand up and correct a typographical error, which was the case in this matter. But, Mr. Speaker, it's rather ironic that after a $400 million cut in CBSA, our government has been working diligently to restore Canada's capacity to deal with asylum seeker claims in a timely way, including making a significant investment of some $72 million to restore CBSA's capacity to deal with removals in a timely way. Mr. Speaker, we're working diligently to uphold and to ensure Canadian law is applied properly, as well as Canadian humanitarian principles.
The honourable member for Lévis-Lotbinière. Mr. Speaker, everything points to these delays just going on and on. Now that we know that illegal migrants will be living forever in hotels at our expense and without the Liberals caring, Mr. Speaker, will Liberals force Canadians to pay for hotel rooms for 12 years in order to deal with the files of illegal migrants, and this being paid for by Canadian taxpayers? The Honourable Parliamentary Secretary. Mr. Speaker, we have a plan, and the plan is working. We have seen a reduction in border crossings over this year over last year. Conservatives are continuing to politicize this matter by spreading disinformation, and they cut almost $400 million from government bodies responsible for managing this sort of problem. I find it rather surprising that they have the nerve to stand up and say things aren't working.
Cardston Warner.
Mr. Speaker, Liberals have repeatedly misled Canadians saying illegal border crossings are under control, that everything's fine. But hundreds of millions of dollars later, we still have people crossing illegally into Canada. The Minister in charge of border security has clarified that less than 1% of these illegals have been removed. Now we're learning an asylum seeker had their hearing scheduled for 2030. 2030. What is the minister planning to do to stop illegal border crossings, and does he expect taxpayers to foot the bill for his failures until then?
Yes. Minister.
Thank you very much, Mr. Speaker. I'd point out once again that during that Harper decade, they cut $400 million from the CBSA and made significant cuts to the government's ability to deal with asylum seekers. We're restoring that capacity to deal with these in an effective way. We've made significant investments to work through the existing backlog, and the typographical error the member refers to has already been clarified.
The honourable member for Dorval-Lachine-Nassau. Mr. Speaker, today we're celebrating the first day of the torch. The Olympic Canadian Games torch is starting its journey and will go through 40 communities in the country.
Athletes in 2019. Can the Minister of Science and Sport tell us more about this great event?
Mr. Speaker, thank you to my colleague for an excellent question about sport and youth. Today on Parliament Hill, we gathered to light the Canada Games torch. In February 2019, youth from coast to coast to coast will gather in Red Deer, Alberta. They will compete in curling, hockey, speed skating, and many more sports. Sport builds healthy lifestyles, self-esteem, and memories that last a lifetime. Nous sommes très fiers d'appuyer les jeunes.
We're very proud to support the Canada Games.
Canberra.
Mr. Speaker, rural municipalities across Ontario depend on mail-in ballots for their local elections. The latest contract offer from Canada Post has been rejected by its union. Canada Post has told election officials it doesn't have to honour the contracts to have the ballots delivered before Election Day. Will the Prime Minister direct Canada Post to have the ballots delivered by taxpayer-owned Purolator before the election?
Yes. Honourable Minister of Employment and Labour.
Mr. Speaker, as we said time and again, our government, unlike the party opposite, respects the collective bargaining process and believes in the ability of parties to work together to renew their collective agreement. I have mediators from federal mediation working closely with both parties. The talks continue. We're monitoring the labour negotiations, and we continue to stand by the parties with mediation assistance. Thanks, Mr. Speaker.
Honourable member for Victoria.
Patricia Kidd from Victoria was married to her husband Pete, a naval surgeon, for 31 years. They raised 2 sons and loved each other until the day Pete died in April 2016. Yet Patricia isn't getting a penny of his pension as the Liberals continue to deprive veteran spouses of benefits if the veteran they marry is over 60. The minister keeps telling me this is a top priority, but these widows are still waiting. Mr. Speaker, will the Liberals immediately eliminate the archaic over 60 clause so widows like Patricia can finally get the pension they deserve?
Minister of Veterans Affairs.
Thank you, Mr. Speaker, and I thank the honourable member for the question. And indeed, in the many town halls that I've done right across this country, this is something that has come up time and time again. I know that it is important to many veterans and to many of their families, and I can assure that member and this House that we are indeed working diligently on this file. Thank you very much, Mr. Speaker.
The honourable member for Saint Louis.
Members of my youth council and I went to visit the shore of my riding looking for plastic debris. Fortunately, owing to the vigilance of our local municipal authorities, our cleanup effort was a light one. However, like all Canadians, my constituents are growing more and more concerned about plastics in waterways. Can the Minister of the Environment tell us what she is doing to implement our commitment to reducing plastic waste in federal institutions and also generally across the country so we do not have to worry about plastic pollution in our waterways?
Honourable Minister of Environment.
I'd like to thank the member for Saint Louis for his question. I'd also like to thank the members of his youth council for stepping up and tackling one of the biggest challenges our time, plastic pollution. oceans, our lakes are literally choking in plastic pollution. If we don't take action now, we will have more plastics by weight in our oceans than fish. We know we need to take action. We stepped up at the G7. We have countries and businesses who have stepped up to sign our Oceans Plastics Charter. We've also committed to eliminating single-use plastics in government operations. We're investing in innovation. We're developing a national zero-waste strategy, and we owe it to our kids.
The Honourable Member for Beauport-Limoilou. Mr. Speaker, since the unfortunate episode in 2012 of red dust emanating from the Quebec City Harbour, citizens are very concerned about the quality of air in Limoilou. For some weeks now, we've had preliminary results with respect to the quality of air in this sector because of a study by municipal authorities. I'd like to know what the government intends to do about this concern on the part of the people of Limoilou. The Honourable Minister. Thank you, Mr. Speaker. I'm very happy. I'd be very happy to speak with the member about this issue. The Honourable Member for Repentigny. After a meticulous investigation, Bruce Campbell, a researcher, confirmed that justice has not been done for the Lac Mégantic victims. Not only have those responsible for the tragedy not been sanctioned, but we learned that the original version of the report was fiddled with before being made public. All this because of political pressure from the Transport Minister, Industry and the government. Will the government confirm that there has been political interference in the drafting of the TSB report and make public the original reports? Mr. Speaker, there was no interference. I'd like to say once again that the Transport Safety Board looked very carefully into what happened in Lac Mégantic. There have been many recommendations, some addressed to the federal government, and which we are now implementing. There were trials. This lasted 5 years, and I would also add that there are many people in Lac Mégantic who don't want to have to relive these past 5 years. The report was fulsome and the file is closed. The Honourable Member. This is extremely serious, Mr. Speaker, because the people in Lac Mégantic want to see the public report or the public study. From what we have learned from Mr. Campbell, the Transport Safety Board is not at all independent. The government, just like the rail industry, are putting pressure so that these reports will not criticize them. The government has to take things seriously right now. When will the government do justice for the people of Lac Mégantic and begin a truly independent investigation? The Honourable Minister. Mr. Speaker, I regret this performance on the part of my colleague. The file will be studied in depth, and I would say once more that rail safety is my first priority. I've been working on this file for 5 years, and we have completed all stages in this investigation. This is extremely disagreeable, all this for the people of Lac Mégantic. They don't want to relive it. The Honourable Member for Beauce. The Prime Minister said that farmers under supply management will be to such a degree compensated for extra tariffs to please the Americans. So it seems we'll be helping them produce while preventing them from exporting. So are they going to buy back quotas, put an end to supply management, and allow farmers to innovate?
Indicated clearly in this House and many times, our party implemented supply management, and we're the government that defended it. Also, Mr. Speaker, it's important to note that the American government wanted to make sure that the supply management system was destroyed. We made sure that would not happen, Mr. Speaker. Also, Mr. Speaker, we will fully and fairly compensate farmers and make sure they continue to seed. We have and will continue to support the supply management system in this country. Thank you, Mr. Speaker.
I would like to draw to the attention of honourable members the presence in the gallery of the Honourable Wade McLaughlin, Premier of the province of Prince Edward Island. And now I believe the honourable member for Chilliwack, for that, the honourable member for Edmonton West is rising on a point of order.
Mr. Speaker, I'd like the House's permission to table a document. It's the most recent Transportation Safety Board of Canada document. And why, you ask? Well, I want to read the departmental results states their goal is transportation system is safer. And all 3 years since the Minister of Transport has taken over the job, they say it has not been met, and our rail safety is less safe, which defies and goes against his comment that it is the #1 priority. It is not.
Does the honourable member have unanimous consent of the House to... no, there is no unanimous consent. The honourable member for...
The honourable member for Repentigny on a point of order. Yes, Mr. Speaker, you will see that there will be unanimous consent of the House to table the book by Mr. Campbell, which will shed new light on Lake Megantic and which describes the actions by all people involved in this terrible accident. I believe that the honourable member knows that it's not possible or allowed to use props. So I would ask her not to use props henceforth. Oh, she's asking for unanimous consent of the House. Is there unanimous consent of the House to table the book, the document?
Usual Thursday question from the honourable member for Chilliwack HoC.
Well, thank you, Mr. Speaker. On behalf of the Leader of the Opposition in the House of Commons, I first of all would like to wish everyone a happy Thanksgiving week in their ridings, and I would like to ask the Leader of the Government in the House of Commons what business will be brought forward for the rest of this week and for the week following our week in our ridings next week.
Government House Leader.
Mr. Speaker, this afternoon we will continue debate at second reading of Bill C-78, the Family Law Act. Tomorrow, we will undertake debate at third reading of Bill C-79 on the Trans-Pacific Agreement. The next week, members will work in their respective ridings. When we come back, we will undertake a debate on Senate amendments to Bill C-65, the Harassment Prevention Act. After that, priority will be given to the following bills: C-77, the Victims' Declaration of Rights, and C-82, the Multilateral Convention to Implement Tax Treaties Act. Finally, I'd also like to take this opportunity to wish everyone happy Thanksgiving. Thank you, Mr. Speaker.
Ordre du jour.
Orders of the day.
Government orders, government bills. Commons resuming debate at second reading stage of Bill C-78, an Act to amend the Divorce Act, the Family Orders and Agreements Enforcement and Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act, and to make consequential amendments to another act.
Oh, I see. Resuming debate, the honourable member for Mount Royal.
Thank you, Mr. Speaker, and it's a pleasure to rise today to speak to Bill C-75, which aims to strengthen our family's justice system by amending 3 federal laws: the Divorce Act, the Family Orders and Agreements Enforcement Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act. As colleagues in this chamber have noted, the reforms proposed in Bill C-78 would represent the first substantive reforms to our federal family laws in over 20 years. And I think we can all agree that this change is long overdue. La séparation et le divorce.
Separation and divorce affect millions of Canadians. We all know that the breakdown of a marriage can be difficult for families and particularly for children.
Ensuring that to the extent possible, federal family laws protect families from the negative consequences that too often arise in situations of separation and divorce. Mr. Speaker, as I have followed the debate on Bill C-78, I have been pleased to hear the expressions of support from colleagues on all sides of the House for the key objectives of this legislation, namely promoting the best interests of the child, addressing family violence, helping to reduce child poverty, and making Canada's family justice system more accessible and efficient. It looks, Mr. Speaker, that when this bill comes to the Standing Committee on Justice and Human Rights, there will be a very collegial approach to making sure that we improve this bill in the best possible way, but actually work together to improving our family law system. As the Minister of Justice has emphasized, Bill C-78 is really about putting children first. The proposed changes to the Divorce Act reaffirm that the best interest of the child is the only consideration in relation to parenting arrangements, and the bill proposes several changes to further support this fundamental principle. Les modifications proposées.
The proposed modifications include an comprehensive list of criteria to determine what constitutes the best interests of the child.
A primary consideration to the best interests of the child test, which would require courts to consider elements crucial to a child's life, including physical, emotional, and psychological safety, security, and well-being above all other considerations. Among other factors, the best interest of the child criteria would require courts to consider a child's views and preferences, giving due weight to the child's age and maturity. Ce facteur est conforme.
This fact is consistent with the UN Charter on the Rights of Children, the right to participate in decisions that have an impact on their lives, and to enable them to provide their opinions based on their age and level of maturity.
We've all seen in our own lives areas where there's been a dispute over child custody, and too often the voice of the child has been ignored. Now, under our law, as soon as this bill is adopted, the voice of the child predominates. Bill C-78 would also require judges to consider a child's linguistic, cultural, and spiritual heritage and upbringing, which includes Indigenous heritage, something that is currently absent from the Divorce Act, but is obviously necessary to take into account when making decisions about a child. For example, should a child come from both the English and French-speaking communities, it is essential that the child learn both languages and the culture of both communities. The same is true when one of the parents comes from an Indigenous community. To strip the child of their heritage would be an unfortunate mistake, and now the law will ensure that that is taken into account. Given that the best interest of the child is the only consideration in making decisions about parenting arrangements for a child, Bill C-78 would not create parenting presumptions in the Divorce Act. The bill would include a modified maximum parenting time principle, requiring courts to ensure that a child has as much time with each spouse as in the child's best interests. Time with parents fosters a child's social, emotional, and cognitive development, and sufficient time with each parent is necessary to establish and maintain these relationships. However, it is important to note that this provision stipulates that the child should have as much time with each spouse as is consistent with the best interests of the child. Thus, courts would ultimately determine what allocation of time would work best for the child. In addition to the amendments pertaining specifically to the best interests of the child test, Bill C-78 proposes several other reforms that promote the best interests of the child. A key example is the proposed change to parenting language. Les termes garde et accès.
Custody and access will be replaced with terminology that will help to reduce conflict among parents. Bill C-78 also calls for parental orders and other orders which would enable courts to provide clear directives to parents with respect to the care of children.
In recognition of the fact that there are often other people who play a critical role in a child's life. The bill would make contact orders available to non-spouses, such as grandparents. In most cases, parents facilitate contact between their children and other special people in their children's lives during one parent's parenting time. These orders would be available as an option in situations where the parties do not agree to allow this to happen. Of course, contact orders would also be based solely on the best interests of the child, but as we have all seen, Mr. Speaker, and as we have all heard from our constituents, there are tragic incidents where after a divorce, grandparents are not allowed to visit children. Great aunts, great uncles, people who are close are suddenly stripped away of the contact they have had their entire lives. And this will now ensure that those people also have a right to say that they want to have contact with a minor child. Turning now to the second objective of Bill C-78, which is addressing family violence, the government recognizes that family violence is traumatic for children who are exposed to it as direct victims or as witnesses. Increasingly, research is providing important insights into the lifelong effects of childhood trauma, and it is critically important that family violence is appropriately taken into account when decisions about parenting arrangements are being made. In order to provide guidance to parents, courts, and family justice professionals, Bill C-78 proposes a statutory definition of family violence that is based on social science research. It explicitly includes family violence as a factor to be considered in determining the best interests of the child. And it includes an additional set of factors to guide courts in considering the impact of family violence. Finally, it requires courts to inquire about any other civil protection, child protection or criminal proceedings, or orders that involve the parties in order to avoid conflicts between family and criminal court orders. The third objective of Bill C-78, Mr. Speaker, is to help reduce poverty. It has been demonstrated that the sooner a fair and accurate amount of child support is established after parents separate and payments are made, the better the outcomes are for the child. While most parents meet their obligations when it comes both to the establishment and payment of child support, many parents do not provide the complete and accurate income information required by the law to establish support. There are over $1 billion of unpaid child support payments in Canada, and this bill provides additional tools to provinces and territories to ensure those debts get paid. Ceci occasionne des conséquences.
This has serious consequences for families who use the family law system. More than 2 million children from separated or divorced parents live in single-parent homes. These families are more at risk of living in poverty. The risk of poverty following a divorce can be attenuated when parents and children receive the support they need.
Would bring much-needed changes to limit the consequences of income-related disputes on the family justice system, parents, and most importantly, children. Amendments to the Family Orders and Agreements Enforcement Assistance Act would permit the release of income information to courts and provincial child support services to help determine fair and accurate support amounts, and permit the release of income information to courts and provincial enforcement services to help enforce these support orders.
Furthermore, the amendments to the Act concerning garnishment and attachment will allow us to garnish your wages more quickly when it is possible, to ensure that families will receive these sums more quickly.
Middlesex London had said in her speech when she was working as a constituency officer for the former Member of Parliament, this is one of the things that is the most frustrating to MPs and their staffs when we have people who are coming in who are the custodial parent and asking for support where they need it, and having to go through hoops to try to find a way to administratively get to the right amount of custodial payments because the other parent isn't cooperating, lying about their income, etc. Now, at least we can do this in an administrative way and not have to run to court every single time. Finally, Bill 78 includes a number of measures intended to streamline processes to help make family justice more accessible and affordable to Canadians while encouraging family dispute resolution. Afin d'aider les familles canadiennes à résoudre des...
To help Canadian families resolve these conflicts, Bill C-78 would make the amendments to the Divorce Act and the Family Orders and Agreements Enforcement Assistance Acts, and to help with other provisions around children, as well as the Convention of 1976 concerning the competence of the Cooperation Act in terms of parental responsibility and child protection measures.
Horrible cases where a parent has taken a child abroad and the Canadian custodial parent has spent years trying to get their children back. We need to do everything possible to work with international forces to make sure that we allow those parents the best arms to get their kids back to Canada. Monsieur le Président, je veux aussi...
Mr. Speaker, I would also like just to take a moment to speak about something that is very important for me, and that is very important for my colleague from Ottawa, Vanier, who's here today, and for many other members in this House, which is the right to access in terms of access to divorce in both official languages.
Quebec, you want to make sure that access to divorce and access to our courts is available in both languages. Nous avons écouté les représentants.
We have listened to the presentation from the legal experts of the French language of common law and Anglophone legal experts in Quebec, and I would like to propose that the committee should consider amendments to this bill to ensure access to divorce proceedings in both official languages of Canada, to ensure that both the French and English enjoy equal official status in these proceedings under the Divorce Act, to ensure that there is a proper comprehension of both French and English by the legal experts who hear the case or the assistant, and to ensure that the witnesses can testify in their preferred language, and that the definitive ruling should be handed down in both official languages when there is testimony in both languages. But it is very important, Mr. Speaker, to ensure that Canadians of a French language outside of Quebec
in their own language. So that is something, amongst other things, that I know we'll be considering at committee. And in conclusion, Mr. Speaker, we all know how difficult separation and divorce can be for families. I've heard some of my colleagues talk about their own experiences, and in retrospect, there's always things that could have been done better. I know the pain that some of my friends have suffered when they've gotten divorced, and I think when the law gives instruction that we need to focus on putting the best interest of the child first, I think that helps everybody in the picture. So I appreciate this bill, which addresses family violence, which will help reduce poverty, which will make the family justice system more accessible. And I believe that Bill C-78, as put forward by our Minister of Justice and Attorney General, represents significant change that will better support Canadian families. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for Elgin, Middlesex, London.
Thank you very much, and thank you very much for this from the Speaker. I recognize with his legal background, he probably has a great insight on this as well. One of the things that I am curious on is to do with the 40% when it comes to sharing. I personally have sat down with constituents in the past, and we've tried to even block in like a schedule on to figure out and calculate how that is done. What is the the framework of that going to be, and how flexible is that going to be?
The Honourable Member for Mount Royal.
Thank you very much, Mr. Speaker. I think that my colleague, and by the way, I really appreciated what she had to say, and her speaking of her own personal experiences. I think it was incredibly touching, and I think her husband, Mike, is very lucky. With respect to the question in itself, having not practiced family law, I also have only dealt with the situation as a member of Parliament, And I know that there will be flexibility built in, but I know that it is one of the things that we'll be looking at committee, and I know the minister will be there to instruct us about that question. Thank you.
Question et commentaire. Honorable député de Jonquière.
Thank you, Mr. Speaker. I listened attentively to my colleague's speech, and I would like to know that whether for him, once C-78 has gone to committee, I would like to hear his own opinion concerning the addition of criteria to better to define the interest of children in separation. The NDP feels that that the interests of children should be looked at comprehensively. So the NDP wants to put criteria in place, but that list should not be exhaustive because there can be varying factors. We're all human. There are different elements that might come into play. So I would like to hear the opinion of my colleague as to what he thinks regarding this list. Perhaps it should be shorter so that there can be a certain amount of leeway in terms of separation. The honourable member. I'd like to thank my colleague from Jonquière for her excellent question. When the criminal code is amended, this question always comes up. Should something specific be defined? Should a non-exhaustive list be given, or should we leave things open? And I thought that the list that was in the proposed bill is a good list, but it is always important to study that in committee. And given that we work very closely with the member for Victoria, or the member for Saint-Hyacinthe-Bagotte, who is going to represent the NDP on this committee debate, we're certainly going to hear from the NDP on that and take it into account.
Some comments. The honourable member for Ottawa-Vanier.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I'm very pleased to see that the committee is going to study this bill very soon, hopefully, and that there is a lot of openness around enhancing this bill, which is already very well crafted. In Ottawa-Vanier, when it was tabled, I held a round table, and many people in the community and experts came together to say that it was high time that this bill be focused more on children and their interests. And during the time allotted for questions during the roundtable, we saw that there was room for improvement to this bill. And today, my honourable colleague mentioned that in terms of Canada's official languages, there were certain flaws. And apparently there seems to be some openness to improving the bill in this regard. Could my honourable colleague how this might proceed once the bill is going to be studied in committee? The honourable member for Mont-Royal. Thank you very much, Mr. Speaker. I'd like to thank my colleague for her question. It's been a great pleasure to work with her on a number of files, including the rights of linguistic minorities. Naturally, what happens when this bill goes to committee is that we'll hear from witnesses. And we'll hear from witnesses who are going to come from official language minority communities who will be testifying. And our committee will discuss that with the minister and the parliamentary secretary and with all the different parties on the committee to determine whether further improvements can be made to ensure that linguistic minorities have access to divorce courts in both official languages. I realize that I know that it's a priority for our minister, the equality of both official languages across the country. She is making great efforts in this regard, and we'll see what we can do with that.
The honourable member for Peace River, Westlock.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his great speech there. I listened intently. One of the things that I've been looking through this bill, and it really seems to me like the government really has the child at the center of the changes that they are making here. One of the things that I was just wondering about, it's a little bit tangent to this bill, but I was wondering if the member had ever heard of something called the life ladder, and the fact that in order to prevent somebody from living in poverty, if you followed the life ladder, if you graduated from school, if you got a job, and then you got married, and then you had children, you were something like 97% likely to never live in poverty. And I was just wondering if he knows anything about the life ladder, and if he had any comments about that. Thank you.
The honourable member for Mount Royal.
Thank you very much, and it's a pleasure also to work with my friend across the way. Sometimes we have a little bit of a different view on some social issues and some justice issues, but I think on this we find common ground. This is one of these excellent bills where we're finding common ground because we all care about the best interests of the child. And yes, I'm aware that there are studies that show that if life follows a certain path, you have a less chance of having child poverty. We're not a government that is able to dictate or wants to dictate to people how to live their lives and in what sequence they live their lives, but I am certainly aware of the literature that you're speaking of.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
So I thank the member from Mount Royal for his speech and also compliment him for his work as chair of the Justice Committee. He raised something that has not come up to a great extent in the debate thus far, and that was the issue of the provision about parenting and presumptions. It's been raised by at one or two points earlier today by members of the opposition about their concerns that equal parenting was no longer a presumption. And I know the member from Mount Royal does a lot of research before he prepares for any speech or any committee hearings. I wanted to ask him about the Special Joint Committee on Child Custody and Access, which noted in its report in 1998 called For the Sake of the Children that a presumption in favor of a particular parenting arrangement would not likely be in the best interests of a particular child. This bill, as the member knows, looks squarely at the best interests of the child and not at parents at the best interests of the child and treating it in a case-by-case basis. I wonder if he might provide his view and his perspective on how that assists addressing children and their plight in the context of divorce.
The Honourable Member for Mount Royal.
Thank you very much, and I want to thank the Parliamentary Secretary and tell him how much a pleasure it is working with him as our new Parliamentary Secretary. I completely agree with the way the bill approaches the question of maximum parenting time. I think that the presumption that would be created by equal parenting causes problems. While it is, in most cases, certainly advisable that parents both have maximum time, there are certain circumstances, family violence being one, where that would not be advisable at all. And to include the equal parenting time as a cornerstone of the bill, I think will make it more difficult to look at the best interests of the child in each and every unique case, which is why I completely agree with how the bill has framed this. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Peace River Westlock.
Thank you, Mr. Speaker, and it's not often you get to go up twice with the same speaker, so I much appreciate the opportunity to ask another question. One of the things that I've repeatedly heard on this topic is that it's easier in Canada to get a divorce than it is to cancel your cell phone contract, and so I was wondering if the member opposite had any comments to that. It's just interesting. The last question that he was answering was about how the children and being divided up between the parents, but I would say that probably the best case scenario is that the parents would never get divorced in the first place. I wondered if he agreed with me on that. Thank you.
The Honourable Member for Mount Royal.
Well, thank you, Mr. Speaker, and again, I thank my colleague. Certainly, I'm not one to tell a couple whether or not they should get divorced. I mean, I think that would be very intrusive into their lives. What I can say is I've tried to cancel a cell phone contract in Canada, and I found it to be very, very difficult. And I can assure you that from all of my friends who unfortunately have had divorces, their divorces have been far more difficult than canceling the cell phone contract. So that being said, I think we'd all love everybody to live in peace and harmony their entire lives and everyone to be blissful. I just don't think that's realistic. Thank you.
Resuming debate. The Honourable Member for Carlton Trail, Eagle Creek.
Very much, Mr. Speaker, and I'm very pleased to rise today to speak to Bill C-78. This bill amends 3 different acts and modernizes divorce proceedings. There is much in this bill that I am very pleased to see. However, I do believe, as with any bill, there is room for improvement. I hope that my honourable colleagues across the way will be willing to hear and implement helpful suggestions in the same spirit of cooperation that this bill recommends for divorce proceedings. Before I go any further, Mr. Speaker, I will be sharing my time with my colleague from Edmonton, Griesbach. Mr. Speaker, much has changed in the legal realm over the past 30 years, including a growing understanding of the impact that our current legal framework for divorce has on children and their parents. That understanding has led courts toward a less adversarial and more cooperative framework for divorce proceedings. Bill C-78 amends the statute to bring it in line with the prevailing legal thoughts as delineated by our courts. I want to just expand on that. Mr. Speaker, marriage is the societal institution on which our society is built. A key aspect of marriage is the creation of a stable structure in which children can grow and learn. When a marriage dissolves, for whatever reason, it is important that the welfare of the child be placed in the highest priority. I am pleased to see that Bill C-78 has placed an emphasis on children. Bill C-78 makes strides towards the recognition of the rights and considerations of children. An example of this change in focus can be found in the adjustment of the language used throughout the process. C-78 does away with the dichotomy of winning custody versus visitation. The current language creates an adversarial situation wherein one parent is defined as the winner of the proceedings, making the other parent the loser of those same proceedings. C-78 adjusts the focus from a winner and loser mentality, wherein the child is a prize to be fought for, to that of parenting, wherein the child is to be protected and cared for. This may seem like an inconsequential change, but the evidence of the past 30 years shows that this is not the case. This is not to say that we can fully understand or predict precisely how these changes will play out in the emotionally fraught experience of a divorce. Nevertheless, this is a positive step towards the protection of children. While clearly changing terminology is only one step along the path, the change of language denotes an underlying change in the framework of a divorce proceeding. This is further advanced by the emphasis placed on the use and encouragement of alternative dispute resolution mechanisms to avoid costly and damaging litigation. Litigation over children is costly, hurtful, and often very damaging for children. Mr. Speaker, I mentioned before that divorces are emotionally fraught proceedings. Nowhere is this more evidenced than in litigation over children. Often parents, faced with the prospect of losing the adversarial contest delineated in the current statute, resort to litigation. Rarely is this in the best interest of the child. In fact, I am sure that many of us can point to examples within our own spheres of friendship and family wherein children have become pawns in the litigation process by parents who unwittingly acted against their own children's best interests. Furthermore, as a conservative, I am uncomfortable with the thought of a court deciding the best interests of a child between two opposed parents. While it may at times be necessary, I believe we can all agree that it ought to be a last resort rather than a first option. I believe it is far better if the parents work together to come to an arrangement that properly addresses the concerns, rights, and responsibilities of each parent while protecting the rights and considerations of the child or children. For this reason, I applaud C-78 for the move away from exposing children to litigation and instead directing the proceedings to alternative dispute mechanisms. These mechanisms may include counselors, mediators, mental health experts, and parenting experts. The dispute resolution mechanisms require parents to work together for the good of their children and heads off potential adversity by placing the welfare of the child as the goal rather than winning custody of that child. This results in the parents being in a position of working together rather than on opposing sides. However, I also have a concern that Bill C-78 perhaps does not address to the degree that it could. As I mentioned earlier, I appreciate the focus that this Act places on alternative dispute resolution mechanisms, as they create a cooperative framework rather than an adversarial one. However, I believe it should be clear to everyone that divorces are often, despite best efforts, adversarial and emotionally charged. One or both parents could and often do choose to proceed directly to litigation in order to win. As positive a step as the revised language and the introduction of the dispute mechanism is, they are not enough to address this issue. I do believe the government considered this issue while drafting C-78, as they put in place a requirement for legal professionals to encourage clients to use the alternative dispute resolution mechanisms. Nevertheless, I would argue that this amounts to slightly more than a requirement to inform. While it is sure to make a difference, there will be many cases where one or both parents write off resolution mechanisms immediately without a second thought. Would my colleagues on the other side consider the possibility of including arbitration as a clearly defined provision within the dispute resolution options? Having this in place would allow the courts to have more leeway in requiring that the divorcing parties go through a resolution process before resorting to litigation. At the least, I would encourage the Justice Committee to consider this issue to ensure that the processes put in place will indeed be as effective as intended. Another concern I have is with the lack of a default position wherein both parents share equal parental responsibility. Critics of this bill point to results of research within the social sciences which suggests equal shared parenting as the best outcome for children in a divorce proceeding. Of course, this may not always be ideal, which is why it would certainly have to be rebuttable. However, as a default position, it would require disproving in order to be changed. Given what we know from the social sciences, I believe that adding an assumption of equal shared parenting is worth serious consideration at the committee stage of this bill and worthy of some discussion. I would like to pause for a moment here to reiterate that my criticisms of this bill, if my concerns can even be called that, come from a place of goodwill. As I mentioned earlier in my remarks, and as so many others have stated, this bill is the first major amendment to the Divorce Act in 30 years, and indeed only the second amendment in 50 years. I believe it is very important that we get this right, as it will likely be the divorce framework for many years to come. Mr. Speaker, there are many other points that I could address about this bill. Unfortunately, I know that I am out of time. Instead, what I will say is that I am pleased to support this bill through to committee, where I hope it is closely reviewed, ardently debated, and where I hope to see my concerns addressed. Thank you very much.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member opposite for her comments and for her discussion of the various issues entrenched in this bill. I want to add something into the debate and then present a question to her. What we know from the statistics is that this bill, and it highlights some of the things that was mentioned by my friend opposite, is that she highlighted the issue about making court a last resort. And one of the reasons why that's important is because court is costly. And we know that the entire system is costly. We know that there are defaults on payments. There are a lot of payments in arrears. There's $1 billion worth of payments, more than $1 billion in arrears in Canada, and that disproportionately affects women. What I would ask my friend opposite is that there are specific measures in this bill that make for an access to justice argument about how you do justice by families by ensuring they don't have to go to court. You no longer have to go to court. You can pursue an administrative procedure for calculating an income support payment, for recalculating an income support payment. And there are incentives put in place to ensure that if legal assistance is necessary, those lawyers need to provide you with ADR alternatives. Are those the types of measures that my friend opposite believes will help address the court backlogs, the court costs, and also the costs that are being borne disproportionately by women in the legal system?
The Honourable Member for Carleton Trail, Eagle Creek.
Well, thank you very much, Mr. Speaker, and I do thank my colleague for the question. I, too, have to state, like many other colleagues have already today, that I am not a lawyer, and I certainly do appreciate the work that has been done by the members of the Justice Committee to date, and by the Minister of Justice in presenting this bill. I know that one of the stated intentions of this bill is to help reduce child poverty by providing more tools to establish and enforce child support. And so I hope that this is a main point of discussion during the committee's debate around this bill. Thank you.
Questions and comments? The honourable member for Bow River.
Thank you, Mr. Speaker. I appreciate my colleague's speech today on this particular and very important piece of legislation. As she has mentioned, there are many positive aspects that she has pointed out, but she has also suggested that she has some concerns, and she briefly mentioned them. I wonder if my colleague would like to return to that part of her speech where she had those concerns and expand on them. Thank you, Mr. Speaker.
Honourable member for Carleton Trail, Eagle Creek.
Well, thank you very much, Mr. Speaker, and I do thank my colleague for that question. As I did say in my remarks, I know that there is significant research within the social sciences that suggests that equal shared parenting is the best outcome for children involved in a divorce. And I think we would all agree that parents having equal access to their children would be in their best interests. However, I also said that I fully recognize that this may not always be in the best interests of the child or the children, which is why I suggested that it would have to be rebuttable. That is one of the concerns that I raised. I raised them to highlight an issue that I feel the Justice Committee could look more closely at during its deliberations. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
Just further on this point, Mr. Speaker, I think it's really critical to understand that this legislation is entrenching specific provisions in law for the first time. A definition of family violence that is expansive, that includes the impact it can have on children, even in observing family violence. It's critical to understand that because insofar as it relates to the position that's being articulated on the opposite side of the House about an equal parenting provision, it is family violence that is so critical in understanding why a best interest of the child analysis should not have an equal parenting presumption. And the evidence that we have seen that informed the development of this bill that has been resoundingly approved of from members of the bar, stakeholders, parents, from coast to coast to coast, is that looking specifically at each case in its uniqueness is the critical approach because it can account for family violence in a way that hitherto was not possible. That's why the presumption has changed and moved away from equal parenting. So I'd ask the member opposite, how do you reconcile those two? A rebuttable presumption is not enough. We have to put family violence in the best interest of the children square and frontal in our analysis here, and that's what this legislation is doing.
Honourable member for Carleton Trail, Eagle Creek.
Well, thank you very much, Mr. Speaker, and I do thank my colleague for the question. I could quite simply say that, I'm not here to rebut that. It is simply something that I mentioned that I would like to see discussed. If there are those concerns and reasons for why this piece of legislation is not including that, I would certainly hope that there's robust discussion around that. Conservatives have always stood up for the safety and well-being of children and families, and so I would suggest that a good discussion around that issue should be held when the committee is studying this bill. Thank you.
Before we go to resuming debate, it's my duty pursuant to Standing Order 38 to inform the House that the question to be raised tonight at the time of adjournment is as follows. The Honourable Member for Bow River in respect to the environment. Resuming debate, reprise de débat. The Honourable Member for Edmonton, Griesbach.
Thank you, Mr. Speaker. I think we all know that divorce is a very terrible thing. It can be a traumatic experience for families, children, and parents, obviously. But yet when it does occur, it really is imperative that the best interests of children should be at the heart of any divorce proceeding. And that's any that they're caught up in. And according to the 2016 census, more than 2 million Canadian children are now living in separated or divorced families. And 38% of the 5 million separations and divorces in Canada between 1991 and 2011 involved a child. So divorce has really sadly become a regular part of the life of everyday Canadians. So with this legislation, we really have a duty to try to minimize the trauma of divorce as much as possible, especially on children. Overall, the intention of the Bill C-78 is good. I'm especially glad to hear this legislation will be centered on the child. Too often, children become pawns in bitter divorces. We've all heard those heart-wrenching horror stories. A woman near and dear to my heart has gone through a living hell battling to get what's best for her daughter for years after her divorce. Under shared custody, the daughter was succeeding in school and attending regularly, especially when she was at her mother's home. But at subsequently family court appearances, the daughter's dad managed to convince the family court it would be in the best interest to have the daughter spend all of her time at his residence. After that happened, the teenage daughter's marks plummeted. She missed a ridiculous amount of school, and she got into trouble with police. It's a very sad story, Mr. Speaker. Despite fighting tirelessly in family court, this woman's daughter is now hopelessly alienated because one parent wanted to punish the other. This child was used as a weapon and essentially brainwashed by one parent to punish the other parent. This daughter will now no longer speak to her mother, her grandmother, her aunts, uncles, or her young nieces and nephews who absolutely adore her. Alienation is one of the most terrible things that can be inflicted upon a child. It's something that can literally ruin a person's life and could take years of psychological help to overcome. So part of the problem I've witnessed in family court is people who appear there do not even testify under oath. So remarkably, there's no requirement to actually tell the truth. So how can a judge truly make a correct decision in the best interest of the child if there's little or no ability to compel people to tell the truth? It's really quite ludicrous, and it's no wonder that some people criticize family courts as kangaroo courts. But that's also why Section 16A of the Act is an important first step. It states the principle that children should have as much contact with each parent within the confines of their best interest. And it also takes into account the willingness of the parent to facilitate visitation as a consideration in custody disputes. It's a move that will penalize parents who, for petty reasons, try to limit visitation and access of the child or children to the other parent. It's a positive first step to make sure that even an acrimonious divorce, in those divorces, the best interest of the child is always first and foremost, and that's as it should be. Promoting the use of alternative dispute resolutions, such as divorce mediation to settle divorce cases, is also an encouraging move. It should help make divorce proceedings as amicable as possible in very bitter situations at times. Now, being caught up in the middle of an acrimonious divorce is never in the best interests of children. So taking steps to create a valuable alternative to litigation in family court is a sensible idea. It obviously wouldn't be able to solve the worst of cases like the case I mentioned above, but it is a start. If done correctly, it could make a meaningful impact for millions of Canadians. Ultimately, though, Canadian children are best served when the custody and divorce proceedings are as harmonious as possible, with both parents having a meaningful relationship with their children. A third important part of the legislation is the introduction of measures on combating domestic violence and child abuse. That's a laudable goal. Having dispute mechanisms and courts take into consideration domestic violence and child abuse is imperative, considering the move to a more dual parenting framework. Now, as I stated before, of course, it's always in the best interests of the child to have both of their parents having meaningful relationships. That, however, is definitely not the case in situations where one of the parents is violent, neglectful, or abusive. And I see the government will be committed to creating a new 39 new judicial positions in Alberta, Ontario, Nova Scotia, and Newfoundland and Labrador. And that's another positive step. It really is. Especially considering the extraordinarily slow pace the current government has taken in appointing badly needed new justices and judges. So let's certainly hope that they appoint them a lot faster than they've been filling other judicial vacancies. Unfortunately, my colleagues across the aisle support of the best interests of the children rings somewhat hollow, because now let's talk about another case that's gripped the headlines and everybody's talking about it. It's the case of Terry Lynn McClintock, a convicted child murderer who is now living at a healing lodge. Canadians are saying loud and clearly she should be back behind bars.
Exactly.
But these Liberals are refusing to act on that. They're saying that we Conservatives are ambulance chasers and we're just creating this whole controversy, and it's very, very low of us. But all we're doing is we're reflecting what the father wants, and he has spoken about it very, very clearly on CBC and other media. So wouldn't, for instance, I mean, I just am not sure how it can be said that promoting the best interests of a child, Terry, you know, the child, is best served. I think she's been murdered, and yet they talk about promoting the best interests of the child in this legislation, and yet her murderer is not even behind bars. She's in a healing lodge. So wouldn't Tory's best interest be ensured that her murderer is held behind bars?
Absolutely. I
just also don't see how having a child murderer at a healing lodge is in the best interests of the children who are often present there themselves. Yet, this is the position that the members across the way supported in votes, and it's really enraging Canadians, Mr. Speaker. So to one day, there's a flippant disregard for what is Tory Stafford's best interest and the best interest of children at that healing lodge. Then the next day, hearing their talking points about how much they care about children in this bill, you know, it's rather shameful, to be honest. It's also the case with Bill C-75, the government's new crime bill. Again, I'm not sure how many parts of that bill mesh with the priority of the best interest of the child that my colleagues across the aisle seem to believe today.
Not a lot.
I mean, how does giving a mere fine in the best interest of children who are forced into marriage, or marriage under the age of 16, or the abduction of a child under the age of 16, how does that act in the best interest of the child in that bill C-75? I fail to see that. I mean, how do any of these reforms put the interests of the child first? I mean, it's very simply put, I don't believe that it is, and that's not the government's position. So if the minister would like to truly put children first, as she should, I would certainly recommend that we do so in a consistent manner and go forward from that. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, and I appreciate the comments and the speech delivered by the member from Edmonton-Griesbach. I wanted to just ask a question that relates to part of his comments, and it related to the statement, and if I heard it correctly, that family courts resemble sort of kangaroo courts. And it prompted me to think about the problems that we have with overly litigious family law matters. That people are prompted to get to court far too quickly, far too often, and it has acrimonious consequences, including the consequences on children outlined by my friend on the other side of the chamber. What we have here is a goal, Mr. Speaker. The goal is twofold. One, to reduce the necessity of going to court. And we've established that in law by making provisions such that you can have an income support calculation out of court, you can have a recalculation out of court. In fact, lawyers are actually required under this new law to encourage you to go out of court. But secondly, that when you do get to court, that court needs to be facilitate your needs, and it needs to be a one-stop shop, which brings us to the unified family court. And my friend did mention this in the later part of his speech, saying that he is in approval of that provision because there used to be confusion between the provincial jurisdiction and the federal jurisdiction. People were forced to go to court, not just one court, but two. We're changing that by creating unified families courts, including in the province that my friend opposite represents, which I think is a step in the right direction, and I believe he said that he agrees with that. What I think is that these are all laudable goals, and my question to him is that does it conform with keeping the best interests of a child at heart to keeping them out of court through the measures that we've entrenched in this bill, such as what I've just outlined about income calculation and recalculation?
The honourable member for Edmonton Griesbach.
Well, as I've said about the bill, it's largely laudable, and the unified court is a good thing. But again, I think that we really have to hold the interests of the child at heart, and I think that is the best part of the bill. It's obvious that divorces can absolutely ruin children for life, and I think we're on the right track here. But we should also be consistent. Like if we were looking out for the interests of the child, let's look out for the interest of the child in not this bill, but also in Bill C-75.
Questions and comments? The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank my colleague and neighbour from Edmonton Griesbach for his comments on Bill C-75. In the course of his speech, he talked about the fact that in most circumstances, it is in the best interests of a child to have both parents involved in that child's development and for there to be ongoing contact and support with both parents. One of the criticisms that some have put forward with respect to Bill C-78 is that it does not provide for a presumption of shared parenting. As the honourable member for Carleton Trail Eagle Creek noted, that sometimes shared parenting isn't in the interests of the child, but would the member agree that perhaps one flaw of the bill is that it does not contain a provision for a rebuttable presumption for shared parenting?
Honourable member for Edmonton Griesbach.
I thank my colleague for that. He's a legal whiz, he truly is, and that's a very good point, and I think that should be something that can be addressed, and I thank him for raising that.
Questions and comments. The honourable member for Jonquière. Well, thank you, Mr. Speaker. There's a lot of talk about children. As I've said oftentimes here, I am the mother of 2 boys. I've also said that my children were born in a common law relationship, and the bill, in its current form, addresses people who are married. What I'd like to know from my colleague is whether we should also make some changes to deal with common law partnerships where parents separate, they aren't married, but they too need support. That could perhaps be incorporated into C-78. I'd like to know what my colleague thinks of that.
For Edmonton Griesbach.
Well, again, I'm not the legal expert here, but I would think that at a certain point, people who live in common law are considered to have the same rights as someone who is married. So I wouldn't see that that should really be an issue as long as I don't know what the time frame would be, a year, 2 years, I'm not sure, but I think that it should apply, certainly.
Resuming debate, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And, you know, it's such a pleasure to be able to rise and speak to what I believe is a significant piece of legislation that we have before us today. You know, it's been many years since we've actually had substantial changes to the Divorce Act. In fact, Mr. Speaker, you'll likely have to go back a couple of decades when we saw some of these reforms. And, you know, it was interesting. One of my colleagues across the way give us a little bit of a history, not only of the date of his birth year of 1984, but also indicated where the divorces and the patchwork that was done across Canada at the time, and questionable in terms of how one could even get a divorce. And when you think of the 80s, it wasn't that long ago. Back in when my colleague was born, I was in the forces, posted in Edmonton, and I can tell you, a lot has changed. It really has. And when I look at it, in the last 3 years, we have seen a minister take a look at what is a very important issue to all Canadians in all regions of the country. And as opposed to trying to dictate in any fashion, she took it upon herself in the ministry to reach out to the many different stakeholders. Because, it's important for us to recognize that Ottawa plays an important leading role on a number of issues. Divorce happens to be one of those issues. And a part of playing that leadership role included the minister reaching out to the different stakeholders. And the stakeholders range from groups such as many women advisory type of groups that are out there that have a lot of opinions and thoughts and valid information that needs to be taken into account, to the many different provinces that we have and territories, and looking at ways in which we can actually reform the system so that it works better. And the reason why this legislation is so important, I had opportunity to ask the minister, about her legislation. And the first thing that she says to me is it's about the child. That, in fact, it's the children's interest that we're really debating here today and been debating before. And I think the Chamber has captured the essence of why it is so important, in the sense that as I've been listening to the debate, even though we might agree to disagree on some of the finer points, most have acknowledged that it's important that we allow the legislation to ultimately pass and go into a committee. And we're very grateful for that. It seems as if all members of the House are in support, at very least in principle, of the legislation and are prepared to see it go to committee, where I'm sure that we will have an opportunity to hear more feedback. We have a department that is very much interested and has been following the debates that have been taking place, so members have had the opportunity to provide some thoughts. And who knows, I don't want to prejudge in any fashion what's going to take place at the committee level, but if there's any sense in terms of the level of debate and the discussions that have been taking place, I suspect that it will be a very fruitful discussion, Mr. Speaker. And I want to emphasize the fact that when we think of divorce and we put the child first, that we also think about that whole issue of jurisdictions. So committee members and those that are participating in the ongoing discussions in regards to this, that the legislation is meant to establish the framework. And it has been something that has been long overdue. We have needed the types of changes that have been suggested in this legislation for a number of years now. But as we go through those clauses, I would encourage members to reflect on the fact that within the department, in coming up with those clauses, that in fact that those clauses were derived from many different forms of consultations, from advocates to provinces to other individuals of interest, Mr. Speaker. So at times it might on the surface look, well, why don't we modify this to say that, or modify that to say this? I would suggest to you that one of the things that you have to take into consideration, or I would ask that you take into consideration, is that before that clause became a clause, there was in fact a discussion that incorporated many other thoughts and ideas. And I say that because I can sense that there is a great deal of interest in possibly making some modifications. You know, here we are, and you know, this is what we're now at 2.5, 3 years into this mandate. And we're debating this legislation today in good part because of a lot of the background work that has been done. And when we talk about putting the child first, it's not only through legislation, Mr. Speaker. Virtually from day one, we have seen this government, in particular this Prime Minister, focus a lot of attention. And you hear it virtually every day about the importance of Canada's middle class and what it is that we need to do to enhance and give strength to the middle class. There are some weaknesses and some vulnerabilities in there, Mr. Speaker, that we have a responsibility to look at. The Parliamentary Secretary on numerous occasions has mentioned that today, about that $1 billion that's not being paid to those children, that's being denied to the children. You know, we, through budgetary measures and the Canada Child Benefit Program, came up with significant amounts of money, hundreds of millions of dollars that we were able to put literally into the pockets of children through parents and guardians, Mr. Speaker. Well, within this legislation, what this legislation is going to do, in good part, is enable those very same children to be able to get money that is due to them, Mr. Speaker. You know, I believe at the end of the day that this legislation will do many things, but as the minister herself has said and made very clear, it is the child that does come first. And one of the best ways we can ensure that the child comes first is ensure that they have the financial resources to be able to do the things that are necessary in order to be able to have the opportunities into the future. When I think of relationships, it's a complicated issue. It can be touch and go on any relationship, Mr. Speaker. There is no relationship that's destined to everlasting peace and harmony. Every relationship will have challenges that come before it. And when you factor in children, Mr. Speaker, it can make things very difficult when unions ultimately come across difficult times. And I'm sure all of us can share with the House some of the stories that we hear, or maybe even provided some counseling on. I've been a part of counseling services myself, Mr. Speaker. And I've had to provide counseling services. And it is difficult at the best of times. But I can tell you, from a child's perspective, depending on the age, you will see that even at times a child would recognize that, yes, maybe it's good if mom and dad separate because they want both to be happy, Mr. Speaker. And then you get the opposite, where a child is absolutely torn through emotions and doesn't know what to do. And you might have parents that are in a very difficult position, and they're at odds with each other in a varying different ways. From, again, a peaceful sit-down discussion where third parties are brought in, to the more violent type of interaction that we know takes place, Mr. Speaker. And because of that, because of the child and because of, at times, the parents, there is a role for government and society to play to ensure that the child's best interest, and in fact, I would suggest you to the family's best interests, are ultimately served. And I think that this is the type of legislation that moves forward the idea of things such as alternatives to having to go to court in all instances. And a good example of that is the issue of incomes and having to get them readjusted. You know, I come from a day of age where I had many of, or a number of friends that had to experience going through divorces. And they'll talk about the costs of divorces and having to go through the court process, the waiting times and the periods, Mr. Speaker. And sometimes it's just dealing, in good part, with issues such as income or income readjustments. I've had the opportunity, you know, it was interesting, shortly after the minister had first introduced the legislation, I happened to be on an Air Canada flight, and someone had come up to me that I've known from the past, and I understood her to be as a judge, and she had provided the comment that this is good, sound legislation. I don't know to what degree she read it through or anything of that nature, Mr. Speaker, but I can tell you that she thought it was sound legislation that would have a profound positive impact in terms of issues like time and peace within families. Now, knowing the individual from the past, it kind of gave me a bit of a vote of confidence that the legislation that we're talking about is really sinking in terms of the community, when it was shortly after the minister had actually brought it in for first reading, and I had someone of that caliber raise the issue because I know the individual, or had known her many years ago, and her attitudes towards families. So I was quite pleased to hear that sort of a comment. You know, in the discussions that I've had to date on this legislation, the feedback has been very encouraging. And that's why I'm glad to see the general support that not only are we receiving from outside this chamber as stakeholders and other interested individuals that are following the debate or have a basic understanding of the legislation as being positive legislation, but it would appear as if there's substantial support from coming across the way, Mr. Speaker. And I think that is so encouraging to see, given just how important it is that this dated law actually gets updated. So we think of the best interest of the child, reducing child poverty, addressing family violence, more access to the justice system through things, Mr. Speaker, that will ultimately lead to more individuals resolving issues related to divorces outside of the courts. Those are all positive, strong points that I think that we need to repeat and say again and again in order to be able to reinforce just how positive that this legislation will put us in terms of on the right track. Let me give some specifics when we think about Bill C-78. And it is a change in terms of even the name itself, Mr. Speaker. When you look at the Act to amend the Divorce Act, the Family Orders and Agreements Enforcement Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act, and to make consequential amendments to another act. It is very comprehensive. Let me highlight some of the things in which that have been provided to me, Mr. Speaker, as to what it is that the legislation is actually doing. And I cite this as examples in terms of some of the specifics. To promote the best interests of the child, something that I've really highlighted. A few of those points would include replacing custody and access with more parenting terminology, Mr. Speaker. Words matter. And to have more consistency of that wording, whether it's here in Ottawa, but more importantly, when I say Ottawa, I'm really talking about throughout Canada, because there has been a great deal of work in terms of trying to get us using the same terminology, Mr. Speaker. That matters. Legislating a list of best interests of the child, you know, in terms of establishing a criteria for that, again, is something incredibly positive. requiring the courts to take the child's own views into account, where in fact is an inappropriate thing to do, Mr. Speaker. Allowing for the implementation of the 1996 Hague Child Protection Convention, which clarifies rules around recognition and enforcement judgments and makes it easier for authorities in different countries to communicate and cooperate with each other about many cross-border issues involving children. Mr. Speaker, this highlights the fact that, in my opinion, that we all need to recognize that it goes, here we talk about Canadian divorce laws, but often these divorces and the interests of the child goes far beyond just our borders. In fact, you will find that there are many other countries around the world that look to Canada and the types of things and manners that we put into place in order to resolve some of our societal issues. I think of the Philippines as an example, a country that doesn't have a divorce law, Mr. Speaker. It's a beautiful country. I've had many opportunities to visit. I will continue to visit into the future, and we can learn a lot from a country like Philippines. But there are countries that don't have divorce legislation. So you have world organizations that try to provide international leadership. And by Canada incorporating ideas and thoughts that come through those international agencies or bodies, I think speaks well in terms of us continuing to play a leadership role, not only here in Canada, but potentially in other areas of the world. Mr. Speaker, we talked about reducing poverty. You know, as I mentioned, the parliamentary secretary, $1 billion. It's been referenced. You know, we got close to 2 million children in Canada that are actually living with one parent or one guardian today, Mr. Speaker. Close to 2 million. Many of those children, talking about hundreds of thousands of them, that are in poverty or borderline of poverty, in good part because the spouse or the individual that is supposed to be paying that support for the child is not fulfilling that obligation. So, within this legislation, Mr. Speaker, we're allowing for the release of CRA information to help establish, vary, and enforce family support. Income for information from the T1S form as an example. That is a significant step forward. You know, and that's why I suggested earlier in regards to the importance of working with other stakeholders, such as provinces and others, Mr. Speaker. What about, Mr. Speaker, addressing the family violence issues by including a definition of family violence in the Divorce Act for the very first time, which would include any conduct that is violent, threatening, a pattern of coercive and controlling behavior causes a family member to fear for their safety or directly or indirectly exposes a child to such conduct. Violence means more than just physical violence, Mr. Speaker. It includes mental, monetary. There's many ways in which you can have a very unhappy family or a child that has actually been compromised to the degree in which it is causing pain, whether it's physically or mentally, Mr. Speaker. You know, in my home province of Manitoba, we have thousands of children that are in custody. Many of those children that are in custody is rooted into family violence in their homes. I'm glad that we are finally recognizing that that family violence does exist and incorporating it into the legislation itself. Mr. Speaker, it looks like you're about to tell me to stop speaking, and I have quite a bit more I'd like to be able to share with members. Possibly through questions, I might be able to do so. But suffice to say, increasing access to justice and improving its efficiency is another very important point. I won't be able to give examples on it, Mr. Speaker, but it's always a privilege to be able to share a few thoughts. Thank you.
Again, sir, the Honourable Parliamentary Secretary will have a chance to have a go at some of those additional thoughts when we have 10 minutes for questions and comments. So we'll start with that now. Questions and comments. The Honourable Member for St. Albert, Edmonton.
Thank you, Mr. Speaker. I want to thank the Parliamentary Secretary to the Government House Leader for his speech, and I'd like to thank him for making reference to my speech and the year 1984, which was a very good year. Aside from the fact that I was born in that year, the best part of 1984 was that by the end of it, there was not a single Liberal government anywhere in Canada. But oh, well, maybe that will repeat itself. But in any event, I do want to ask the member, and I agreed with much of what he said. I think that a number of aspects of this bill, in terms of the objectives, are laudable, but there has been some criticism of the bill. Robert Harvey, a family law lawyer in Alberta and a former bencher, wrote in the Lawyers Daily that Bill C-78 is an expression of good intention without sufficient substance to accomplish real change. And in that regard, Harvey states that fundamentally Bill C-78 is devoid of change to the overall resolution process itself. I was wondering if the Parliamentary Secretary could comment on that.
Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And to the first point, I can assure the member I was born and raised up during many Liberal governments, and most importantly, nice thing about Canada is I think about 75% of our Confederation, it has been a Liberal government, so he has reason to be optimistic going forward, especially with this administration, as we have been able to tackle so many issues that have really benefited Canada's middle class, and we hope that Canadians will return us into the future, but we won't take that for granted. But one of the ways in which we do this, Mr. Speaker, is we bring forward progressive legislation that we're talking about today. And, you know, my colleague in his second part of the question cites an individual that has some concerns in regards to the effectiveness of the legislation itself. I would advise what my friend might want to do is to provide some of the speaking notes that have been, or some of the speeches that have been said here in the House, possibly even from the minister, and share those notes. Maybe encourage him to listen into some of the debates, listen to some of the other stakeholders that are coming forward, commending the legislation itself as a major piece of legislation that's going to have a profound positive impact on families and the way in which we move forward, in particular.
Just an advice to honourable members, from time to time they get looking at other parts of the chamber when they're delivering the remarks, and it makes it unable for me to give at least a cue as to how the time is going along, but we'll try to appreciate members when they turn their direction this way, at least from time to time. Questions and comments? The honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. Well, there are 4 stated objectives in this bill. 2 of them are promoting the interests of children and 2, combating family violence. It is stated in this bill that the safety and the physical, emotional, and psychological well-being of the child must take priority. Now, interestingly, in the Criminal Code of Canada, there is a prohibition against assault, so that in this country it's against the law for anybody to strike anybody else, except there's an exception, that adults in this country can still strike children. They can still hit children in the context of the domestic home. And I'm wondering if the purpose of this bill is to reduce domestic violence and put the interests of children forward, if this honourable member agrees with me that maybe it's time for us to look at the criminal code in this country and remove the sections of the criminal code that still permit adults to strike and hit children in their homes as a form of punishment and control.
The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I appreciate the member's interest in that area. I look forward, and as I indicated earlier, I suspect that once this legislation passes, Mr. Speaker, what we will see in committee is a great deal of discussion. I would suggest and recommend to my friend that he raise this issue at committee, maybe provide some additional details, and see what happens there. I'm not in a position to go any further than that, other than to express a personal opinion. But I would like to have heard a little bit more before I even did something of that nature. But I appreciate the sensitivity of the issue and the question itself. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker. During the course of the debate over the past several hours today, we've heard about initiatives to improve family law justice in this country. We've heard this afternoon about 39 new judicial appointments that are being made in 4 new provinces to create unified family courts. We also heard articulate comments made by the Parliamentary Secretary the Parliamentary Secretary, the House Leader here, about the listening exercise and what we were hearing from people around the country. And after the UFC, the Unified Family Courts Initiative, what we heard is that that's one piece of the puzzle. Another piece is actually addressing the legislation. And we're doing that here, but I wanted to get to a point that the Parliamentary Secretary wasn't able to conclude on, the access to justice point, because there is tools in this legislation that allows people not to have to resort to court, which is important, but there's also dollars that are being put in place by our government to support those initiatives at the provincial and territorial level, specifically $16 million a year to assist with negotiation, mediation, collaborative law activities, and other out-of-court dispute resolution mechanisms that are implemented by the provinces. Could I ask the Parliamentary Secretary if he believes that is exactly what is needed here to support this legislative instrument with the dollars that get people out of court and get their matters resolved in a more efficacious manner?
The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker, and I appreciate the question. I know the Parliamentary Secretary has been here throughout the day posing some very good questions, advancing the bill, and, you know, it's one thing to bring forward the legislation, which is absolutely fantastic to see. Another part of it is to look at ways in which we can deal with this through the budget. And we have seen that through the Minister providing support not only in legislation but also in budgetary measures, such as the Parliamentary Secretary has not only referenced just now but earlier. I want to pick up on the idea of the increased access to justice and improve efficiencies aspect, Mr. Speaker, and that's by encouraging the use of out-of-court dispute resolution by requiring parties to try to resolve matters through dispute resolution processes. And I think that is something that is very tangible, that will in fact make a difference, and this is the type of initiative that I think that will be very well received overall, and hopefully, I believe, speed up the entire process. And if there was something that I should have provided more comment on during my speech, Mr. Speaker, it would have been the issue of not only is this in the child's best interest, but it will also speed up the process. I really do believe that, Mr. Speaker, and at the end of the day, I'm very glad to support the legislation.
Questions and comments? The Honourable Member for Vancouver Kingsway.
Well, thank you. I'd like to follow up to my question so I can be more specific. So it's known as the spanking exception. So in a domestic household, parents in this country are allowed to hit their children. And it's a form of assault that other countries in the world have now made illegal. It represents an outmoded form of violence that really most people nowadays understand causes trauma, physical and emotional harm to a child. So I'm just wondering with this government, if they're proud of this legislation that puts the interests of children first and are concerned about doing something about domestic violence, I'm going to put a clear question to my honourable friend. Will his government bring forward legislation to amend the criminal code to remove the exception that allows parents to use physical violence against their children as a form of punishment and control?
Parliamentary Secretary to the Government House Leader.
You know, again, Mr. Speaker, I can tell that it's an important issue to my friend across the way, and there are things that are taking place. And, you know, if we take a look, for example, at the TRC, where there's recommendations dealing with children, and no doubt there's consideration that's being given on a wide spectrum of things, and this is one of those issues. And that's why, for me, what I would like to suggest to my friend across the way is that he bring the matter before the committee and see if, in fact, they might want to take into consideration what the TRC report actually had to say also. I'm not familiar with the details of it, but I'm sure my colleague across the way can familiarize himself with it, raise it with the committee, and who knows what may come of it, Mr. Speaker.
Resuming debate. Reprise de débat. Is the House ready for the question? La question est la suivante.
Question is as follows. Ms. Wilson-Raybould, seconded by Mr. Duclos, moves that Bill C-78, an act to amend the Divorce Act, the Family Orders and Agreements, Enforcement Assistance Act, and the Garnishment, Attachment, and Pension Diversion Act, and to make consequential amendments to another act, be now read a second time and refer to the Standing Committee on Justice and Human Rights. Is it the pleasure of the House to adopt the motion?
Oui? Oui?
Yes. Carried.
Ce bill, deuxième lecture de ce projet de loi.
En conséquence, le projet de loi.
Therefore, this bill is referred to the Standing Committee on Justice and Human Rights.
See the Honourable Parliamentary Secretary to the Government House Leader on his feet, perhaps on an issue that may be of interest to the House.
Absolutely. Thank you, Mr. Speaker. On a point of order, I would ask, I suspect if you were to canvass the House, you'd find unanimous consent to call at 5:30 at this time so that we could begin private members' hour.
Is it the pleasure of the House to see... Yeah, he's doing my job. You know. Is it the pleasure of the House to see the clock at 5:30 p.m.? Yes? Agreed, and so ordered. Accordingly, the House will now proceed to the consideration of private members' business as listed on today's order paper. Orders of the day.
Affaires émanant des députés. Resuming debate at second reading of Bill C-376, Sikh Heritage Month Act in the name of Mr. Dhaliwal.
When we last took up debate on the question, the Honourable Member for Brampton East had 5 minutes remaining in his comments, and we'll go to him now. Resuming debate, the Honourable Member for Brampton East.
Thank you, Mr. Speaker. And once again, I'm proud to rise in this House to debate Bill C-376 at second reading. The bill was introduced by the member from Surrey Newton, and I was more than happy to second the bill. I'm humbled and enormously grateful for this opportunity to speak in favor of a bill that provides an opportunity to highlight the many contributions that Canadians of Sikh heritage have made to Canada, and on occasion to educate future generations about the role that Sikh Canadians have played and will continue to play in communities across this country. At the heart of this bill are everyday Canadians. At the heart of this bill are values that all Canadians share, cherish, and protect. At the heart of this bill are diversity, inclusion, and tolerance. Every day, Sikh institutions like Seva Food Bank are doing tremendous work by running and operating a food bank in Mississauga that provides services to over 900 families each month. The Guru Gobind Singh Children Foundation, which operates under the motto Children Helping Children, holds annual charity runs to help raise money for children in third world countries. And the Guru Nanak Free Kitchen is a voluntary organization in British Columbia that is working on eradicating food insecurity through the Sikh practice of langar, a community kitchen, where everyone is treated equally. These three organizations are just a small number of the numerous organizations across this country of Sikhs helping Canadians succeed. A Sikh Heritage Month is also an occasion to educate future generations about the role that Sikh Canadians will play, have played, and will continue to play in this country. Mr. Speaker, it is well known that Canada is one of the most diverse countries in the world. Canadians of Sikh origin have contributed to its diversity, which is interwoven into the cultural fabric of our country. We continue to honor and preserve our history and our heritage in order to inspire future generations to continue sharing our country's story. Diversity is Canada's strength, and our differences, no doubt, make us stronger. I fully support Bill C-376, seeking to formally celebrate the month of April as Sikh Heritage Month. Mr. Speaker, I've always said I'm a proud Sikh, I'm a proud Canadian, but I'm most proud that I live in a nation that doesn't make me choose between the devotion to my faith and the devotion to my country. When people ask me about the Sikh Canadian story, I always sum it up as follows. In 1867, then Prime Minister Sir John A. Macdonald asked for an army of Sikhs to help secure Montreal from a U.S. invasion. And in 2015, a Sikh was appointed the Minister of National Defense. This story is only possible in the greatest country in the world. Sikhs are truly living the Canadian dream. I look forward to seeing this bill passed, and when it does, I look forward to celebrating with Sikhs and Canadians of all different backgrounds across this country from coast to coast to coast. Mr. Speaker, when people ask me why we need Heritage Months in the first place, the answer for me is quite simple. The beauty of Canada is that no matter where you come from, no matter what you believe in, Canada will always have a place for you too. But this does not happen by accident and will not continue without effort. And that's why Heritage Months provide an opportunity to educate and learn about the history of our fellow Canadians. And that's why I fully support the concept of Heritage Months. And I look forward to celebrating Sikh Heritage Month this April. Thank you, Mr. Speaker.
Resuming debate. The honourable member for Charlevoix, Côte-de-Beaupré, Île d'Orléans. Thank you, Mr. Speaker. I'm pleased today to rise to take part on debate on Bill C-376, which would designate the month of April as Sikh Heritage Month. First of all, I would like to recognize my colleagues on both sides of the aisle here in the chamber and my Sikh colleagues who share their culture with us day after day. I'm a French Canadian from the great region of Charlevoix, and there are very few Sikhs who live in my area. Yet I've gotten to know Sikhs, and they've shown us another face of what it means to live in Canada. We are surrounded by many communities. So I was actually quite surprised to see that there are over 500,000 Sikhs living in Canada, and that this community is the second largest Sikh population in the world. So I would like to recognize that fact, because every day we speak with our Sikh colleagues. Sometimes we debate against our colleagues, but we don't debate against the Sikh community. It's against the Liberals, so there's a difference there. I greatly appreciate my colleague to my right. I can't name him, but he is also a Sikh, so I'm very pleased to share this moment with him. When we see all the different faces of Canadians, when we get to know our fellow Canadians, we open ourselves to the world. And it's important here in Canada to do just that, to be open to the world. And that is one of the premises our country is built on. Canada is a very welcoming country, and we want to remain a welcoming country. I will leave it at that because I don't want to get off track. So what I really wish to say is that I fully support April as Sikh Heritage Month, and I hope that every year in April you will help us discover your culture. You will show us what makes your culture so different, so special. The French-Canadian culture
has poutine. We eat poutine, so it would be interesting for us to discover your culture and, in fact, your culinary culture, your musical culture, what moves you. As I said, I'm from the Quebec City area, and unfortunately, I don't have the opportunity to meet many Sikhs in my region. So when I'm here, it is a wonderful opportunity to discover the Sikh culture, the Sikh religion, which is different from mine. We come from different places, but we are not different in our heart of hearts. The only thing that's different is our backgrounds, our history, our culture, which is unique to each of us. So, Mr. Speaker, again, I'm very pleased to support this bill. I believe it simply shows another face of Canada today. We are all Canadians. You are Canadian. You are from the Sikh community. I am from the French-Canadian community. I'm a woman. Well, you're men, but there are also Sikh women, of course, here in Parliament. So it is, we are speaking to this issue in a spirit of friendship, and I find that it is with the help of bills like this that we can be open to the world and find out where people come from. And so each April, when we celebrate the Sikh Heritage Month, it would be interesting to find out more about your culture, more about your heritage. It'll be interesting to see how your culture differs from mine. Who are your musicians? What kind of music do you listen to? I'm looking forward to those exchanges. I'm looking forward to becoming more familiar with the Sikh culture. I know a little bit through my colleague, but as we get to know each other better, as we speak with each other, we will get to know each other's culture better. And often we are afraid of others because they are different. So I would like to recognize all Sikhs who are here today, who work as hard as I do, and thank you so much for sharing our daily lives here on the Hill. Thank you, Mr. Speaker.
And the Honourable Member for Esquimalt, Saanich, Sooke.
Thank you very much, Mr. Speaker. I'm very pleased to rise today to support Bill C-376 at second reading. This is the bill which designates the month of April as Sikh Heritage Month. And New Democrats have long been supporters of multiculturalism and of celebrating the diverse backgrounds that make up the Canadian mosaic. The designation of Heritage Months is one important way that the government can recognize Canadian diversity and the contributions made to Canada by specific communities. April is, of course, a very important month for Sikh communities, as it is the month when Vaisakhi is celebrated. And Vaisakhi, as we know it today, grew from the traditional spring harvest festivals in the Punjab. These celebrations came to be marked as specifically Sikh celebrations when, in the 17th century, Guru Gobind Singh established a formal order of committed Sikhs, the Khalsa Panth, and consolidated the Sikh articles of faith, practice, and community. This was nearly 2 centuries after its founding by Guru Nanak. And this not only demarcated Sikhs as a community within India, but also established the Khalsa as the temporal authority for that community. Now, far be it from me to lecture on Sikh theology, but it's interesting to note that Sikh theology urges the cultivation of improvement of both the individual self, which, by the way, has no gender in Sikh theology, but it also demands that Sikhs serve the community around them. This brings about an integration of the spiritual and temporal worlds. So the Sikh community remains to this day a community which places a strong emphasis on service to the community. New Democrats have a long history of pressing for recognition both of the struggles of the Sikh community in Canada and the contributions of that community to Canada. Carrying on the hard work of former NDP MPs Jasbir Sandhu and Ginny Sims, in early 2016, the member for Vancouver East moved Motion M35, which called on the government to officially apologize for the 1914 Komagata Maru incident, an apology finally delivered on May 18, 2016. The first Sikh Heritage Month in Canada came about in Ontario as a result of the efforts of current NDP leader Jagmeet Singh in his capacity as MPP for Brampton Gore Mountain. Singh's Private Members Bill 52, an act to proclaim the month of April as Sikh Heritage Month in Ontario, received royal assent on December 12, 2013. Now I want to turn for a moment to the story of the Sikh community in Greater Victoria and in my riding, a history which stretches back more than a century. The first people from India to migrate to BC were Sikhs from northern India, mainly the Punjab. It seems that Sikhs first traveled through BC as a part of the British Empire Army regiments who were traveling in 1897 on their way to the Queen's Diamond Jubilee celebration, and again in 1902 for the coronation of King Edward II. These Sikhs noticed both the similarities of British Columbia forests to those of the Punjab, and they also noticed the great opportunities that would be available in British Columbia, opportunities that they should have been free to take up by traveling to and settling in British Columbia as British subjects. By 1906, there were about 1,500 Sikhs living in Canada, almost 90% of those in British Columbia. Most were retired British Army veterans and their families. And by 1910, there were an estimated 4,000 Sikhs living and working on Vancouver Island, many working in the forest industry, applying skills that they'd gained in the Punjab before coming to Canada. And many, in particular, worked in a part of my riding along the Gorge Waterway in lumber mills. In 1912, the Gurdwara Sahib, or the Khalsa Diwan Sikh Temple Society, was established with about 100 members. They built a Gurdwara on Topaz Avenue in Victoria, the same site it still stands on today. And at the time, this was BC's third Sikh temple. The Gurdwara opened with a massive parade of more than 1,000 Sikhs from all over British Columbia. And by 1969, the original temple building had become far too small to accommodate the community, so it was demolished to make way for a new and larger temple on that same site. In 2012, the Khalsa Diwan Sikh Society of Victoria celebrated its first 100 years, and a community that included more than 3,000 members. Just this spring of 2018, after more than 100 years break, Victoria hosted its first Vaisakhi Day parade. Racism and legal restrictions often stood in the way of the Sikh progress in British Columbia. Fears of Asian immigration to BC among Anglo-Saxon residents escalated in the early years of the 20th century, often based on fears that economic competition would lower wages, but nearly also always fueled by simple racism. As British subjects, Sikhs should have been able to immigrate to Canada and live and work there on the same basis as any other subject of the British Empire. Instead, in 1908, the Canadian government implemented a regulation making a legal requirement that immigrants arrive in Canada via a, quote, continuous journey. This was specifically designed against South Asians, as no shipping lines sailed directly from India to Canada. And the result of this was the Komagata Maru incident that I mentioned earlier, when a ship chartered by a Sikh businessman to bring 376 immigrants to Canada was denied landing in Canada, and after a 2-month standoff was forced to return to India. A tragic incident for which the government has now apologized. And this occurred in a year when Canada accepted more than 300,000 immigrants from Europe and the United States. Progress in ending restrictions and legal discrimination on the Sikh community was slow. It was not until the 1920s that the restrictions prohibiting immigrants from India from bringing their families to Canada was lifted, and Sikhs were finally allowed to bring their wives and children to join them in Canada. Many from the Sikh community volunteered during World War II, and this fact of service was used to try and leverage equal treatment in Canada. In 1943, members of the Khalsa Diwan Sikh Society of Victoria joined others in presenting a petition to the British Columbia Premier asking that South Asians be granted the right to vote. In 1945, those who had fought in World War II were granted the right to vote in provincial elections, and finally, in 1947, all South Asian men were granted the right to vote in both federal and provincial elections in Canada. Being on the voters list had another importance that we sometimes forget, because in British Columbia it wasn't just a matter of right. The voters list was also used in order to register people to practice professions like medicine, law, pharmacy, and the voters list was also used as the basis for getting government contracts and licenses to use public resources. So this meant that Sikhs were, being off the voters list, prohibited from practicing law, practicing medicine, getting grants of forestry, business licenses that other Canadians were able to get. It wasn't until 1963 that immigration regulations were changed to eliminate racial discrimination based on the country of origin. And since then, the Sikh community in Canada, and in particular in British Columbia, has grown and thrived. While the Sikh population makes up only around 3% of the population of my riding, and only about 6,000 of the population of Greater Victoria, the Sikh contribution to Greater Victoria far outweighs the numbers in many areas. This is true whether we're talking about respected small and large businesses, and here I would include the Jal family, who have built one of the most respected and successful development companies in Greater Victoria, or whether we're talking about smaller builders of affordable and luxury homes like Jasbir Bandal in the Gorge area and on the West Shore in my riding. It is also true whether we're talking about professions like law or medicine, or whether we're talking about community services and charitable organizations. I want to single out two community leaders in particular, both of whom I'm privileged to call friends. The first is Mo Sahoda. Mo was the first Sikh elected to federal or provincial seat anywhere in Canada, and he represented the provincial riding, which is the heart of my federal riding. He served until 2001, and in 1991 became the first Sikh cabinet minister anywhere in Canada, serving in a number of posts, including as Minister of Labour and later as Minister of the Environment, where he provided over a major expansion of the BC Park system. I first visited the Khalsa Diwan Sikh Temple in Victoria in 1985 with Mo Sahoda and the then leader of the BC NDP, Bob Skelly, and I've always felt very welcome at the temple in my many visits since then. The second friend I want to note here is businessman Gordy Dodd, who is perhaps surprisingly better known for his community and charitable work and his absolutely hysterically funny business commercials than he is for his substantial business success. This year, I was pleased to participate in the 9th annual Guru Nanak Walk for Peace, and I've now made it to all but 2 of those walks, I believe. This is a walk organized and run by the Sikh community led by Gordy Dodd. The walk raises awareness of the importance of peace while also raising funds for community organizations, and this year, again, the recipient was the Hospice Society. I am proud that the NDP is led by a Sikh, Jagmeet Singh. Just as in the past, we've been led by leaders from other faiths like Tommy Douglas, who, as we know, was an ordained Baptist minister, and of course, in British Columbia, Dave Barrett was the first Jewish premier anywhere in Canada. So Sikh Heritage Month will encourage the continuation of Sikh traditions within Canada, and it will help make those Sikh traditions better known to other Canadians. And the more we know about each other, the stronger we all make Canada. Thank you very much.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Canadian Heritage and Multiculturalism.
Thank you, Mr. Speaker. Wahi Guru Ji Ka Khalsa, Wahi Guru Ji Ki Fateh. I rise today on behalf of our government to add my voice in support of Bill C-376, an act to designate the month of April as Sikh Heritage Month, which seeks to recognize the enormous contributions of Sikh Canadians from coast to coast to coast. I acknowledge that we're gathered here and I'm speaking on the traditional unceded lands of the Algonquin peoples. First and foremost, Mr. Speaker, I want to thank my good friend from Surrey Newton for bringing this private member's bill. Before I speak on the substance of the bill, permit me to share with you the pride and strength of the Sikh community in Scarborough, the area that I represent. Guru Sikh Sabha Canada in Scarborough was built by sheer determination, strength and sense of community of a small but vibrant Sikh community in northeastern Toronto. This community in Scarborough faced the challenges of racism head-on. In building the Gurdwara, the community faced opposition, but the community organized and challenged convention that opened the doors for many more places of worship of various faiths to take hold in Scarborough. Guru Sikh Sabha celebrated its 30th anniversary recently, and I'm so grateful for the warmth and generosity extended not just to me, but to all my colleagues. Monsieur le Président,
Mr. Speaker, it's a very well-known fact that Canada is one of the most diverse countries in the world, making it the second largest Sikh population in the world with more than 500,000 people. So making it the second largest Sikh population in the world. Canadians of Sikh origin have contributed in many ways to the fabric of Canadian society. One of the most visible and prominent contributions is the value of Siva.
Mr. Speaker, and Sikh Canadians have helped build this country from coast to coast to coast, working on the railroads, the lumber mills, in mines and farming fields across this great country. Today, many Sikh Canadians have received international recognition for their work and established themselves as leaders and trendsetters in their field of expertise. This progress has not been without its challenges. Though today Sikh Canadians are seen as an integral part of the Canadian mosaic, this was not always the case. In 1914, the Komagata Maru, a Japanese ship carrying Sikhs fleeing India, was turned away by Canadian authorities and was forced to return to India, where 20 of the more than 300 passengers were killed by the British authorities. In 2016, as you know, the Prime Minister apologized to Sikh Canadians on behalf of the Canadian government for this unspeakable act. It is noteworthy that the same year the Komagata Maru, with its passengers, including veterans of the British Indian Army, were sent back to India, 3 young Sikh men enlisted in Smiths Falls, Ontario, to fight in World War I. Their names had been lost to history until very recently, when Private Buckam Singh's grave was discovered in Kitchener, and then this year in September, when Lashman Singh and Waryam Singh's names were added to the cenotaph in Smiths Falls. This dedication to Canada, despite not being accorded basic civil rights such as the right to vote, should never be forgotten. Today, Sikh Canadians continue to contribute to every single aspect of our society, from excelling in businesses to representing Canada at the Olympics, to introducing the world to Sikh and Canadian arts and culture. One of the most visible contributions is right here in this House and other legislatures across this country. Sikh Canadians have attained some of the highest offices, political offices in Canada, and I would like to especially mention a few members of our cabinet, namely the Minister of National Defence, the Minister of Natural Resources, the Minister of Innovation, Science and Economic Development, and the Leader of the Government in the House of Commons, amongst many other colleagues of the Sikh faith who are in this chamber. I wish to personally take this opportunity to thank my good friend from Mississauga Malton, who is also the Minister of Innovation, Science and Economic Development, who in many ways opened the door for someone like myself to be here, and I suspect many of my colleagues will share in the same sentiment. In 1988, Mr. Speaker, Canada became the first nation to proclaim a Multiculturalism Act. The Act requires we continually safeguard the equality for all Canadians in all economic, social, cultural, and political aspects of their lives. Our multicultural heritage is about more than just a commitment to welcoming diverse people from around the world. It is a commitment to principles of equality, freedom, grounded in human rights and enshrined in our legislative frameworks, including the Canadian Charter of Rights and Freedoms and the Canadian Multiculturalism Act 1988. This was most evident in the case of Inspector Baljit Singh Dhillon, who I personally had the opportunity to meet last year, and his quest to serve Canadians joining the RCMP. As most members of this House would remember, it was a public debate that turned very ugly very quickly. Dhillon never set out to be a hero or even a poster child for the Charter, but in his humble way, respectfully sought the right to wear a turban in the RCMP. Much hate was propagated against him, but he resisted and simply stood his ground. At times he was alone, but he was emboldened by the support of his community and his many allies around the country. After some 18 months, the government caved in, and Baljit Singh Dhillon would become the first of many, many turban Sikhs to join the RCMP in 1991 and in many other places where uniforms are required. De certain de Dhillon, on livra une lutte discrète avec une...
There are hundreds of Dhillons who quiet confidence and with great integrity fought their battles. Some in the court of public opinion, some in Parliament, and some went right to the Supreme Court of Canada to secure their rights. They never wanted to turn the tide of history, but they simply wanted to be treated with dignity and with respect by our governments.
Component of our Canadian identity, Mr. Speaker, Canada is becoming increasingly diverse, which is also reflective of the growing presence of individuals of Sikh heritage across this country. The contributions of Sikh Canadians are vital to the social, economic, and political fabric of our nation. Finally, Mr. Speaker, I would like to thank all Sikh Canadians for contributing to this great country. Celebrating our interconnectedness and the many unique communities and cultures that thrive here gives us a chance to discover what we all share in common. This allows us to fully appreciate the value our differences. In celebrating our diversity, we learn about our common struggles and our shared values. We learn how far we've come, but also what hurdles must still be overcome. And we thank the Sikh Canadian community for opening many doors and overcoming many obstacles that have forever changed our country for the better. Thank you, Mr. Speaker. Wahi Guru Ji Ka Khalsa, Wahi Guru Ji Ka Fateh.
Resuming debate, the Honourable Member for Vancouver Kingsway.
Thank you, Mr. Speaker. It gives me a great deal of pleasure to stand in this House and speak in full support of Bill C-376, an act to designate the month of April as Sikh Heritage Month. Mr. Speaker, the New Democrats in this House have, for decades, been strong supporters of multiculturalism and strong proponents of our country celebrating the diverse backgrounds of all groups and communities that make up the Canadian mosaic. The designation of Heritage Months are one very important way that the government can recognize Canadian diversity, and in this case, the contributions made to Canada by the Sikh community or any other specific community which has been designated in similar manner. This bill itself designates the month of April as Sikh Heritage Month, and as I'll touch on in a few moments, there's a particularly important reason why April is an appropriate month for that. Now, Mr. Speaker, a couple of basic facts to situate this debate. According to the recent figures that have come before us, Canadian Sikhs account for about 1.5% of Canada's population, with a total population approaching 500,000 people. And almost half of those citizens are located in the province of British Columbia, some 250,000 people. Ontario has about 225,000, and Alberta has almost 100,000 people of the Sikh faith. And we know that Sikh communities are growing in provinces across this land, notably Manitoba, Quebec, as well as Saskatchewan and Nova Scotia. In fact, Sikhs formed the main religious group among South Asian immigrants within Canada. Now, this bill presents a great opportunity to educate Canadians concerning the Sikh community and their religion, which is based on some wonderful values. The Sikh faith is fundamentally based on the concepts of freedom, equality, and justice. And I think by sharing these values with Canadians, broadly speaking, we can develop a better understanding of and appreciation for a rich and unique heritage. Now, I want to say that this bill also follows, I think, the leadership of the leader of the New Democratic Party of Canada, that is Jagmeet Singh, who, as an Ontario member of the provincial parliament in 2013, proposed and was successful in getting passed Bill 52, which was an act to proclaim the month of April as Sikh Heritage Month in Ontario. And that bill received royal assent in that province on December 12, 2013. I believe that was the first bill of any type in Canada, and to the best of my knowledge, may be the first bill of that type to be passed anywhere in the world. Now, while we're on that subject, I think it behooves us as members of this House, and I think I speak for all parties when I say that we are all strong proponents of Canada's multicultural fabric and very proud of the diversity that is represented in our great country, to note that Jagmeet Singh is the very first leader of Sikh faith who has ever led a major federal political party. And I think that's notable. In fact, I think Mr. Singh is the first federal leader who's not of Caucasian descent. So we have, with Jagmeet Singh, the very personification of, I think, the values that this bill seeks to present before this House. And that is a celebration of the free and democratic society we have, where Canada is a place where people come from all over the globe seeking freedom, democracy, human rights, and the right to pursue their lives in the manner that they wish in a multicultural setting. And I think everybody in this House probably would join me in celebrating the step forward that the election of Jagmeet Singh as leader of a major federal party in this country represents in terms of Canada's development. Regardless of anybody's personal ideological beliefs, it has to be a positive step and a sign of inspiration to children and citizens across this country who come from a variety of backgrounds to see that they can be reflected at the highest levels of politics in this country. Now, I want to stop for a moment and just say on a personal level how important the Sikh community is to me and the people of Vancouver Kingsway. I have been blessed to meet so many wonderful people of the Sikh faith, and I want to talk about a few of them now. There was an organization in the greater Vancouver area of the Lower Mainland called PICS. That's the Progressive Intercultural Society of British Columbia, and it's a wonderful organization that was started by an amazing person named Sharan Gill, who was a courageous person who led unionization efforts, particularly among poor farm workers and migrant workers, and who spearheaded this organization. And PICS provides social support services to members of the South Asian community and even beyond, ranging from employment counseling and resume building to job selection to parenting skills to ESL classes, ranging the full gamut, assisting people who come to Canada to help learn to integrate into our communities while retaining the best of their culture. And I want to point out that people like Inderjeet Hundal and the current CEO of PICS, Satbir Chima, are people who have carried on that fantastic tradition that was begun by Sharan Gill. And these are people who are bedrock community builders. They are pioneers in the Sikh community, but more than that, they are heroes in the broader Canadian community for all that they have done to foster understanding and assistance to thousands, tens of thousands of people in our community. I want to talk about my good friend Bill Basra, who is the president of the Sri Guru Ravidas Temple, who has done so much to help members of the Sikh community. In that case, it's a temple that seeks to help people who are regarded to be the inheritors of the lowest caste, and they fight against that caste system, and they fight for freedom and equality of all people. And so not only do they help advance the interests of some of the poor and forgotten in the Sikh community, but they help remind all Canadians that we live in a country where we're all equal, where whether you're wealthy or poor, whether you're brown or white, whether you're Catholic or Protestant or Sikh or Hindu, we all are equal and deserve the same respect in the eyes of all Canadians. I want to mention my good friends Hardev Bal and Mukhtar Sandhu. These are people who have been members of the New Democratic Party for decades. And when they came to Canada, even though they struggled with language and they struggled with a lack of credential recognition and they struggled with racism, they joined in Canada's political system, and they threw themselves into the political party, and to this day they are proud members of the New Democratic Party, and they contribute, as do many Sikhs of all parties, liberal and conservative and any other party, and they help build the fabric of our democracy. On the media side, Kushpal Gill, who publishes Sach the Awaz, is someone who has contributed to journalism, and we all know in this country that part of the fabric of democracy is built on the threads of other very critical parts, including journalism. And Kushpal Gill brings in both Punjabi and English important political news to members of the Sikh community, in fact, of the South Asian community. I want to mention as well the importance of gurdwaras in our society. And for any Canadian who might be watching this, whatever your faith, if you haven't visited a Sikh gurdwara, please do so soon. These are among the warmest, most welcoming, most generous, most peaceful places of worship of any kind of place of worship that I've ever been. And I think everybody in this house that has had the fortune to be in a gurdwara knows that you're welcomed in. They serve lunch to the community without cost, and they welcome everybody in of all faiths for a moment of meditation and in a place that makes us remember those values of peace and equality that undermine the Sikh faith. I want to conclude by saying that Vaisakhi, it happens in April. That's why I think April is a particularly important month for this. And Vaisakhi is now not just a South Asian or Sikh festival, it's one that all Canadians are able to partake and enjoy. And I'm going to conclude by saying, Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh.
Resuming debate, the honourable member for Brampton South.
Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh. Mr. Speaker, I'm honored to rise today in support of Bill C-376, the Sikh Heritage Month Act, put forward by the honourable member from Surrey Newton. Sikh Heritage Month would give Canadians the opportunity to learn about the history of Sikh Canadians and the many contributions they have made in shaping Canada into the great country it is today. Sikhism began around 1500 Common Era, when Sikhism's founder Guru Nanak Dev Ji began teaching the faith. The practices were formalized by Guru Gobind Singh Ji in 1699. The 10th Guru Gobind Singh Ji formed the Khalsa Panth and introduced the 5 Ks that help form the identity of the Sikh. Women have always played an equal role in Sikhism. The first Guru Nanak Dev Ji described women's greatness when it is said in Gurumukhi, "So kyo manda akhiye chit chame rajan." And today, we recognize the same principle of gender equality in Canada. It is clear that Sikh values reflects Canadian values. Sikhism emphasizes principle of volunteership, giving back to the communities, and providing a helping hand to those in need. And that is perhaps why the impact of the Sikh community has been so pronounced in Brampton South. For example, from blood drives and organizing mass bone marrow registration events, as done by Match for Marrow, to raising funds for our hospitals and raising funds for natural disaster relief, and contribution from Sikh Canadians to Brampton have been tremendous. That is why this bill is so important. It provides us with an opportunity to recognize all those that work tirelessly to make our communities better and contribute so much to our country's social, economic, and cultural fabric. Canada is at its best when we commit ourselves to our principle of diversity, inclusion, and multiculturalism, when we can recognize one another's contributions, struggles, history, and dreams. It makes our country better. As our Prime Minister says, Canada is stronger because of our diversity, not in spite of. The Sikh Canadians community has a long and proud history since the first Sikh immigrants arrived in Canada in 1904 and established themselves in British Columbia. More than 5,000 South Asians, greater than 90% of them Sikhs, came to British Columbia before their immigration was banned in 1908. The discrimination against Sikhs was most pronounced when in 1914, the Kamagata Maru, a Japanese ship carrying hundreds of Sikhs, fleeing from India was turned away by Canadian authorities. The decision would have deadly consequences for many on board. For that, our Prime Minister apologized in 2016 on behalf of the Canadian government for this horrible act. Despite facing discrimination, Sikhs established themselves and by 1908 built their first permanent Gurdwara in British Columbia. Even though the life in Canada for the earliest Sikh Canadians was difficult, they remained proud of their country. With their dedication and commitment to their new country and with personal sacrifice, early Sikh immigrants to Canada laid the groundwork for their generations and for the future generations. During the First World War, Sikh Canadians were on the front lines with the Canadian Armed Forces. A chance discovery of the Victory Medal that belonged to Private Bukam Singh has highlighted an forgotten tale of the Sikh Canadian soldiers who fought for our country during the war. Sikh Canadian soldiers have proudly served in Canadian Armed Forces for decades. Indeed, our Minister of National Defence is a shining example. In 2011, the Minister became the first Sikh to command a Canadian Army Reserve Regiment. And in Cabinet, Minister of Natural Resources, Minister of Science and Economic Development, and our House Leader, we are all proud of them. After the Second World War, life for our Sikh Canadians began to change. By 1947, Sikhs were able to vote in federal elections. By the 1960s, immigration laws were changed and racial quotas were removed. It was during this time that Sikhs were able to establish themselves across Canada, and the foundation was laid for future generation. For Sikh Canadians, this is clear today with vibrant communities thriving throughout our country. Canada holds the second largest Sikh population in the world, home to over 500,000 proud Sikh Canadians. Today, Sikh Canadians continue to make major contribution to our countries as doctors, as engineers, artists, politicians, businesses, and every field. Indeed, Mr. Speaker, we have come a long way from 1914 when a boatload of prospective immigrants from India was prohibited from landing in Vancouver. One of our goals as parliamentarians is to uphold Canadian values of acceptance. By celebrating the vibrant heritage of Sikh Canadians, we send a clear message to acceptance that makes a tremendous difference, not only for Sikh Canadians, but for everyone in our country. It gives us a platform so that we can talk about the celebrate Sikh Canadian history, beliefs, values, and heritage. Declaring April as a Sikh Heritage Month would give all Canadians the chance to learn about the Sikh culture, religion, and practices, and help create more understanding and better connections between Sikh Canadians and their neighbors from all communities. Once again, I commend my colleague from Surrey Newton for putting forward this bill and thank him for his dedication to representing his community and celebrating the diversity of Canadians. Mr. Speaker, being a Sikh Canadian myself, I believe this is a great step forward, and I'm proud to see the tremendous support that has shown for this bill. This bill will help shape our identity as Canadians and empower our youth. When our youth are able to learn about the contribution and history of each of Canada's rich and diverse populations, we are instilling and creating strong values of understanding, compassion, and caring for one another. This is a bill that embodies the Canadian spirit and one that I'm proud to support. Sikh values reflect Canadian values, Mr. Speaker. I encourage every member to the House to support this bill as we move forward. Thank you, Mr. Speaker.
And before we go to resuming debate and the honourable member for Bow River, I will let him know that there is not quite the full 10 minutes available to him, as we need to leave some time in the hour for the right of reply. So that gives him about 7 minutes or so thereabouts for his remarks, and we'll go to him now. Resuming debate, the honourable member for Bow River.
Thank you, Mr. Speaker. Well, I'm pleased to rise today to speak on Bill C-376, an act to designate the month of April as Sikh Heritage Month. I would like to thank the member from Surrey Newton for introducing this legislation. We've taken time throughout the year to acknowledge the many great people that make up Canada's cultural mosaic. I'm happy that April will now officially be a time to reflect on and honor the many great contributions Canadian Sikhs have made to our country. Sikhs have long, proud history in Canada. The first Sikh settlers are understood to have arrived aboard the Empress of India in 1897. However, I've learned from the Sikh Heritage Museum of Canada that Sir John A. Macdonald had appealed for an army of Sikhs to defend our nation long before the Empress's arrival. He was concerned about the threat of our southern neighbor posed as our southern neighbor posed to us from the south. It is telling that he recognized the incredible bravery of Sikhs long displayed on the battlefields around the world and specifically requested their support. Indeed, Sikhs would go on to serve admirably in many other conflicts around the world, like Canadians. Punjabi Sikhs were British subjects and were called upon to defend freedom and democracy in its time of need. They stood stalwartly alongside fellow Commonwealth forces in the muddy trenches of World War I. Known as the Black Lions during the war, they won great renown in that horrible conflict. They also fought bravely against the Japanese during World War II in places like Malaysia, Burma, and Italy. Long before large numbers of Sikhs opted to become Canadians, they shared a proud and honorable history with their Commonwealth allies. I think it is one of history's great injustices that despite their shared Commonwealth heritage and brave commitment to their country, Sikhs were not always welcomed by their fellow Canadians. They helped construct the Canadian Pacific Railway, that great link that finally connected East and West. It served to unite and strengthen our young country. We owe any involved in building it a great debt of gratitude. However, Sikhs were paid less than white workers. They were not made to feel welcome by their fellow Canadians. This was the case of many Canadians that were not of European descent at the time. It was not until many years later that non-European Canadians came to be accepted as they should be. I understand that our government often issued prejudiced decrees discouraging their presence in our country. Indeed, much of the early 20th century Sikhs faced discrimination. I think we all know well the story of the Connemara, that ship that was turned away for no other reason than based on racism. I'm glad the Canadian Sikhs have now received a much-deserved apology for that shameful incident. Despite the discrimination they faced, I'm happy to say that many Sikhs chose to call Canada their home. Their vibrant culture has enriched our country immensely. This bill's preamble notes that there are now over 500,000 Canadian Sikhs. Their population is large enough that even Hockey Night in Canada is offered in Punjabi. In fact, the announcer, Mr. Singh, who is a popular commentator on Punjab Hockey Night in Canada, is from my riding. He is from Brooks, which I myself call home. That's where he grew up. His father, Doc Singh, was a teacher in the high school and one well-respected educator. Brooks is a vibrant multicultural city today with people from all over the world who work and live there. Over 100 different countries are represented in that community. It has changed a lot since Doc Singh came to the city of Brooks. So, indeed, I know Sikhs have settled largely in urban areas, but my own rural riding of Bow River is also home to many Sikh descendants. They contribute greatly to Canada's prosperity and economic success. I know that they are now well represented in countless industries operating across the country, and I know their dynamic communities are achieving great success. Without a doubt, Sikhs, both past and present, have made incredible contributions to Canada. I'm happy that institutions like Sikh Heritage Museum of Canada in Mississauga are doing such a great job of highlighting Sikh history. According to their website, their mandate is to create a dynamic, learning-focused, permanent Sikh museum and educational facility. The Sikh Museum will celebrate the Canadian Sikh experience and its vibrant history, explore the richness and complexities of the Sikh spirituality and identity, and commemorate and honor Sikh history. I think those are fantastic objectives, but I think it is about time that a month is officially designated to celebrate their contributions. This will help further highlight their contributions. In closing, I would like to thank the member for Surrey Newton once again for introducing this legislation. I think it's going to be a very positive thing going forward. I'm happy to say I'll be supporting it wholeheartedly. Thank you, Mr. Speaker.
Resuming debate. Reprise de débat. Accordingly, I invite the honourable member for Surrey Newton for his right of reply. The honourable member has up to 5 minutes. The honourable member for Surrey Newton.
Thank you, Mr. Speaker. I am proud to rise today to speak on my Bill C-376, an act to designate the month of April as Sikh Heritage Month. I would like to thank the Parliamentary Secretary, opposition critics, all the members those spoke, and all members from all sides for their support for this bill. I would also like to give a special thank you to my esteemed colleague and hard-working member from St. John East for giving me his private member spot and allowing me the opportunity to have the second hour of this bill debated today. As other members have mentioned, the journey of Sikhs in Canada has not only taken this community to great heights, but at the same time, it has helped Canada transform into a proudly diverse and welcoming nation. Mr. Speaker, there are over 500,000 Sikhs in Canada, which is the largest population of Sikhs outside of India. Sikhs are now equal members of the society, working in every sector of our economy, and above all, very proud Canadians. Along the journey, there were many contributions by Sikh Canadians, ones who had fought for equality in our democracy, respect in our workplaces, and freedom in our society. With the passing of this bill, we can ensure that all Canadians will learn about these contributions, better understand the history of our country, and celebrate the culture and the religion of those from Sikh faith. Better understanding and celebrating religion is important because it strengthens our diversity. To quote the Right Honourable Prime Minister and member from Papineau, quote, Canadians understand that diversity is our strength. We know that Canada has succeeded culturally, politically, economically because of our diversity, not in spite of it, unquote. Mr. Speaker, there is a strong connection between Canadian values and Sikh values, as both put a priority on respect for others, selfless service, and equality. These values are the foundation of Sikh faith and our Canadian culture. I want to take a moment and share with everyone a little about the Sikh faith. Fundamental beliefs of Sikhism include faith and meditation on the name of one Creator, the divine unity and equality of all humankind, engaging in selfless service and serving for justice for the benefit and prosperity of all. Sikhism is based on the spiritual teachings of Guru Nanak Dev Ji, the first Guru and the founder of Sikh religion, and the 6 Gurus that succeeded him. The 10th Guru, Guru Gobind Singh Ji, named the Sikh scripture as Sri Guru Granth Sahib Ji as his successor, terminating the line of human gurus and making the scripture the eternal religious spiritual guide for Sikhs. Sikhs have 3 core duties. In Punjabi we say, Naam Japna, Kirt Karna, and Vansh Shakna. First, Naam Japna refers to the remembrance of God by repeating and focusing the mind on His name. Secondly, Kirt Karna means to live and earn honesty. Lastly, Vansh Shakna is the core of the faith, means to care about your surrounding community and share your blessings with those around you. Mr. Speaker, this provides insight into how our cultures are so deeply connected. The values we share need to be better understood, and our history together need to be remembered and celebrated. That is why I ask each and every member of this House to support this bill so that we can continue to better understand more about one another and in the process strengthen our ties to this great nation. Again, Mr. Speaker, I would like to thank each and every member on both sides of the House for supporting this bill. Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh, and thank you, Mr. Speaker.
The question is as follows. Mr. Dhaliwal, seconded by Ms. Sahota, moved that Bill C-376, an act to designate the month of April as Sikh Heritage Month, be now read a second time and referred to Standing Committee on Canadian Heritage. Is it the pleasure of the House to adopt the motion? Yes. Carried. Accordingly, the bill stands deferred to the Standing Committee on Canadian Heritage. Order. In accordance with the Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The Honourable Member for Bow River.
Thank you, Mr. Speaker. I'm delighted to stand up and follow up on a question that I asked in the House this spring as relation to carbon tax and the environment. One of the things that is extensively agriculture in my area, the carbon tax, is really a really tough piece for the ag sector. I mean, farmers are at the bottom of the supply chain. That means whatever price they can get is it. They can't raise it. Then they're subject to all of the cost increase above them. So input costs, when you're talking about seeds, equipment, particularly fertilizer, the fuel, and this year it's going to be grain drying that's going to be happening because the crops are going to be harvested much later. So all of those input costs with a hidden tax, which is a regressive tax, a hidden tax on everything, is going to be very difficult in the ag sector. Now, we will hear that the federal government say, well, the provincial government could do something to subsidize that or put exemptions. But this is a federal tax, the federal tax. And whether exemptions are in one place or another, it varies. It is a tax, though, on the agricultural sector. They're asking the agricultural sector to increase their productivity from 55 billion to 70 billion export. But yet they're handicapping them with this tax. Their competitors do not have this tax that they have to compete with on the international market. So with the hidden tax that's on everything and then the outfront tax on ag guys, they're paying it twice. So this makes it very difficult. It doesn't take into account all of the mitigation effects that have happened in the farming industry. Farming industry has become a very precise industry, very technical. They've had many advances in the sense of how they work with the planting, the fertilizer, the zero-till, the carbon sink that it does create. There is no credit for that. It's very regressive in the sense of cost and no recognition for how they're creating carbon sinks in this industry. So, Mr. Speaker, when we have the federal government saying they could be returning it, they could return money, but they never respond about the GST, the possibly hundreds and hundreds of millions out of Alberta and BC alone that's going to come to the federal government. So is that coming back? They talk about possibly returning if they implement it, but they don't talk about the GST. So it's interesting that they will exempt for some industries, some large, like the large cement industry that's being built in Quebec. It's getting exemption from this particular piece of legislation of carbon tax. The LNG that's being announced is going to get an exemption. But where's the farmers in this? The ag industry, they're paying it not once but twice. So this is a very regressive piece, very tough on the ag sector, which is a huge industry. And when the minister says he hasn't met a farmer that doesn't support it, I haven't met a farmer who does support it, and there are thousands in my riding. Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary to the Minister of the Environment.
Thank you very much, Mr. Speaker. It's my pleasure to rise in response to the question both on the notice paper and delivered orally tonight. Before I begin, I'd like to thank my colleague and friend from Bow River. Mr. Speaker, despite our friendship, I've got to say I couldn't disagree more strongly than with his position on this particular file. The Conservative Party has had 10 years in government and now a total of 13 years to come up with a plan to actually deal with pollution, and they still don't have one and refuse to come forward with a solid plan to protect our environment. Canadians, quite frankly, know, Mr. Speaker, that protecting our environment is a priority. Even though I think most would acknowledge that that's the case, my colleague across the way, who belongs to one of the biggest political parties in the country's history, doesn't have a plan to actually take climate change seriously. The party he represents, in my opinion, is out of touch and being extremely short-sighted. In fact, the question here tonight is not asking what can the government do to help our environment, to protect our environment. It asks about the cost of doing something. Well, to answer the question as succinctly as I can, there's going to be a net benefit to Canadians with the plan to put a price on pollution, not a detriment. My colleague doesn't even need to take my word for it. He can ask Stephen Harper's former Director of Policy, who indicated that the government's plan to put a price on pollution is going to result in middle-class families being better off. They will have more money in their pockets as a result. Our plan to put a price on pollution is going to protect the environment and help grow the economy and put more money in the pockets of Canadians. Mr. Speaker, we're taking action on the environment and the economy and doing so in ways that's going to benefit both. Putting a price on pollution is widely recognized as the most efficient way to reduce emissions and to create a sustainable clean growth economy. Pollution, quite frankly, already has a cost. The cost of inaction is greater than the cost of addressing the problem. We're already suffering from effects like smog that have not only an environmental impact but a health impact. We're experiencing floods and wildfires in different parts of the country, like the very fires raging over the province that the member represents. Putting a price on pollution lets everyone see the cost of pollution so we can do something about it. Unlike the Conservatives, whose plan seems to be nothing further than to make pollution free, we're making life more expensive for polluters and more affordable for Canadians. If my colleague is sincerely worried about the cost of a price on pollution to Canadians, I'll reassure him by telling him that the cost of inaction, as I said, is actually greater than the cost of taking the problem seriously. I wonder if he understands that the cost of inaction on climate is actually going to exceed $5 billion by 2020, because that's what the cost of not taking this threat seriously is. In fact, we know that by 2020, our historical failure to take threats to the environment seriously are going to exceed this incredible figure of $5 billion. Mr. Speaker, I like to work off evidence-based decision-making, not decision-based evidence-making. And the evidence is clear. We've seen the Governor of the Bank of England, a Canadian, Mark Carney, indicate that the economic opportunity is $23 trillion. Mr. Speaker, our government is protecting the environment, taking the challenges posed by climate change seriously, and trying to capitalize on the opportunity to make Canadians better off and protect the environment, not only for ourselves, but for our kids. Thank you.
The Honourable Member for Bow River.
I was delighted to see my colleague here tonight in the House and being able to discuss this topic with him. It's somebody I do respect and believe he's a fine representative for his area and speaks well in this House. You know, from my point of view, in a sense, there's a carrot-stick approach. And in Alberta, you would find with the oil sands over 50 years with innovation, that was incredible things done between the 60s and now with innovation. And it was done with a positive, not with a negative. And I believe the ag sector has done incredible positive things for the environment and really believe in the environment, because without the farmland, there is no business, and they really believe in environment and working with it. But with a positive approach, not a negative one. And this piece is really negative on the farm ag industry. It's a double taxation. It makes it very hard for them to increase. When they are doing more innovation, they are doing it for the environment. So this is tough, this is hard, this is why the carbon tax is very regressive. Thank you.
The Honourable Parliamentary Secretary.
Mr. Speaker, in response to the rebuttal, I'd like to point out that there are components that actually encourage people to make investments to help protect our environment in the clean tech sector, in public transit, in conservation measures. But we are going to put a price on pollution because the really negative aspect of not doing so, to me, is that we're making pollution free for those who actually damage our atmosphere, and we download that cost onto everyday Canadians. Mr. Speaker, there was an election a few years ago in 2015. We committed to grow our economy and protect the environment at the same time, and we were transparent during that campaign to indicate that our plan would involve putting a price on pollution. Mr. Speaker, we have a duty to protect our environment and to grow our economy, and just because the Conservatives couldn't do either doesn't mean we're not going to do both. Thank you.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, the House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24-1.